Good morning, everyone. Morning. Good morning. I guess they started the feed live early this morning. So Bruiser was fussing at me and he said, Mama, you got to start and go live. He didn't say that. I'm just kidding. I can't believe it's taking a week to seat 6-person jury. Thank you. I mean, my Lord, have mercy. Now, he wants 8 alternates, though. He did say that early on. I don't know why he wants 8 alternates. I guess in case of COVID, he's probably been through. By the way, you guys, uh, my mic, if it sounds too low, please let me know. I did adjust the volume down this morning. A couple of things that I adjusted. I did that. Plus, I adjusted the ad settings. I had somebody tell me the other day that they came in and within 5 minutes, they had 6 ads. That sounds a little excessive, but if that is occurring for you guys, please let me know because I do have my ads turned on. Otherwise, I'm working and not making any money. Or I put it on a different level. It was on balance. There shouldn't have been that many ads. So I've actually changed it today to be a little bit different. And I'm curious to see how it affects everybody. If it gets crazy ads, please let me know. I've got premium, so I don't know how many ads you're getting. I do recommend YouTube Premium, though, if you don't have it. If you watch YouTube all the time, you might as well go ahead and get it. It's so worth it. So anyway, back to this jury thing. I get it. I get why he wants more people because we've already got one person out saying they got COVID. So then you know how that works. You get one string started and they keep going and keep going. Somebody else will come back and say it. I tested positive. I wonder if they have to show they tested positive. I mean, sometimes people just want to get out of jury duty, right? You never know. So there could be that. Am I having Pop-Tarts and juice? No, I'm having a big, huge cup of coffee. Coffee with lots of cream, no sugar. I've got all the sugar I need, honey. I don't need sugar in my coffee. Long Crime is already live at 8:45. I know, I don't know why. I have no idea why they went live so early. Did you guys see, if y'all weren't here last night or yesterday, after they got done with the hearing, we stayed on and we were watching that portion of Sam and I's video on the different BSS cases and whatnot that we were comparing because we were looking at the case laws. And Trial TV Live was able to get a live feed in the courtroom. They got permission. So we ended up watching, I think most of you guys were here, but we ended up watching the part of the jury selection yesterday. It's on my live stream from yesterday, and I did finally go in and timestamp it. So if you want to go check it out, hopefully the same thing will happen again today. I don't know. We'll see. It might be a little different today. I think yesterday afternoon, we ended up where the state had finished, I think, most of their questioning the jury, potential jury. And I want to say they might have a little bit more left. Or if they don't, they're going straight into the defense questioning the jury in the morning. It was interesting to hear it and to hear the different ways that they're approaching things. Of course, they're asking about, anybody have ever been involved with domestic violence, you or anybody you know. Then they get into the whole, he went into, what was the questions he asked? He even asked about people that had anxiety and if they took medication for it. It's either you or somebody you know. Then he asked about, couples getting, one of the things he said was, do you know any couples, or have you ever been in a restaurant and then like a couple you don't know, they just start arguing? It's kind of uncomfortable, right? What did you do in the situation? That kind of thing. It was weird. It was just kind of different weird. So we're going to go, let's just recap. Again, still on my first cup of coffee. Let's recap what happened yesterday. So as far as the battered spouse syndrome thing, hearing, motion, judge kind of left the door open there. He said, okay, look, you can't use it in your opening statements, but you can mention it. He said, you can mention it in your opening statements, battered spouse syndrome. But until you prove that you have a case for battered spouse syndrome, you cannot use it once we begin trial, which I was like, okay, how does that work? So I guess they would have to bring Sarah on the stand because they're saying it was lacking. That Dr. Harper's diagnosis of Sarah is lacking. And he said her opinion to allow, he said, what is her opinion in order for us to allow her to testify? And the judge says there's no overt act here. And an overt act, guys, is something as an act that can be clearly proved by evidence from which a criminal intent can be inferred. So, like, he made the example of if you had a biting dog. What was the other example that they gave? It was a great analogy. They said there was no overt act by George. So, in other words, him sticking his fingers out of the suitcase, the defense wants us to believe that him sticking his fingers out of the suitcase, excuse me, is the overt act. But then she beat the hell out of his fingers with a baseball bat. The defense said his hands coming out of the suitcase, and she was afraid for her life at that point because if he got out, then he was going to hurt her. I don't know. I think self-defense is absent on everything, based on everything up until the trial start, until we, I mean, if there's just no, they're trying to prove self-defense. And the state said, nope, everything shows that she is clearly the initial aggressor of everything, aggressor. And the state brought up that George only weighed 103 pounds, which I was so glad they did that because I feel like they're zoning in to where we're zoning in on this, guys. I mean, it's not like we thought they weren't working on this, right? But it's good to know that we're all on the same page here. And her claiming something about, I think it was Jay said something about the night before she was claiming that he drug her up the stairs by her hair. The other thing that occurred yesterday, my notes suck. Wow. I was just a scribbling. The medical records for George. Okay. So let me catch everybody up if you have not been here. Apparently, like 2 days ago, the defense dumped on the state 550 pages or plus of medical records on George Torrez Jr. And the state came back and said, you can't do this. You can't just dump all this on us. What does this have to do with the case? Like you can say that here's the medical records. We want to insert this page, this line, whatever. But you can't just throw us 550 pages and say, this is it. The defense is trying to say, well, he had all of these things were happening. They're trying to paint George as I think, an angry, violent person because at one point he had gotten into a fight with his brother, and another point, well, his brother beat his ass. His brother beat him up. But another point, he had put his fist through a window and broke the glass, and so he cut his arm or cut his hand, and he had to get stitches. And There's like 487 pages where he had to have, I think, jaw reconstruction or something from his brother beating him up. And they want all that to be included. And so the state is saying, look, we don't care if you want to bring in that he got into a fight with his brother. That's fine. But we don't need to see everything, all the details about his surgery and the follow-up visits from his surgery. Like, what's the point in bringing that in? And so we believe what's happening is the state, it's just the defense's way to try to like pull the wool over the jury's eyes with a bunch of junk, throw a bunch of stuff at them, and maybe they won't notice the elephant in the room. I don't know. So the judge said that the narrative can come in, the narrative of the idea of his what was going on with his medical records. But those 487 pages about him being all the surgery and procedures afterwards, after he got beat up, he's going to leave that open. It cannot be brought in right now because until the defense comes back and says, show me the specific pages that you want to insert within the trial, the judge says no. Literally yesterday, you guys, it was as if Owens and mostly Henderson. Henderson is Owens' co-counsel. And it was mostly like he came in and was like, oh, hey, yeah, I haven't read the transcripts, but I want to insert the transcripts. Well, I didn't read them. I just heard about them. I didn't watch the videos. I didn't read the depositions from these witnesses, but we would like to insert these witnesses. And the judge is just saying, he's looking at him like, what, excuse me? And they're like, well, we just got on this case like 45 days ago. And they're going to keep using that excuse throughout the entire trial, you guys. They're going to keep doing it. We know this, right? How is my audio, everyone? Can you let me know in the chat? Is it too low? I know I'm usually too much. Hey, Noni signed up for a new membership. Thank you, honey. Case one I found out last night. She used to be a paralegal. Oh my word. Show me proof, case one. Show me proof and we'll talk about it. I don't know about that. See, that's the first I've ever heard that. That's how rumors get started, y'all. Case one, give me some receipts, mama. I'm not saying you're lying on purpose. I'm just saying, give me some receipts. Henderson is completely clueless. I swear he was like, oh, you need me to show up to court on Tuesday or Wednesday? Okay, I'll be there. Oh, are we actually going to trial? Oh, okay. Well, let me get my book out. I'll read the stuff you sent me on the way over. That's what it seems like. Henderson is truly treating it like I'm not getting paid for this, so I'm just kind of here. And Owens is like, dude. I wasn't impressed with Henderson. I was surprised. I thought he was going to come in and be a lot like Owens and try to woo everybody with his charisma and all that. And I didn't see any of that. At least Owens puts on a little bit of a show that way. He's got a lot of charisma, but he still talks out the side of his mouth. Aw, thank you, Noni. That's so kind of you. Noni found the super chat button, you guys, and the member button. Look at her go. You're like me. Thank you. Thank you very much for your super chat and your membership. Okay. Thank you, Laura. It's perfect. Okay. So I don't know. Have I usually been really loud? Am I usually too loud, guys? I know that I'm loud, like without a microphone. I've always been that way because I took drama and speech and all that. And I've always been one that's like, I project my voice. I can't help it. Not too loud. Okay. Thank you so much. Who has all the power and control in that home? Well, whose home are we talking about? Are y'all talking about a different subject in the chat again? Giannis said, I did not expect Henderson to be good. He was awful the first time we saw him. Well, yeah, but I was like, well, he was on Zoom though. I was gonna like, okay, he's getting a kickstart or whatever. I expected him to be a little bit better yesterday, but mm-mm. So now we're gonna. I guess Henderson is gonna be doing the jury selection questioning this afternoon. How about the selected juror who just didn't come in? I know. Well, there was one guy that they said, I gotta get y'all a parachute emoji. I promise you I will. There was one guy that said, well, I guess I misunderstood because I called the number or I misunderstood when I was supposed to come in. And because it was already so late in the day that they gave him a pass. I bet they're going to put him back on the list though to come back. I guarantee you he's going to get called next week. Dorothy, good morning from New York State. It's 34 degrees here, freezing like Boone's heart. I am in Alabama and it's 46 degrees here. And that was surprising. I actually turned my little heater on last night for my cat because I didn't want her to get too cold. I feel like we didn't get any fall weather. It just went straight to cold weather because to me, that's really cold. Thank you for coming in from New York State. Since you're from New York, are you a Yankee fan or a Mets fan? I need to know these things. I'm a Yankee fan. Except I haven't watched baseball in a while. I think probably after I stopped watching baseball several years ago, but I used to watch it like crazy. Okay, so anyway, the jury stuff. I was making some notes and I'm like, why am I making notes? Because we got it right here on tape. Oh, here are my notes. Right. He said, have you ever experienced a couple have a public fight or an argument? That was one of the things that Prosecutor Jay said. And he said, what about like, he started making baseball player references and batting average references. And it was funny because one of the guys that apparently knows somebody that is in the pros said, well, I can get up and hit the ball. And he kind of went a little bit too detailed with the whole thing. And Jay was like, okay, whoa. Then they had an opinion based on the news society. That's right. Oh God. They got into politics a little bit. What news channel do you watch? And he made a good point. I don't understand why he said this, but he goes, okay, so look, if you lean one way politically, are you more than likely going to watch the news that's kind of more towards that, or do you go watch other feeds of news to learn different things about it? I.e. Fox or News Nation or whatever versus CNN or something like that. And that was kind of different. It was interesting to see what people said about that. One lady got up and she was telling her, she's like, I don't trust anybody. I think they're all a bunch of she didn't say they. She said, I think they're all a bunch of crooks and they can all be bought and da da da. It was like, what? Yeah, we don't talk politics usually on this channel because I think politics divides people. But yeah, I was hoping, I'm like, please tell me this is not going to get too political yesterday when we were watching it because I was just watching the chat. I started zooming in on the chat. I'm like, where are we going with this? Because I knew y'all were going to start chiming in. I'm like, I don't want to know your political views. I'm not going to tell you mine. I don't want to know yours. Looking at my other notes here. There was mention that the evidence that was being filed. Prosecutor Jay said something yesterday about Owens is not filing the information or the evidence through the clerk of courts. And I guess it's not getting filed properly. He's not going through the proper chain of command. Because, and I think that's probably Owens playing dumb or taking shortcuts. And the state's like, you can't do that. You can't do that here. We don't play that game in this county. They started talking about the cell phone evidence yesterday, which was super interesting. That was probably the most interesting thing that happened all day. And the defense tried to say that, well, we don't know. There's a bunch of photos here. But, we don't know where these photos came, like what the dates were on them and how to, are they, should I bring them into trial? Should I not bring them into trial? And when he said that, the first thing that came to my mind was, dude, you have a whole report. The state, I know, pulled a whole report on the cell phone, right? And as soon as he got done saying that, Prosecutor Jay walked around. He was so ready for it. He walked around. He put all the paper in front of everybody, including the DVD and everything. He goes, okay, what I have here is the narrowed down phone extractions. I've color coded it. I've alphabetized it. I've got diagrams. I've got a full PowerPoint. That's not exactly how he said it, but that's kind of how it came off, like he had documented every single photo, and they were time stamped, and he had different divisions of the pieces of the different things off of her phone. There's apparently a conversation with George's family that I'm really, really interested in hearing. Hang on just a second. Sorry, I needed some water. I think it's Mo. I think it was Mo that she was talking to. But somewhere in there it says, I'll get rid of him. I heard that. I'm not really sure how that fits into everything. But it sounded in what he was saying, it sounded as if everything on that phone is showing contradictions. I need to piece that out. I should have done that last night, and I did piece out. So I went in and I time stamped everything that we had yesterday. So if you want to go back and watch it, at least I've time stamped it down somewhat because it was an 8-hour live stream. And then last night, I broke out the hearing, and then I guess I don't want to pull it up and then us miss this. So hang on. If somebody wants to, I'm sorry, I'm sniffling. Somebody yell at me if Law and Crime comes back on. I'm going to see if I can find the portion of the hearing that talks about what they filmed on the phone. That was the one time yesterday that I got up to go to the bathroom. They started talking about the phone. And I'm like, are you kidding me? I've been sitting there all day long and I missed that part. Not always the way it is. Who was it that got the Grammy or Oscar? Was it Renee Zellweger that got the Oscar? And she was in the bathroom. They're like, she's in the bathroom. Let's see if we can go to the part. Oh, shit. Okay, sorry. She's back. All right. I'm back. We're staying on this. Sorry. I was going to let us watch the hearing from yesterday. So, again, third day in a row, she's got the suit on. Different shirt. Now she's in yellow. Remember, yellow was one of the colors they said not to wear on our color psychology. They just went and got her a bunch of shirts from Walmart. They got her a suit from Goodwill and a bunch of shirts from Walmart. We're going to have to watch her sit there in that damn gray suit this whole trial. Or is that a brown suit? Or is that the same gray one? Maybe it's brown. Maybe it's a different one. Yeah, everybody said gray. I said, I think it looks brown. From yesterday, anyway. Which, by the way, if you buy your shirts at Walmart, I'm not judging because I just got one from Walmart the other day. I bought a T-shirt that says, "We can't fix stupid, but we can give it a court date." I'm gonna have a T-shirt made up like that for our channel. It's an odd green. Is that what it is? It's not a full brown. If you know how to shop at Goodwill, you can get some good stuff at Goodwill. You got to know how to do it though. I used to go over there like once a month when I worked in insurance during my lunch hour just to browse and see what they got in. But you do have to work, you have to go to a good one, a big one, and you got to weed through a bunch of stuff to get to the good stuff. So if you don't have time to do that, because vintage is not always a bad thing. Her blazer is cut from the same cloth as Owen's jacket. Que sera, sera. Que sera, sera. Put state at disadvantage, not based on law. I was ready to shut off. What does that mean? Well, everything they came in with yesterday was not based on law. They're still, it's that same strategy where it's like, Judge, I'm going to reserve this to talk about this later. And instead of just saying that up front, they try to argue everything and waste the court, like in 30 minutes of court time. And then they go, well, I was just bringing it up because I want to be able to talk about it later. Well, why don't you just say that? Why don't you just say that? You think she's definitely wearing eyeliner. Well, these are important things we need to know. Judge is in the room, apparently. Nobody else is going to stand up?
William J. for the state.
Oh. Audio sucks.
Ma'am, good morning. Can you state your full name and date of birth for the record for me? Ms. Boone is seated at counsel's table wearing a dark gray suit and a yellow blouse. She is in custody. However, she is not being shackled for the purposes of the trial based on the court's prior findings. We're here to conclude the objections as identified in the state's response to defendant's fifth amended reciprocal discovery exhibit list. The court has reviewed the objections and the defendant's fifth amended reciprocal discovery exhibit list. Anything else we need to address, state, before we begin addressing those objections?
Judge, I do not see a written order from yesterday's rulings on the court's website. I want to make sure I am crystal clear as to what the court has said is going to occur during the trial regarding opening statements by either party and so on and so forth, so that I am not in violation of any motions in limine or any case law that presides over what I can say or not say.
Okay. Madam Clerk. Were you anticipating a written order on the motions in limine?
I felt like I heard you say everything that I anticipated was going to be put at least on court minutes by the clerk's office. I wasn't anticipating to type a written.
Okay, that's what I wanted clarification on. Thank you.
But I just do want crystal clear clarification as to what we are both doing. Because based on that, I have some things that I would like to get on the record for post-conviction matters.
Sure. All right. Madam Clerk is pulling up the file now, sir. Give us a moment.
Thank you for your super chat, fan lady.
You did not.
You're cracking me up, girl. Tequila Rose, thank you for your super sticker.
Madam Clerk is advised that court minutes were not prepared for the ruling from yesterday due to it taking place during the trial and jury selection. So digital was not providing recording services yesterday. So it would have been Madam Court Reporter. So I would have to beg and plead if she's able to get me a copy of what it was so that it can be re-reviewed so that we're all on the same page for that. Madam Court Reporter, how long do you think that would take you? Is that acceptable? Can we address it at 1:30 before we
Makes it very difficult to prepare for opening statement. I don't know what I can say.
No, I agree with you, and I'm not trying to, submarine anybody or put anybody in an inappropriate box,
I
but
understand, but I need to know what I'm going to be allowed to say.
I don't disagree. But is 1:30 acceptable?
No.
Okay, well then, short of taking a break right now and having her create it, I
Wow.
don't know what else to tell you. State?
We have an out-of-state witness and people that are scheduled to come in. So we do see problems with that.
Okay. I don't know how long jury selection is going to take this morning. I can't recall off the top of my head how much time the state said, or the defense said they were going to need for the purposes of their questioning. So, Mr. Henderson, how much time do you think you're going to need, sir?
Hour and a half.
Okay.
And then we've got pause and territorial.
Correct.
I believe we each have 10 strikes.
That's correct.
10 strikes.
That's going to take.
Mr. J?
I just need that ruling so that with enough time to prepare.
I understand. So the way I see it is we've got a couple of options. We can, and there's no good way to cut this up. One, we can wait on the objections, which I know you do not want to do. Or we can stop now. Madam Court Reporter can provide a rough draft of what was ordered yesterday. And we could go over it and review it, make sure that we're all on the same page as to what the court's ruling really was yesterday as to the various motions in limine. Then we can continue with jury selection, or then we can pick up with the objections. I'm amenable to however it is you want to proceed. I understand your concerns of running afoul with a motion in limine. I totally understand that. But it will take her some time to prepare this.
I'm fine with either letting her do that now or letting her do that after we argue this hopefully last pending motion in limine, but prior to getting into jury selection so that I have time to rework what my opening statement will be based on the ruling during Mr. Henderson's voir dire.
Let me then ask this question. Assuming we get a jury this afternoon, what are the concerns with starting tomorrow morning with openings? Is it due to out-of-state witnesses that may be unavailable or because of their schedules?
I feel like if we have time, we should at least get into preliminary instructions and opening statements and use every waking moment we have to not waste these jurors' times until 5 o'clock today.
Okay. All right. Madam Court Reporter, how long do you think it would take you? Is that acceptable as opposed to in print? She could go back and pull back the audio from and re-review it and just provide it to us now? Sure. Okay. All right. Then we'll take a short recess. Just let us know when you're prepared to give us that ruling and then we'll go from there. Anything else we need to discuss before we take this brief recess?
No, Your Honor, thank you.
State or Mr. Owens? How long do you think? 10, 15, 20? Okay, great. All right, we'll
15
be in
minutes.
recess till 9:45. Thank you. Yes, sir. Yes, sir. Yes. You're talking about the motion in limine regarding anticipation of affirmatively pled intent to use battered spouse syndrome evidence? Fine. Okay, well, that saves me some time then, so I appreciate that.
Yes, they
All
do
right,
need a
so
mic.
do you have any objection then, Mr. Henderson, to the granting of the state's motion in limine, which would allow the state to be able to outline in opening statements and present evidence in the state's case in chief in anticipation of the use of the battered spouse syndrome defense at trial? All right, motion's granted. All right, we'll be in a brief recess till 9:45. We're off the record. Thank you.
Okay, hang on. I'm fixing to sneeze. I don't want to sneeze into the microphone. Okay, wait. I think it went away. Okay, so if you guys don't know what's going on, or if you're confused, let me explain why the state is so adamant about this, and I'm going to try to break it down as much as I can understand it. So on the rulings that the judge gave yesterday, he kind of left too open-ended in a way. On the battered spouse defense, he denied it in part. And he said that you can mention the battered spouse syndrome in your openings, but you cannot put on a battered spouse syndrome case. I don't know if that's the piece that Jay is upset about. The other thing that he ruled on was the thing about the narrative with the medical records. And he said you can bring in the narrative about about the 550 pages of his medical records. You can bring in the narrative of him being in a fight and the hand going through the window and getting cut, but you cannot bring in the 487 pages that are details of his surgery and the follow-up procedures and all that stuff. Well, thank you, Miss Janice. Janice said, sorry, I can't. What? Oh, okay. I understand. Oh, you do good things. Wildlife rehab facility. Oh, hon, that is so awesome. I love that. Well, thank you for your time that you do for your community. That's so special. I love that. Thank you, Janice. I'll try to keep you up to date, my friend. I'll try to break today's stuff down as much as I can before then. Yesterday we were on for 8 hours, you guys, or 8.5 hours, and I was so tired when we got done. And I had to go take a nap. And I got back up last night, and at least I trimmed down the hearing out, but I really wanted to trim some more out. We don't have time to watch the pieces that I want to watch because it's going to take too long. So that's why I'm reading this off to you guys. It said on some of the medical records, it says at Christmas of 2017, it said that George was jumped and beat up. We know this was Mo that did it. And we know that it had to do with Sarah telling the family that George hits her. And I thought to myself, my goodness gracious, please tell me they're not sitting around at a Christmas function and she's drinking and she brings this up and a fight ensues because of that. But I guarantee you that's probably what happened. Anyway, the state said that's irrelevant because it has nothing to do with Sarah and George's relationship, in a sense. And the state's claiming that they're just trying to bog the jury down with a bunch of paperwork. In regards to the other motions that were discussed, okay, remember how they wanted to redact a bunch of the interrogations? Well, there was one piece where he said pages 53, 55, 56, and 92. He said, no problem. You can take that. We'll take those out of the interrogation. The state didn't fight that. I think the state didn't feel like that was that big of an idea, big of a big deal. So anyway, let me tell y'all yesterday. So what happened yesterday was after that thing I told y'all, we got to see jury selections. So Trial TV Live has a press pass, and they were able to get over into the jury selection room. That they went up to the 23rd floor. And they were able to give us a feed yesterday of the jury selection. Of course, the feed was basically on the judge, and then it was on Sarah most of the time. But you could hear what was going on in the background, which is all we really wanted to do, and all we knew that was going to be the way that it was, right? So let me take this down. Sorry. Jules and Chris from Trial TV Live did a live last night, and they were talking about their experience yesterday, and they said that Owens was a little snarky with Sarah. that he seemed like he was in a bad mood yesterday. And Sarah was telling him to do stuff. She was writing stuff down, and then he would take her paper and shove it back in front of her and point to the judge and say, "Listen." She said it was funny. But she did say that she was in the elevator at one point with the prosecution, and the prosecution knew who they were because she said, "What time are we supposed to be back?" And they, or, and something about the time was mentioned, right? So she overheard them talking amongst themselves. And oh, Chelsea Copsall was in the elevator with them because, she was in the morning hearings yesterday. And Owens got all flustered over that. He did not like the fact that Copsall was in there. And she's the main detective, the Cough-a-Lot detective in the interrogation. They didn't need her. They just said she's here to watch. I mean, they can have her there at trial. I don't know why Owens made such a big deal out of it. So apparently, Jules overheard them talking yesterday, and they said it out in the open that they didn't like the BSS ruling. And Copsall says, "Well, I need to know what's going on. So if I'm called and I'm being questioned, I need to know what I'm allowed to testify about." And so I think this is the part, it all has to do with this battered spouse motion being split up. I think that's where they want them to be more specific. They want it on the record. So I guess that's why the state is doing what they're doing. I want to show y'all something really quick. How about you? This is the juror box sheet that Sam showed us. I had to blur it out so that because it's a real one from a real trial, but it just shows you how this is kind of like what both the prosecution and the defense have, and you can see where they've clearly marked out the jurors and stuff. So that when they get down to the point where they're at now, they make their notes on there, on each box, on each juror, and then they just kind of check them off as they go. Last night they were dropping like flies in the afternoon session because you could hear when they would come back with their answers. We're like, "Oh, that person's going to get taken out. That person's going to get taken out." Cookie said, "Y'all think they're going to claim 2 fingers sticking out of the suitcase is an overt act?" That's what they said yesterday, Cookie. Henderson said this. It was clear that his fingers sticking out of the suitcase were proof that he could get out of the suitcase. And she knew that once he was going to get out of the suitcase, that he was going to come after her. That's how he put it. So, yeah. I know. I know. I agree with you. I'm with you. But thank you so much, Just Another Smith. All hard work on this case, deep diving for all the details. Thank you. Thank you so much. And thank you for noticing. I appreciate that. I try, y'all. I try. Oh, I missed it from Emily. I'll get back to you, Emily. Hang on. Yeah, I'm doing my best to keep up. And you know what's crazy? I don't know about y'all, but so this is the first case that I've really paid attention to the docket from the beginning, from start to finish. Usually I go into a case and it's like, okay, let's watch the trial. That's just me. Like, I know the details of the case for the most part from watching court TV, other documentaries, but I haven't really gone in and read what's on the docket. I haven't gotten into the legal side of it, right? This is the first time I've actually listened to what's going on. We've had Sam on, and she was giving us a lot of great items and tidbits that we were able to learn, not just from her side of being on the investigation side of the defense, but also her legal knowledge because she does have a legal degree. So it's like, or law degree. So it's really interesting this time around for me and just learning all the more about how trials work. Like, I didn't know anything about the JAC before going into this trial or going into this case. Now I totally get it. I totally understand pretty much not everything there is to know about the JAC, but I know a lot more than I did before. I never even knew it existed before. If you asked me a couple of questions, I could probably answer them at this point. You know what I mean? So that's interesting. Thank you again, Just Another Smith, for your super chat. And I love your name. That's so cute. And Emily, Miss Emily, thank you and happy Friday Eve to you too. And yes, hashtag justice for George. So let me look at y'all's chats and see what you guys got. It's been really cool. Let's see, to watch you learn. Oh, thank you, Yana. Yana's like, yeah, we know, Carrie. We've been trying to teach you. And Mark knows because Mark's been here from the beginning, and he said you're doing a great job with the trial, Carrie. We appreciate all your deep diving commentary. Thank you. Court is back. Y'all, I'm live. What do you mean court's back? What you talking about, Amy Crew? We're live on Long Crime. They're still not showing it. Amy Crew. Never mind. I'm wrong. Psych. She said psych. No, here they come. I did see something come up, though. Let's see. Scout November Light. What a cool name. And I'm looking at your different photos. That's cute. Your picture says, hope y'all all ready with your 5 peppermints. I know I am. I did. I went out and bought my 5 peppermints last night. Yes, I did. I'm just kidding. Got no damn peppermint. Did everybody put in their order for their Pop-Tarts this morning? Okay, why am I seeing the coverage on my phone and I'm not seeing it? Because my phone is not live. Okay, that's irritating. The electronics are messing with me this morning. Scout, where are you coming in from? Is that, it's not a regular dollar sign. What's going on? What? So you're not in the U.S. Where are you coming in from? Let me know. I think what we're going to do next after this case is over, you guys, is, yeah, I'm still on coffee too, Jeannie or Millie. I want to go into that Courtney Clenny OnlyFans model and start diving into her docket. That sounded so bad, but it's true. What kind of snacks do you guys have? Oh, you're in the UK, from Sweden originally. Oh, wow. That's so cool. That's so cool. We can grab the liquor later. We might need liquor later, you guys. Jeez, my knees. I mean, it's funny because we've been talking about AA and stuff since this trial started because of what it's all about. And it's amazing to find out how many people in here are recovering alcoholics. It amazed me last night listening to, I keep saying last night, yesterday afternoon, listening to the pieces from the jury selection, how many people either were affected by alcoholism in their family, they themselves, somebody they knew, and then also the next step was domestic violence. They themselves, someone in their family, or someone they knew. And I kept thinking, wow, our potential jury, they're dropping like flies over there. Everybody was connected to something somehow. Or you know what I didn't do because we were watching it? I did not go into Twitter and find out exactly what it got narrowed down to yesterday. I don't think it did. Did anybody look? I'm going to open Twitter right now and take a quick look. And see if I can find anything for you guys. Because before that, we were. I was getting all the deets about the jury selection. But since we watched it yesterday, I didn't, but they didn't dismiss, to my knowledge, they didn't dismiss any jurors yesterday because they're still going through them all. Because the defense now has to come in and ask their questions. Hi, Leah. You weren't in chat when you were discussing the actresses to play Sarah yesterday. Was cracking up on the replay. Renee Zellweger would be perfect to play Sarah, and she's 5'4", so she's the right stature too. Her or Megan Mullally. Somebody said we like the idea of Maggie Gyllenhaal. Is that her name? But she is too tall. Somebody said. You're right, Kesa Rosarod. They didn't let anybody go because they still have the questioning going on. You guys, please give some love to Bama and Laura for being here and keeping y'all in a safe space. Billie Jean says if she went to bed scared George would come after her, doesn't she think that he would come after her when she woke her? And her sleep voice text spelt George wrong. Thank you for all your hard work. Yeah, like if you're scared, do you really go back to bed or do you leave at that point? You've got him in a suitcase, so get the heck out of there. You got your car keys, you got everything you need. You could have left. Is that where we're gonna be, you guys? At the end of this trial, are we gonna be sitting here looking at just that? Is that gonna be what's gonna be the qualifier? It's after everything that we've been huffing and puffing about while we've been preparing for this trial. The jury's going to be sitting there and they're going to say, well, that night she had the chance to leave if she wanted to, and she didn't. She stayed in the house, which told us that she knew he wasn't going to come out of that suitcase. Or, are you guys, do you understand what I'm saying? We've sat here and we have dove into this case backwards and forwards, trying to find the angles. Where's everybody going to be coming from? What's going to happen? And the jury's going to say, yeah, she could have just left. I do a great impersonation of Sarah. Thank you so much. No, wait, I don't know. You know what's funny is I got to stop listening to that stupid interrogation because yesterday I was making comments and I was listening back as I was editing it out. And I thought, oh my word, I'm starting to sound like Sarah, talking like she does, making the same comments she does. You guys are so nice in the chat. Wow. Who's paying you guys to say all these nice things? How much are you making? Please, if you don't mind, y'all, make sure you hit the like button on your way in or on your way out. It does help me tremendously. No, it doesn't count if you like it twice. But thanks for trying. Keep in mind that the jury will not see. Exactly. And Michelle, that's just it. Like, that's what I was thinking about yesterday. We've got to go into this with the mindset that there's going to be a ton that we know because we've been so involved in this case for well, it's been going on for 4.5 years. I know on my channel, my deep dive started back several months on it. But what is the jury going to have? What is the jury going to truly be able to see? We're going to have to keep that in our mindset and not what we already know about the case. So we're not questioning the things going on. Very, very well said, Michelle. Yeah, she called the police on him, Zombie Girl, for pretty much anything she could. It's like Sarah was bored one day, so she calls the police. Sarah's not getting enough attention, so she calls the police. Jean said, battered spouse syndrome is allowed as a defense, but in my opinion, George is the true battered one. And I'm going to tell you right now, don't worry, Jean. I think what's going to happen is the state is ready for that. Because, like I said earlier, when he mentioned George's size and that he was only 103 pounds and that Sarah was clearly the aggressor, the initial aggressor, the state is in it with us. They are on our side. They are in the thought process of all of us here. So this is good. All right, when we get audio, I'm going to shut up. We don't have any yet. That poor court reporter. I wonder who that is in the back there. In the gallery. That's not Copsel. Her hair's too long. And she was sitting way far away from them on the other side by the window the other day. Yesterday. Oh, Angela S. I'm a retired homicide detective of 20 years. I have sat as advisory detective witness at the state's table numerous times. You are doing great, and I appreciate how you ask for proof on everything. Ah, cool. Thank you so much. That means so much to me, knowing that you have all that experience and you still think I'm okay. Thank you. I question myself a lot. Thanks, Angela. I appreciate you. Yeah, Emma. She could have, once she got him in the suitcase, the thing would have been to call 911, left the door unlocked, called 911, and
We're
said,
back on the record.
Go get
Case
him.
number 2020 CF 2603, State of Florida versus Sarah Boone. We get appearances for the state. Okay. Ms. Boone is seated at counsel's table wearing the same clothing from this morning. Ms. Boone, a third of your defense team is not present at the moment. Are you amenable to proceeding without Mr. Beck being here? Okay, thank you very much.
Yeah,
That cures itself. Counselor?
There he is.
Thank you. Record reflect that Mr. Beck has just entered the courtroom. All right, the court's had the opportunity to review the excerpts from the motion in limine hearing from yesterday. And my understanding is both the state and the defense were provided copies of same. Mr. J, is that accurate?
Yes, Your Honor.
Mr. Owens, is that accurate?
Yes.
Okay. The court's reviewed it. Are there any questions with regards to the court's rulings on that motion?
Yes, Your Honor.
Yes, sir.
My understanding is that based on
Sure. Madam Clerk's providing you a printed copy, sir. Bless you. Have you had the opportunity to review that excerpt yet, Mr. Owens? All right, go ahead and take a look at it.
Thank you, Blanco. God knows we need that fund. I was wondering who was going to support me on that fund. I knew you'd come through for me, my friend. Oh, Donna, thank you for being here so long yesterday. It was a long day. I was so tired. I didn't even eat lunch. I had peanut butter crackers. I've got to start getting up and walking around while they're having jury sessions or discussions so that I'm not sitting at my computer the whole time. Why is he looking at this with her? I swear I think he's placating her. Isn't that the word
Okay.
that I need to be using? Placating her?
All right, Mr. J, you may proceed.
Thank you, Judge. We are referring to a rough draft printout that the court reporter made. It's 4 pages of part of your rulings from, there were several motions yesterday, but in this one, it's on page 1, lines 22 through 24. Part of the court's ruling was it's indisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court prior to battered spouse syndrome evidence coming in. And perhaps the state wasn't clear in its request, and I apologize if I was not in our motion, though. But paragraph 24 of the state's motion includes a quote from the Holland case. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an overt act by the victim at or about the time of the incident that reasonably indicated a need for self-defense. Holland versus State, 916 Southern 2nd, 750, page 760 of that opinion, a Florida Supreme Court case from 2005, which was quoting Quintana, Quintana versus State, 452 Southern 2nd, 98, page 100, a Florida First DCA case from 1984, also quoting Williams versus State, 252 Southern 2nd, 243, 246 is the page, Florida 4th DCA 1971, Reed, R-E-I-D versus State, 213 Southern 3rd, 1110 at page 1111, Florida 5th DCA 2017, Rudin versus State, 182 Southern 3rd, 724 at page 726, Florida 1st DCA 2015. So what we were asking for is in addition to the battered spouse syndrome expert testimony to not be mentioned prior to an overt act being laid was any evidence of the victim's character, including reputation or prior bad acts. We apologize if that was not clear, since the motion is titled the battered spouse syndrome evidence, but the backbone and basis of that battered spouse syndrome is obviously prior bad acts by the victim. So we are seeking a pretrial ruling as well on the admission of prior bad acts, specific bad acts, or reputation evidence of the decedent.
Thank you. Response.
I just have one question as to what time. Are we talking about for Dyer? Are we talking about opening statement? At what time are we talking about?
During the testimony in the trial.
That was my takeaway.
Okay, he's absolutely correct.
Okay, then the motion's granted. So the court's going to rely on that specific excerpt in Holland, 916 Southern 2nd, 750 at pinpoint 760 through 761. Beginning with, as a general rule, evidence of a victim's character is inadmissible to prove actions in conformity with it on a particular occasion, section 90.041 Florida statutes. However, when a claim of self-defense is raised, a defendant may introduce evidence of a victim's character to establish who the aggressor was, or that the defendant was apprehensive of the victim at the time of the homicide. Internal citations omitted. However, before a defendant may introduce evidence of the victim's character, he must first show that there was an, quote, overt act by the brackets victim, end bracket, at or about the time of the bracket incident, end bracket, that reasonably indicated a need for bracket self-defense, end bracket, internal citations omitted. That's the standard. So hearing no objection from the defense, the motion will be granted.
Judge, just understand, clear on the record. procedurally, before we can put evidence of that, there has to be a claim self-defense. That has to come from someone, and in this case, we all know that has to come from the state.
Received and understood. Any other clarifications for the purposes of opening or trial based on the court's oral rulings on the state's motions in limine yesterday?
No, Your Honor. And then the only other thing that we beg of the clerk of the court and the court is just that we can have some written rulings, even if it's just minutes from all the motions that were ruled upon yesterday, at some point, for the record, for the 6th DCA.
Okay.
Yes, ma'am.
All right. Thank you. Anything further from the state before we proceed with the objections? Defense.
Judge, yes, just my overall understanding is that the motions and the orders that the court has applied to trial and the organization or the flow of the evidence at trial. Certain things have to be presented before certain witnesses can testify. It has nothing to do with or diet nor open statement.
That is correct. And the court ruled specifically on that yesterday. And that's in the excerpt that was provided to you and your co-counsel. All right. Thank you.
I also believe part of the court's ruling was that the testimony that was proffered, the expected testimony of the defendant that was given to the experts, I believe the court's position was if that is the testimony, then that is not an overt act.
The court's statements yesterday speak for themselves. I'm not going to rehash that matter today. Anything else, Mr. J? Anything else, defense? All right, let's proceed with these objections. The court again has had the opportunity to review that 5th amended reciprocal discovery exhibit list filed by the defense, I believe back on October the 2nd or the 3rd, and the court was provided yesterday the actual exhibit list itself and the state's response and objections to same. There's no need to go over the items for which the state has no objections. So state, I would ask you just to, provide as to the ones that you have objections for, and I have notes with regard to all of them. So you may proceed, sir.
One by one, I assume?
I think that's the easiest way to go. I know we start with item 1 and then go to 3, 4, et cetera. So we can ping pong it back and forth from there.
All right, regarding item number 1 on the 5th amended reciprocal discovery exhibit list from the defendant, I do not believe we have received those records.
Response from the defense.
You're referring to 1A1?
We're referring to 1. 1A is all the state's evidence that you believe you can use, and I labeled that as paragraph 0 in my response. So specifically talking about your paragraph that you labeled 1, certified medical records from Advent Health Orlando, paren, not yet received by the defense, paren. It's not yet received by the state, paren.
The defense has not received those records.
Motions or the objection is sustained. Moving to 3. Are these the 550 pages that we addressed yesterday?
My belief, and again, none of the exhibits are numbered as they get disclosed to the state. They're not Bates numbered. I do that myself. But what I have and what I believe is states 2 was 81 pages of records regarding treatment by.
I'm not talking about 2. You don't object to 2. Talk about 3.
Well, I do need to talk about 2 now because
Okay.
This morning, after having previously already been given 81 pages of records that purport to be from Winter Park Advent Health regarding treatment of Sarah Boone over a variety of different dates spanning 2018 to 2020. After having received those, reviewed those, and made my decision on not objecting, this morning I was given a thumb drive from the defense, which contained 119 JPEGs rather than a single PDF with 119 pages. A JPEG, for the record, is a digital picture. They were upside down, they were sideways. I got them all formatted. I was able to read them while we were waiting for Madam Court Reporter. They do not appear to be completely the same as what has been previously provided by the defendant in regards to Winter Park's Advent Health treatment of Miss Boone. So I just want to be clear that now, since the state's response, there has been some sort of change in what those records purport to be. And we are objecting. We are requesting a Richardson hearing regarding the 119 JPEGs that we were provided this morning in regards to defendant's exhibit number 2.
At this point in time, the court is going to proceed with a Richardson hearing. Defense?
Judge, referring to our paragraph 2, the defense exhibit.
Correct. My understanding, based on what Mr. J just provided, and based on his response, is that there were 81 pages provided to the state on or about September 27th, 2024. State had no objection to those. State further identified that this morning a thumb drive of 119 JPEGs evidencing something else was provided. And under the mandates of the 6th District Court of Appeal, based on Young v. State 369 Southern 3rd 1243, I am required to conduct a Richardson hearing. The court is conducting a Richardson hearing at this time.
Judge, the 81 pages that.
The 81 pages are not at issue.
I understand that they were given Sarah Boone from the Advent Health report. The 119 pages, my understanding is we thought we had sent them previously. We realized yesterday or last night that we had not sent them. So we provided those to the state as soon as we were aware that we had not.
And what do the 119 pages evidence?
Their medical records from the hospital relating to Sarah Boone over a period of time. So obviously that's going to be whittled down depending on her testimony and whether or not it would cooperate. Her testimony that she suffered an injury at the hands of Jorge Torrez.
I need more specifics than that. I don't have a time frame. I don't have when. I don't have what.
Well, it's going to have to be matched up with the dates that she was injured, which would coincide with the.
But that all goes to the irrelevancy issue. We're conducting a Richardson hearing at this time. So I need to address the inadvertence or willfulness of the discovery. I need to address whether it was trivial or substantial. And if I don't know what's in these 119 pages, it's difficult for the court to determine whether or not this is a trivial or substantial matter. Are these items that were previously produced in the 81 pages? Are they different? Are they different events? Are they different injuries? Are they different things? Moreover, I need to make a determination as to whether this violation had an impact on the ability for the state to properly prepare for trial. Those are the 3 prongs that I need to address.
My understanding is the first 81 pages were medical records of Sarah Boone that we got from one of the previous lawyers that we had sent to the state. The other medical records were those that we had requested directly from the hospital that we got last week or late last week, and we just failed to immediately provide those.
When did you receive them last week?
I'm not sure, Judge. I have to get my secretary. We have to take a break and let me find out from my secretary when we receive it.
Okay. I'm going to continue with the balance of the objections, and we'll circle back on the issue with regard to this objection so that you can provide when, where, how, what.
My staff is
Understood.
texting her.
All right. I'll make a note to circle back to this issue. Moving to number 3. Is this the Advent Health Winter Park Jorge not yet received by the defense? State's response reveals a motion in limine was filed regarding this motion. Is that the 550 pages that we addressed yesterday?
Yes, Your Honor, the state still has not received a whittled down exhibit that they plan to introduce at trial.
The court ruled on that yesterday regarding the blood alcohol content records, and the narrative would be admissible.
I'm still waiting for those particular pages to be disclosed to the state.
Okay.
You want the exact pages that those,
Yes,
the DAC and the narrative are on?
that's what's going to be offered into evidence at this point in time.
Judge, we'll work on that.
Appreciate it.
I've got staff here in the courtroom.
So as with regard to the state's objection to item 3 that was previously ruled upon yesterday, is that the same with regard to the state's objection as to item number 5, certified medical records, Advent Health, Ultimate Springs, George?
I believe so, without being able to tell. Advent Health, it just seems to all come from Altamont Springs, the records. So I believe that is all encompassing, but so we don't have an objection other than the ones previously noted for 3 and 5.
Okay, thank you. Moving now to item number 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they also have not yet been received by the state.
I think, did we address number 4? We went from 3 to 5?
Oh, I apologize. You're correct. 4, certified medical records, Advent Health, Altamont Springs, Sarah, not yet received by the defense. I'm assuming also then state you have not received them?
I believe the only records until this morning that I had was the 81 pages from Winter Park disclosed on September 27th, 2024. If there is something that they have from Advent Health, Altamont Springs, I don't believe I have that.
Defense?
Judge, we have not yet received those records. We had Sarah Boone sign a medical release, and we have sent requests to various medical facilities asking for records, and we're just waiting on a response.
Too late. Too late. Oh, well. Can't use them.
The objection sustained. Moving to 6, certified medical records, Orange County Jail, not yet received by the defense. I'm assuming they have not yet been received by the state either.
Last night, after business hours, I received 382 pages of jail records regarding Boone. Once again, I had to spend my personal time reviewing these records. Of the 382 pages, probably fewer than 5% refer to her mental health and the psychiatric treatment that gets provided to inmates at the Orange County Jail. The other 95+% of these records is all about physical treatment, COVID tests, things I won't outline here unnecessarily, since I do not believe these records will come in, but all of the things that you would expect a middle-aged inmate to have to go through for the course of 4 years. The state just is having great difficulty understanding what, if any, pages of these records are relevant. On page 135, there's records from part of her intake procedure on February 26th, 2020. On page 137, that's the initial screening when she came into the jail on February 25th, 2020. Page 137 and 138 include this initial intake screening. But from there, we get pretty far removed in time, pretty far removed in relevance. So the state is objecting to the introduction of these records. Even her intake screening on pages 135 through 138, I don't understand the relevancy of it. She indicates panic symptoms. She's semi-cooperative, has poor insight, unrealistic expectations, wants holistic treatment, doesn't like being housed alone. The screening on 225 goes through alcohol abuse, yes, type, spirits, not wine. Last used 2/23/20, several times a week. The intake screening also includes a history of violence towards others, yes. So there's no psychiatric treatment records for treatment for trauma. Any of the recognized trauma diagnoses in the DSM-5, PTSD, or any of the other trauma symptoms that can be diagnosed. There's no records of any treatment of that. It's just the anxiety, which, having read the expert depositions, I'm sure you understand that that was pre-existing before the jail. So our objection is we don't understand the relevance of these records. They do not go to her subjective state of mind on February 23rd, 2020. They do not go to help us understand whether somebody in her position was objectively reasonable on February 23rd, 2020. And quite frankly, most of it's just embarrassing and irrelevant, and it would bog the jury down, much like 487 pages of Jorge Torrez's records. There's just a lot of COVID screenings and blood test results, and we struggle to see the relevance, Judge.
Thank you. Response?
Judge, it's similar to the state about 10 days ago, sending me over 500 pages.
We addressed that yesterday. That's not germane to the issue.
As soon as I got the medical records, I sent them to the state. He mentions anxiety was pre-existing. Now, that's not what their expert, Dr. Werner, opined in her deposition, that the anxiety she may be suffering from at the jail was from being in the jail. So there are questions about that, but generally you get these records, as you know, when you have a forensic psychologist that's trying to evaluate a patient.
What is the relevance of these records? What do COVID tests have to do with anything in this case? What do blood tests have to do with anything in this case? If they don't, then what of these 382 records, 382 pages of records are relevant? What specifically is relevant? What page? What date? What document? You're not answering my question, counselor. They are listed on your exhibit list. The state is taking the position that these may be sought to be entered into evidence.
I don't intend on introducing this exhibit evidence. I intend on potentially the doctors, the experts, Dr. Werner, Dr. Harper, to rely on these records.
The depositions of all three doctors predate their request for these records. So it's pretty unclear whether any of these experts have already reviewed these records. Now we're going to have to address, when do I get to depose their doctor, Dr. Harper, if she has not reviewed these records yet? When do I get to depose her? Who's going to pay for the expedited cost for the transcripts? What relevance is it to her if she hasn't reviewed these records? They got these records post deposition, post evaluation. The last date that I believe she saw Ms. Boone was September 30th or October 1st. And then we took her deposition either the 1st or the 2nd. So this is also a problem, even if it's just going to be relied upon and not introduced. And I appreciate them letting us know that they don't seek to introduce these records into evidence, because of course, experts can rely on inadmissible evidence if within the course of that area of expertise, it's the type of evidence that's routinely relied upon. But how are these records relied upon if They acquired them after we've done all the depositions. Now, Dr. Harper did say that she relied upon some jail records during her deposition. State didn't have those at the time. I don't know what the date span is of the records that she did review at the time of her deposition. So now we have new issues to confront. We would like to know whether or not their experts have been provided these new records so that we can address that.
Mr. Owens?
Judge, I don't want to delay the trial. I'll wait. I will not have Dr. Holcomb review.
So she has not yet reviewed these yet, correct? Okay.
I don't want to get in a situation where we will take another deposition. So I'll wait. I will not have her review.
Okay. State with,
That was the only purpose.
okay. So state, understanding that tactical decision and that Dr. Harper is not reviewed and seemingly will not be relying upon these experts, does that cure any concerns that you have?
Yes, sir.
All right. Then based on counsel's representation, the court's not going to sustain or overrule the objection, as the defense has identified they are not going to be seeking any of these 382 pages into evidence. Moving now to 8, 9, 10, and 11. There's no issue with regard to the body cam footage, but there is to the police report itself. What is your response to that, Mr. Owens?
Judge, the arrest reports are not listed as evidence in itself, but the reports may be used to refresh the officer's memory if needed during their testimony.
Okay. Does that cure that understanding?
Yes, sir.
Okay. All right. So based on Mr. Owens's representation, as those items will not be sought to be moved into evidence or received into evidence, but only for the purposes of refreshing a recollection, the objection is not sustained nor overruled, as they're not going to be sought to be entered into evidence. Moving to Exhibit 17. No, I'm sorry. 16. 16 is a repeat of 11, so the court's going to adopt its, or similarly with regard to that exhibit. Mr. Owens, are you only going to be seeking the arrest report for the purposes of refreshing?
Yes, sir.
Okay, so court's same ruling with regard to Exhibit 16 as with 9, 10, and 11. Moving to 17, the jail calls involving defendant and third parties. State, anything else to add other than your written objection?
No, Your Honor.
Response?
The defendant is not intending to introduce the jail.
Okay, the objection is sustained. 18, prior criminal history of Jorge Torrez not yet received by the defense. Has the state received that?
Other than the arrest history that's resulted in interaction with the state attorney's office, we have not. He's not a testifying witness. So obviously we have to provide, if they can't get it through due diligence, rap sheets of witnesses, but he's not a witness. So we have not done anything other than had discussions about prior interactions with the state attorney's office.
Okay. Response, Mr. Owens.
Judge, we're referring to the prior record involving Sarah, that Sarah's aware of.
Okay.
I know he had some priors in Pennsylvania, in Massachusetts, we're not referring to those. We're only referring to the ones involving incidents involving Sarah.
I'm just trying to understand, are they seeking to introduce some sort of paper, or is this just the broad notification that Ms. Boone, when she testifies, will be testifying about any prior incident of violence that she wants to regarding the decedent, because can't rebut it.
What is it? Is this oral testimony? Because this is an exhibit list, so that's my confusion. Because if it's oral testimony, that may be a different critter once the overt act is established under Holland.
Judge, she's going to testify to it, and then it kind of ties into that evidence being used to refresh the officer's testimony. The officer's testimony, we believe, is going to corroborate Sarah's testimony about her injuries. anything about prior criminal history other than what she's testifying to.
Okay, so there's not going to be any documentary or physical evidence that's provided, informations, charging affidavits, a criminal history report, anything tangible that's going to be offered to establish that criminal history other than Ms. Boone's testimony? Is that your position?
Yes, unless there's some dispute about that, that we have to cooperate and ask the court to take some judicial notice that there was a case file that was set up to handle that criminal prosecution.
Okay. Mr. J?
I don't know that papers generated by a government agency is relevant. The disposition of the papers that were generated by some government agency is relevant. What's relevant is if there is an overt act that gets testified to, prior instances of violence by the decedent that she is aware of. That doesn't open the door to hearsay. That doesn't open the door to any of these things that he seems to be referring to, whether it's criminal rap sheets, which is what I believed he was referring to, or police reports, or state attorney records of no bills, or I don't know. Based on his last statement, I don't know what we're talking about now, but we do have hearsay objections to, I thought we were talking about physical exhibits. And that's what our objection would be to believing that what was represented was a criminal rap sheet.
Judge, part of battered spouse syndrome, and Dr. Brennan will testify, I assume Dr. Crumble will testify about it, Dr. Warren will testify, is this feeling by a victim of being battered that she has nowhere to turn. Her family can't help her, she has in group. The state attorney dropped 3 of the charges. 3 separate times Jorge Torrez was arrested, charged with violence against Sarah Boone. And her request, she wanted them dropped. That's part of the syndrome. But in addition, in her mind, she felt like the state attorney had let her down. They could not, they dropped 3 of the cases. So she felt helpless that there was some outside entity that would protect her. That ties into her state of mind as to whether or not she felt an imminent threat at the time of this event. So that may become relevant depending on what Dr. Harper says, Dr. Warren says about that, what Dr. Brandon says about that, as to whether or not she felt helpless because the state attorney's office was not prosecuting Jorge Torrez when she was.
But that all sounds like oral testimony. And again, this goes back to, this is an exhibit list. What are the exhibits? Tangible, physical?
We may want to introduce something in a court record indicating that the state attorney dismissed it.
Okay. What does that have to do with prior criminal history? Because that's the topic here. Prior criminal history of Jorge Torrez Jr. not yet received by the defense. That's the line item in your exhibit list.
I will withdraw the prior criminal history.
Okay, all right. So based on counsel's representation of the withdrawal, the court will not sustain or grant the objection. Does that clarify that for you, Mr. J?
Thank you.
All right. Moving now to 19, Orange County Sheriff's Office Investigative Workup Report. Response.
Has to be used to refresh the officer's memory if need be during their testimony.
Okay. With that understanding, Mr. J?
Yes, I'm not clear what a workup report is, but if it's not sought to be introduced into evidence, then I will accept that representation.
Okay, so accepted. Your objection's overruled based on counsel's representation. The investigative report workup will not be offered into evidence, but merely for refreshing. Moving to 21, all court orders in all Orange County criminal cases regarding Jorge Torrez. State. Any further argument?
I believe we went from 19 to 21 without addressing 20.
Oh, I apologize. I had the wrong, I color-coded this and I miscolor-coded this one.
We don't intend to introduce anything on 20.
Okay, then based on counsel's representation of withdrawing that, the court will not rule on that objection. Moving to 21, anything further, because we kind of addressed this as well with number 19. Anything further, argument state. Anything further, argument? Okay, I'm going to overrule the objection as to, as this point in time. Because if a declination of prosecution may have been filed, that may be relevant based on Ms. Boone's testimony. So I'm going to overrule your objection at this time, assuming the overt act concept is placed into evidence. Moving to 22, family law case file Boone v. Boone, case number 2017 DR 01660-0. I understand the state's objection as to relevance and hearsay. Response?
Judge, Brian Boone, the anticipated, is going to testify for the state, he testified for the defense, and he may be considered an adverse witness or hostile witness, and so we may attempt to establish either bias on his part based on some of the documents or orders in the court record, or we may reflect, for impeachment purposes, the fact that he has not complied with some of the orders, and that the reason being is because of his feelings for the defendant. You know, he's now got full custody of their son and has had full custody for 4.5 years. That was not the agreement they originally had, and he was ordered to pay alimony, which he has failed to do as a result of her being incarcerated. So there's litigation going on. Brian Boone has counsel considerable, does not have that force, but there.
What does
And
the
what he says,
what does the non-payment of alimony have to do with what's happening in a family case?
well, that, Judge, that goes to his testimony, that goes to his credibility, whether or not he can be impeached, that her in the position that she's in now, he's biased, and to show that he's biased, that he has not paid alimony for her. He's supposed to pay $1,000 a month for a number of years, that he's just failed to comply with the court's order. That shows his personal bias or feelings towards her.
Response?
Sounds like this is ongoing pending litigation that has not been decided by a circuit court judge in the Ninth Circuit Family Division. I can certainly understand why one may believe they don't need to pay alimony when their spouse is incarcerated. I can certainly understand why somebody may believe they don't need to pay child support when their spouse is incarcerated, and they would probably want to seek legal redress about those issues. And it sounds like it's all ongoing.
Are there any orders from the court in that case addressing the non-payment of alimony and that being contemptuous or in violation of any court order?
No, they were divorced. I think there was a marital settlement agreement that was attached to the final order. Brian Boone did open the case back up to move the child to Gainesville, which has happened. And then my understanding is there's still some issues. I think she was given some kind of a notice of the hearing coming up. She's not represented. I don't represent her.
Is there, so if there's no order in the court file finding there's a violation of an order to pay alimony, what is?
Well, there's a final order about his obligation to pay alimony, and I think if he gets on the stand, I'm going to ask him, but you haven't paid her alimony like you were ordered to do so. I can go into under cross-examination.
But it sounds like there's pending litigation, including a relocation and I don't know because that's not my case and I haven't looked at it.
That's been decided. He has been able to relocate. I don't know all the ramifications. I'll look at the clerk file. I think we had subpoenaed the custodian of the records of the clerk file. I'll look at it and I'll let the court know and the state know.
Can you all approach just for a moment?
I think the judge right here is finally calling out Owens and the whole defense team. Oops, I got my phone on this sidebar. I'm wondering if that's what this is about. There's too many things that he keeps bringing up that, well, we don't have that piece of it, or we're getting to that, or we haven't done this, or we didn't realize you'd need that, and we thought the state knew, and there's too much of that going on. And the judge sees what they're doing. He's not stupid. Bet you money. I wonder about. So they're saying that Brian has not paid alimony. He hasn't paid alimony because, according to the records, the judge ruled that they were going to address this, I thought, once they found out what happened with her sentencing here, or what turned out here in her criminal case. And I don't see how. I guess they're saying if he gets up there and talks bad about Sarah, the defense is going to turn around and say, well, you want her to go to jail because you want her to you want her out of your life, and then if she goes to jail, you won't have to pay her any money moving forward. That is opening a whole new can of worms, I think. Yeah, no doubt, Heather. No doubt. I had seen before, I think, where they had moved up north, and I'd kind of left it open. Like every time I saw it, I think one time I mentioned it and I caught myself and I was like, shh, don't do that again. But now he's put it out there to everybody that's watching the trial of where they're located, which is so unfair. To her son. She doesn't give a crap about her son and what he's been going through. Everywhere she goes, she leaves people in her wake. She is just one of those type persons. So I wonder if that's going to be a problem, you guys, where they're saying that on the police reports and the work reports and stuff, that all these reports from the police department, whatnot, I hope they're looking at that closely, because I feel like the defense is trying to slip something in there, because they're saying we're not going to use those as evidence, but if the witness on the stand needs to reference anything in those reports, they can. That's just, yeah, it's just like Sam said. They're just dumping at the last minute. They're dumping all this crap on to the state. And I almost feel like there's no telling what they're trying to pull in while they're doing that. It's like, watch this hand over here while this hand over here slips this in, you know? Oh, she is a parasite. Just, oof. Just ridiculous. CB, they're just pathetic. I agree. Hey, D. Hogan, thanks for becoming a member. Oh, you look pretty today, Sarah. I just wanted to tell you. Cater to her. Owens is like, she's getting pissy. Go over there and give her some attention. Get her off my back. I'm trying to do something. Distract her. Oh, they're friending. Isn't that sweet? Hey, can I be your friend on Facebook? No, that wouldn't be possible. I don't think so. I think after this case, I'm not going to be able to talk to you anymore. Loba says, about the parts redacted from the police interview, can the DA ask the detectives when on stand about those comments? Yes. Redacted from the police interview? No. I think once it's out, it's out. And they said, you're referencing the pieces where he goes, well, you realize you killed him. And she's like, I've thought about that. That's one of the statements. There's some other statements in there too, which again, we'll go over that when we have a pause here in a moment. It would be a good document to look at today. But no, if it's pulled out, it's pulled out. That is my understanding. Now, if there's anybody in the chat that knows for a fact that I'm incorrect on that, please call me out and tell me. Miss Pensacola. That's a good one, Mark. Mark W. He's giving our other Mark a run for his money on the comedy in the chat. You want to go for drinks after we're done, Sarah? No. No. Watch, you guys, watch Sarah get up on the stand and talk about being in recovery from being an alcoholic.
All right,
She's
thank
going to
you
do
all both
that.
for your arguments and clarifications. Based on, court's going to overrule the objection at this time for the reasons discussed at sidebar. Moving now to 23, the policies and procedures of the Orange County Sheriff's Office regarding Miranda. Have those been received by you, Mr. Owens?
Yes, sir.
Okay.
I'm no longer seeking to introduce those.
Okay. All right. Based on counsel's representation, court takes no action on the state's objection.
Same with 24.
Based on that representation, court takes no action. Moving to 25, records from Tealwood Park Apartments.
Judge, we never received what we wanted. We're not seeking to introduce that.
Okay. Based on counsel's representation of not seeking to utilize it, court takes no action on that objection. Moving to 27.
26, the defense does not intend to introduce any of the 911 calls.
Okay. All right. Thank you. Moving to 27, the video footage of the arrest on February 25, 2020.
The defense has not received that. The state may have it in their possession. It appears there's news footage of Sarah Boone in handcuffs being escorted.
State, do you have such an item in your possession? News footage?
No? Not that I know of.
All right, but we have not received it, so we don't have the evidence.
Okay. All right. Based on it not being received, court's going to sustain the objection. Moving to 29, the iPhone photo file name. Not going to read it. It's very long.
Judge, I do not intend to introduce 29.
Okay. Court takes no action based on counsel's representation. Moving to 32, iPhone photo. Yeah, I'm sorry, sir.
29, what is the ruling?
There is none, as the defense has advised they are not seeking to enter it into evidence. 32, another iPhone photo file name. It's very long, so I'm not going to read it.
This does not intend to introduce.
As such, the court will not take any action on that objection. 33, another iPhone photo file name. Court's not going to read it because it is too long.
Defense does not intend to introduce.
Based on counsel's representation, court takes no action on the objection. Moving to 48, another iPhone photo file name, 505 period JPG underscore embedded underscore 1 underscore 772.
We would stipulate.
All right, the objection is sustained based on stipulation. Moving to 59 and 60. I understand your objection, state. Any response?
Any and all exhibits previously listed by the state?
Mhm. Yes, sir.
Judge, Mr. J is a smart lawyer with a lot of experience. He's board certified. He's filed this motion in limine to disallow the battered spouse syndrome twice. And yesterday, we were forced to disclose the overt act that constituted our defense that tied in with the self-defense. And so tactically, he was able to get us to that posture, so he knows our defense and how we're coming at it. The problem is the state has not been forced to give the details of what they allege Sarah Boone's overt acts or non-acts.
I need to clarify something. There was no forcing yesterday. The court reviewed Dr. Harper's deposition, and there was no overt act that she had testified to. She was specifically inquired about any imminent fear, and there was no response to those questions. The word overt act did not appear in any of the 4 or 5 sessions that she had with Ms. Boone. And the state was seeking, as we addressed yesterday in limine, to prohibit that.
I disagree with that. That was his deposition. He tried to control the witness. He kept cutting her off. He wouldn't let her finish explaining. I certainly wasn't going to do it. She's going to testify in trial about it. It's not my fault that he felt like he got the answer he wanted and he moved on. He didn't ask for any elaboration about that. But that's going to come out. But I understand that's all you had. But we had to do that. The state has not had to do that. And I understand under the Sixth Amendment that we have a right, the accused has a right to be informed of the nature and cause of the accusation. And the problem with that boilerplate information is we don't know what they're claiming that she actually did, overt act or omission that constituted second-degree murder. So because of that, we have to list everything because we don't know. It's like he wants to know. He wants the court to make rulings so that he can tweak his opening statement based on the court. The same with us. We don't know how to respond to their opening until they give it because we don't understand the full nature of what they're alleging Sarah Boone did to constitute second-degree murder. So in an abundance of caution, we've got to list everything that may be relevant, but we don't know yet because we haven't heard. I would like to renew, they've renewed their motion on battered spouse. I would like to renew my motion for a statement of particulars so that I could know, the defense team could know what it is exactly that the state attorney is alleging that Sarah did or did not do that constitutes second-degree murder. It's a serious charge. This is not, it's a unique case. It's not something that happens every day. And that's why we believe that it was proper under that rule of a statement of particulars so that we could be informed about what it is exactly that they claim that she did criminal so that we could prepare a defense. And it goes to directly to this point, which is they want to know why we want these documents and what documents specifically are y'all going to use. Well, it's difficult to tell when we don't know what we're accused of.
Any response, Mr. J?
Yes, sir. Mr. Owens, Mr. Cacciatore, myself, and Dr. Werner all sat together within 5 feet of Sarah Boone the first week of October and heard the final version. It's not very dissimilar from the version of Dr. Harper, but Dr. Werner's deposition was provided to the court previously for our motion to eliminate. I don't understand the position they're taking that they were forced to show their cards when Dave Cacciatore and myself and Mr. Owens and Dr. Werner were all there together to hear her version. And her version is, it was all fun and games. It was Sunday fun day. He gets into the suitcase. We're all laughing. I zip it shut. We're still laughing. There comes a point in time when he says, I can't breathe. This triggers her based on her past abuse, no overt act that day. And she begins violently doing the things to the suitcase that she says she did, whacking him with the baseball bat on his fingers. And now, after being the initial aggressor, now after having committed a forcible felony or two, now after having put Mr. Torrez in a reasonable fear of death or great bodily harm, she says, well, she realizes now if he gets out after these things that I've done to him, I'm in big trouble. And it's my understanding that we have had this discussion and that if that is the proffered testimony, that that is not going to amount to an overt act, which will allow for reputation evidence, past incidents of violence, or the battered spouse syndrome evidence. they weren't forced to show their hand. I was there. The rules of criminal procedure allowed me and Mr. Cacciatore to be there and to witness this evaluation. So that being said, we're not abusing the system. We're not doing anything that we're not allowed to do. And we're making every effort to make sure that we understand how this trial is going to go down and how they, and Ms. Boone understands how the trial is going to go down. Because my understanding of how it's going to go down is she's going to have to testify to the specific events of that day. And right up when she comes to the point to saying, and when he said, I can't breathe, the state attorney, Mr. J, is going to object. He's going to ask to approach. He's going to say, Judge, there's been no change in her testimony. Unless there is, then that's a whole different bag of worms. But if there's been no change in her testimony, Judge, we got a ruling prior to this that there's been no overt act testified to. Now we're going to object to her answer of because of the past violence, and we're going to object to any further attempt to bring in violence, reputation evidence, or battered spouse evidence. I just want everybody to be clear and on the same page about that. Now, in regards to their request, a renewed request for a statement of particulars, they've had the discovery for several years. This is the state's case. A video that starts at 11:12:45 p.m. on 2/23/2020. Sarah, for everything you've done to me. Sarah, for everything you've done to me. Sarah, F you, laughter. Sarah, F you, laughter. Sarah, stupid. Sarah, that's my name. Don't wear it out. Sarah, I can't effing breathe, baby. Seriously. Yeah, that's what you do when you choke me. Sarah, 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 laughter. Sarah, I can't breathe, babe. Laughter. That's on you. Sarah, I can't breathe. Laughter. That's on you. Sarah, unintelligible, drunken, slurred words. Laughter. Sarah, 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 I can't breathe, baby. That's what I feel like when you cheat on me. Sarah, F you. I can't effing breathe, Sarah. You should probably shut the F up. Sarah. Shh. That's our case. That is an evinced, depraved mind, conscious disregard for whether he lives or dies, whether she put him in there or not, she let him remain for 2 minutes during that video. And then at 11:23:03 p.m., there's another 22-second video, and it just zooms in on the suitcase. Sarah. So that is a second-degree murder case when the medical examiner comes in and says, Jorge Torrez, George Torrez, died from positional asphyxiation and the asphyxiation from being in a confined space. And eventually, after Lord knows how many breaths, he expired in that suitcase when she went upstairs and went to bed. But in addition to those statements, we now have her new statements, which are she intentionally violently shook the suitcase, threw it upside down, hit him with a bat, committed independent forcible felonies. And that's going to be corroborated by the medical examiner's testimony to all the blunt force trauma to both sides of his face and his mouth. That is a second-degree murder case. That is what we're going to be presenting. This is a portion of what I will be telling the jury this afternoon.
Any rebuttal?
I wanted that in writing weeks ago. She was assessed, Sarah Boone, the defendant, was assessed at the Orange County Jail a couple of weeks ago by Dr. Warner. Their rebuttal, state's answer. The characterization that Mr. J just gave about her testimony, I do not agree with. There was 4 of us there. Dr. Warner, 5 of us there. Dr. Werner, Sarah Boone, myself, and the 2 prosecutors. The mistake we made was not recording that assessment. Because I can't testify to what she said. The 2 prosecutors can't testify to what she said. The only 2 people that can testify to what she said is Dr. Werner and Sarah Boone. We dispute their characterization of what she said. That's just going to have to be testified to by Sarah Boone and then Dr. Werner. And jury, while we're here, they are going to have to decide who to believe and what happened. But that is a jury question that we're all going to have to wait for. I appreciate the prosecutor giving me the evidence he intended to introduce to prove second-degree murder. It was something I was asking for a couple of weeks ago. Thank you.
For the same reasons that the court identified when we had the hearing on the original motion for particulars, the court relies on its same ruling in the case law identified at that time. The renewed or tennis motion for a statement of particulars is denied. The state's objections as to paragraphs 59 and 60 are also overruled. The only other issue to address then is the Richardson violation. Court's going to take a short recess, and we'll address that as promptly as possible. It is 5 till 11. I still intend on moving forward with jury selection this morning. We will be moving to 23, correct?
Yes, sir. I'm just making sure I'm clear on 60. Our request was that prior to the testimony of any of the listed witnesses, which I listed only by initials, that we have the opportunity to depose them and we address the costs of expedited transcripts. I just want to make sure they meant to overrule that request.
I apologize because I was just looking at what was articulated in the exhibit list, which was relevant reciprocal discovery to be obtained through ongoing investigative efforts. What's your response, Mr. Owens, with regard to these persons identified in the state's objections who may be called and deposing them?
Well, the state listed a bunch of witnesses on October 3rd. So if the court allows the state to do this and take the depositions, then we ought to be allowed to take the depositions of their witnesses they listed later.
I believe those are the same witnesses that they've listed in regards to the prior incidents, the deputies that went out on the call outs and the cases that resulted in cases to the state attorney's office and 911 dispatchers.
Okay. Is that accurate, Mr. Owens? That October 3 state's list?
But yeah, we don't dispute that they should be allowed to depose them, but they've been listed by both parties, whereas these people are unilaterally listed by the defendant.
Okay.
Judge, again, I'm not complaining. Been on the case 45 days as we have gotten witnesses or found witnesses, Billy Lane or whoever else was trying to locate him on my team, we have tried to disclose. Based on what Sarah Boone has asked us, I want this witness, I want this witness. We've made attempts to comply with her request. Whether or not we're going to call them, the law says, the case law says, Sarah Boone has a right to trial. Sarah Boone has a right to testify. Sarah Boone has a right to appeal. I believe those are the 3 fundamentals. But the defense lawyer makes the decision about which witnesses to call. So although she may want some witnesses, she's asked us to find them and list them and locate them, which we've done. That doesn't mean that I have to call them. And it may not, we may not call many of those that she wants to, but I believe my right to do that and to present our defense with our witnesses is paramount. And she does not have the right.
Okay, thank you. All right, court's going to take a brief recess to address this and the Richardson violations. We'll be in a short recess. Thank you.
I don't know about you guys, but I'm a little bit confused. Yeah, the videos will testify. You don't need a witness for that. That's a good point, Miss 56. The community needs to be protected from Sarah Boone. Absolutely. Yeah, if you guys don't have your snacks stocked up. Y'all need to get ready because we're fixing to go to trial here. All right. So I'm confused about what they were saying about the BSS, the battered spouse syndrome. He's saying the state didn't disclose their overt act and we had to give ours. They made us give it, Judge. They made us give it, our whole case right in front of everybody right before trial. You know what their case is, you guys? Their case is that he could get his fingers out of the suitcase, so he could get out of the suitcase. George could get out of the suitcase, and when he did, he was going to come after Sarah and hurt her. And that is their case. That's their case. Really? Really? Did you guys catch that we're not going to get the 911 calls? They're not going to introduce those. We already have the 911 call from when she passed or when George passed. We just didn't have the previous incident 911 calls, and I was really hoping to hear those. Then he said something about the state putting in the news footage of her being transported or being taken to the police car. I know exactly what footage they're talking about. You guys know when they pulled her out of the interview and they escorted her to the police car to book her? That's the one they're talking about. State's like, we don't have that in there. No, James, that's part of your YouTube feed that you've been watching. Separate your files. You got too many things going on, James. Records from the apartment complex are not going to come in. That sucks too for us because just because we wanted to hear about all these complaints that were coming from Sarah and Brian. I find it interesting, and I think I know why, you guys. Okay, so if you're not aware, Tillwood Park Apartments was the name and owner. I don't know what the owner's name was, but that was the name that they went by back in 2020. They have since been purchased by a different property management company, and they've renamed the complex. I think what they're saying is because this other company, I don't know if they're out of business. I don't know what the status of that corporation is, but for some reason or another, they're not able to get those records now, which I find interesting because I believe that the state probably has those records. But I guess there's nothing in there that the state feels like they need to pursue. But at the same time, are we not going to hear from Melissa, the apartment manager, who had a lot of interesting things to say? If she testifies, are they going to object to her talking about the police being called at the complex? Are they going to testify about if she gets up and testifies about the complaints that they received from their apartment unit? What about Benny? Is Benny not going to testify? Is Brandon not going to? You guys see what I'm saying? Like, how is that going to affect us if they're saying they're not bringing in the records from the apartment complex? I feel like that's a fast move by Owens. So he can say when they do try to call that witness, they're going to say, no, they can't do that, Judge, because remember, we're not putting those records on in the evidence. I don't know. I could be wrong. I'm just trying to think ahead to see I'm trying to figure out what the hell James Owens is doing. You guys, please let me know. I didn't see what somebody said something about ads. I have switched up the ads on YouTube for this particular stream. And to what I understand, you should be getting less ads today than you got before. If you are having issues with ads, can you do me a favor? And it's hard for me to find your comments in the chat, but maybe if you could email me and let me know if it's a problem now than it wasn't before, because I am trying to understand where the ads setting should be so that you guys can have a better experience while watching the trial. Because I know you're not going to miss anything if they play an ad. All they're doing is putting it on pause, and then you come right back once the ad is played. But hopefully there's no long ads being played. Hopefully they're all skippable. Thank you, Truth 17, John 17. Thank you for your hard work and commentary. Thank you. Thanks for being here and sticking with me through this trial. I appreciate you guys. You guys are becoming part of my family here, man. This is awesome. No, I understand. Well, I had somebody yesterday tell me that they got a bunch of ads, like, as soon as they logged on, and I'm like, that shouldn't be happening. Oh, you think it's because of the politics? It's all political ads? Is that what it is? I don't know. I probably should log on without being in my thing, because I do YouTube Premium, and I really like YouTube Premium. The only ads I get are for Curie's merch. Shut up, Mark. Oh, my goodness. All right, so let me go over my notes here and see if I could. Somebody help me understand. They're not placing in evidence the previous 911 calls for their incidents. They're not placing in evidence several iPhone photos from Sarah's phone. Got that. Check. We just heard the state say that they have not deposed all of the defense witnesses yet. That to me was interesting. Did you guys catch that? I'm like, oh my gosh, here we are. We are at day. I mean, we are behind the deadline. What is going on? Has anybody ever seen anything take so flippin' long? CB says that finally I get to see a picture of CB. That is so spiteful. Which part? I mean, I know you're talking about the defense, but which part? Sunday fun day. The emoji list, fan lady says. Please. I know I gotta get up on it. I gotta get up on it. We gotta get y'all all kinds of emojis to use for this trial. I'll work on that tonight, I promise. And CB said they're just pathetic. The defense is. Yes, yes, yes. I agree. I agree. Let's see, what else do we have here on my notes? I'm gonna do a poll and ask you guys how many times James Owens is gonna throw Margaret under the bus throughout this trial. I gotta get that up. So they were talking about these records for Sarah, these medical records for Sarah. 382 pages of jail records. The state questions the relevancy there, and they said less than 5% have to do with her mental health, which is what we're supposedly talking about here. I mean, these are after she was arrested, you guys, so it's not like anything that they're bringing in should really have anything to do with the trial, right? And it's just the defense playing games. They're just dumping. They're paper dumping. George, they still reference the 550 pages from George. They're saying that the defense said yesterday they were going to whittle those down, and they haven't done it yet. Then they said that there was the 81 pages from Sarah medical records, the treatments. This is a separate medical records for Sarah. There's 81 pages of her treatment from 2018 to 2020. The defense just gave this to the state, but this is what they're having the Richardson hearing on. They gave it to the state in images. What they do, text it to them? Like, they didn't say, here's the documents. We're going to scan them in or anything. It's like they literally scanned the images in and sent them to them. So there's no markings. Apparently they're just, I can't wait. Put them up on the screen, please. I hope they do. I hope they put them up on the screen. It sounds to me like all it is a bunch of junk just sitting up there. Just all of her records. Nothing's marked. Nothing's highlighted. Nothing. And that's what James Owens is doing right now. State wants the written rulings from this week's hearings. I want them to, please. Thank you. Thank you, court reporter. What else? The state is saying that all of these records that the defense is bringing in have nothing to do with the state of mind of Sarah Boone the night that George died. And frankly, Judge Cranick, it's embarrassing. We need a J emoji. We definitely need a prosecutor J emoji. He said and the judge did say COVID tests, blood tests, they're not relevant. Judge says, I want pages marked. I want dates marked. I want to know what you're doing. This is the second time the judge has, or is it the third, that's gone back to him and said, this document that you just put in, you need to go through and do your work on it. You need to quit throwing stuff at us and telling us this is what you're doing at the last hour. But judge, I've only had 45 days. So yeah, we feel like the states or the defense is pulling a fast one. But I don't know. Maybe did he give up? Is he saying he's not putting those into evidence? The defense wants the police reports to not be placed in evidence. And the state did not argue that. So the police reports, the Orange County Sheriff's Office work reports, everything that we've been able to see so far, I think, basically the witnesses on the stand can reference their reports when they're being questioned, but the jury is not going to be handed the reports to review in their deliberation or anything like that. Does that make sense? That's the way I picked it up. This is going to be a dumpster fire. Yes, Fawn Fargo. Thank you for your super chat. And I agree. I agree. Oh my gosh. And then they start talking about all these court orders for all Florida criminal records on George. I did a internet, like a paid search. I had this program that was like a paid search on people. And it's not the one that the police use, the FBI uses. It's just one of those that it's a cheap one. And I didn't have any records on George prior to Sarah. So I don't know what they're referencing. I heard a rumor that he may have a DUI out there somewhere, but that's the only thing I've heard. And then they want to talk about the criminal, they overruled them being able to discuss. No, they overruled the state objecting to the family law case for Sarah being brought in. So to fill you guys in on this, I will tell you somebody, SKR has some great footage or videos on the family court paperwork, letters that Sarah's written, things that has happened over there, because I have not been following it. But since Sarah's been incarcerated, Brian has turned, he's done with her. And he's taken his son and they've moved away, right? So he stopped paying her alimony. And the judge had ruled that, I heard the judge ruled that he was supposed to continue to pay alimony, even though she was incarcerated. But that the custody thing, everything else was going to be put to the side until we figure out what happens in Sarah's criminal case. Is anybody, I know you guys follow SKR. Do you guys agree? Can you tell me what you know about that? Thank you, Phyllis Ann. Cooper wants to know when opening statements are. At this point, Cooper, they still have to go back and question the jury again. They're in their, they haven't done their preemptive strikes. It could be this afternoon. It could be in the morning. We're not sure yet. I don't even think they're sure, to be honest with you. Yeah, the alimony debacle is pathetic. Can you guys, hang on, I'm reading your notes. Hang on. What does SKR stand for? I don't know. Oh, I don't know. I would say it's not gonna start until tomorrow. I really feel like that. There's too much. I mean, it's already 10, well, it's 11:15 over there right now. So they're gonna end up going to lunch before they go and see the jury. I hope that it's not Monday. So NR says, that's what I heard. Judge ordered Brian to pay, but he hasn't been paying. That's what I heard too, NR. And the family, and Amy said, yes, what you said, the family court is pending the outcome of her trial. Okay, that's what I thought. Whew. Wow. Yeah, so the defense is saying that he's now going to be, what do they call it? A hostile witness? Because he doesn't want to pay any money to Sarah anymore. So he's going to, it's almost like they're saying he's going to say whatever he needs to do to keep Sarah in jail, which is, I don't know. Are they allowed to do that? Are they allowed to say that? That sounds kind of wrong. Definitely said he's biased because he owes her money. The judge overruled the state's request for the relevancy to bring that in. So somehow or another, that's still an open deal, and we will hear more about that. Jeez. I cannot keep up with all this. I think I've just caught us up on everything that was just discussed in that last segment. State wants more specific on the battered spouse ruling. They did that. They gave them some written ruling on that. Yeah, we've gone over everything. Holy manoli, you guys. Thank you so much, Phyllis Ann. You're so kind. I appreciate you guys. Let me go through these. Buzzman Jr., can you tell Owens is getting frustrated with Sarah? Oh, yeah. We knew that would happen. Guys, I'm telling you, I cannot wait until she blows up in front of everybody. And I feel like she will. I just hope the cameras are on it when it happens. Because, they always cut the feed or they cut the volume or the audio when they're not on session. I certainly hope we get to hear it if there is. Okay, so Michael, thank you for being a member for 2 months. He says federal benefits and 90 days in jail alimony too. Oh, yeah. Everybody's paying for Sarah, but Sarah. Unfreaking believable. I'm going through my notes right now to make sure I'm not missing anything for you guys. Alimony could go to motive for biased testimony. I mean, yeah, I get that. But I guess they're going to allow it. I guess that's... Oh, also, this afternoon, I wanted to remind you guys that we may be going over to the court feed. If Trial TV Live does if they do allow the court feed again, like they did yesterday, we'll be watching it from there. So you guys can stay tuned. Don't go anywhere after this is over. So this Richardson hearing thing that they're fixing to do here when they come back. I had to Google it, but it says the purpose of a Richardson hearing is to determine whether there has been a violation of the discovery rules. I think there's been a couple of those happening here in the last 2 days in this trial, but they're just doing it on this specific evidence. Which one was this? Oh, I've already forgotten, you guys. Hang on, let me go back to my notes. I mean, the way they dumped some of these medical records, it was like, he hadn't even looked at them. He's just like, well, I don't know, just in case, just send them all of them. And then that'll give us a chance we're just going to stall. That's all this is. It's like stalling for the longer this goes on, the longer these hearings go on, the more time that Owens has. He thinks he's slick. I need to get a Daryl Brooks emoji talking about how slick they think they are. Hang on, I'm looking for my notes about where it said Richardson. Oh, it's the 81 pages of Sarah's medical records, her treatment from 2018 to 2023. They can't just give them 81 pages and not tell them specifically what they want to look at, what they want to discuss. I'm taking a verbal break right now. Uh, Thank you guys for being here with me. I really appreciate you because I know that there's a lot of people that are streaming this today, and I appreciate you guys watching it with me here. It's so nice of you. Sarah Unintentional Boone. Somebody put that up as a. Jesus, so ridiculous. It is so ridiculous. Cookie, what? Does Owens really believe the jury will be sympathetic towards Sarah because Brian doesn't want to pay alimony to her awaiting trial for second degree? I know, right? If I'm on the jury and I know, first of all, here's what's going to happen. I don't know who's going to call him first, but when the prosecution gets up there, they're going to say, Brian, how many times did you have to do this for Sarah? How many times did you bail Sarah out? How many times did Sarah ask you for money? How many times did you give her money? How many times did you continue to take care of your son when Sarah wouldn't, because she was intoxicated and called you and said, me and my boyfriend are intoxicated. We can't have him over to the house right now. Brian, how many times have you done this, this, and this? Brian, who has the health care for your son? Who pays for his clothing? Who pays for his food, his groceries? I mean, as soon as they do that, he's gonna be like father of the freaking year, because he is in this case. What did they call that? What was that movie with Michael? What was his name? Mr. Mom. Was it Mr. Mom? Yeah, he's Mr. Mom. So yeah, thank you, Cookie, for your super chat, Mama. Appreciate you, babe. If we have a break, you can come on up and hang out with us if you want to. Barbara said, oh, Gretchen, hey, welcome in. Thanks for becoming a member. Barbara says, disagree defense is pathetic. Since consensus among lawyers rare to deny a new attorney time to prepare a second degree murder case. Today's chaos shows why. Okay. Well, he didn't have to take the case. Thank you for your super chat.
All right, we're back on the record. Case number 2020 CF 2603, State of Florida versus Sarah Boone. State appearances for the record.
William J.
Defense.
James Owens for Sarah Boone.
All right, Ms. Boone is seated at counsel's table wearing the same clothing from earlier this morning. All right, it is 11:24. With regard to the Richardson hearing with regard to item 6 in the defendant's fifth amended reciprocal discovery list, the court is going to reserve and have that hearing tomorrow morning at 9 a.m. Defense is to provide an edited version of only the records that pertain to anxiety or their lack of thereof to the state before 9 a.m. tomorrow morning.
Judge, number 6 was secured by
Okay. Did that happen when I was not here?
No, it happened earlier while we were here.
Then what specifically was the Richardson violation for then, if it wasn't for number 6? And I apologize.
Number 2 is the 119 new JPEG pages, reporting to be from Winter Park Advent Health, and they're a little bit different than the 81 pages that I previously received.
Okay. So the ruling remains the same. Court's going to address the Richardson hearing tomorrow, and you were to provide an edited version of those records that you seek to offer into evidence. Mr. Owens, before 9 a.m. tomorrow morning.
Regarding the paragraph number 2, regarding the Winter Park Advent Health records, the 119 that we gave them this morning.
That is correct, sir. With regard to the witnesses that have been identified by the defense in paragraph 60 of the state's response, those witnesses will be excluded if not deposed prior to being called as witnesses, and the defense shall pay for any and all expedited transcripts.
All right, Judge, the same as should apply to them. There were 3 people that they gave us late that we didn't have before: Rachel Fenner, Meredith McCaskill, and Victoria Shelton.
State response.
Meredith McCaskill is an FDLE analyst that is substituting for an analyst that is unavailable during the trial period. So in an effort to not continue the case, we've got a substitute analyst. So that's our reason for the late disclosure on her. And who were the other 2?
Rochelle Fenner and Victoria Shelton.
And those are the 911 dispatchers. If we end up having to call them, then that's fine. We will pay for the expedited transcripts. What I would expect will not be lengthy nor expensive.
Okay. Has the FDLE analyst that was originally set to testify been deposed in this matter?
Mr. Cacciatore does not believe that the defendant ever deposed that person.
Okay. Any other positions, Mr. Owens? Okay. All right. State will afford the same opportunity to the defense as provided by the state to the defense. Court's going to be in recess. It's 11:27. Hang on. Juror number. Yes, let me address that. Can I have the thing again, please? If you all still have yesterday's sheets from jury selection, Madam Clerk has advised that Jury Services has told us the juror in seat 25 wearing badge 63 called. The nephew that she cares for is ill and that she is not here due to caring for that child. He is not here due to caring for that child. State's response, if any.
For cause.
So stipulated, juror number 25 wearing badge 63 will be struck for cause. We'll advise the Jury Services to call them and tell them they do not need to report. With regard to the Order Tennis motion, as to Ms. Boone's request for snacks, the Order Tennis motion is denied. Ms. Boone is being provided all the same services as to any other inmate being transported for the purposes for trial. Anything else we need to address, State, before we report back to 23 at 1 p.m.? Defense?
No, sir.
All right, we'll see you all at 1 p.m. Thank you very much. Court's off the record.
No snacks for you, Sarah. Oh, my word. That is hilarious. All right, guys, stick with us. We might still have a feed from, I don't know, Law and Crime might stick. Now they might be able to pull the feed too. We'll see. I'm going to support Trial TV Live, though, if we can. Let's see. We'll see what happens. Oh, she's mad. She's not getting her permit. She's not getting her Pop-Tarts. She's not getting her cookies, her candy. Look at her. She's fussing. She is fussing. Get out of the way, Sheriff's Office, please. She's not happy. She's not happy, and we like that. Zephyr, thank you, Mama. Hang on. Let's get her off the screen, and then I'm gonna put up your super chat. So we're definitely going to be back tomorrow. Jeez, for more hearings, not opening statements. That's not sounding very positive, is it? Yeah, I was watching yesterday. That just cracked me up yesterday. She was getting up like she was going to leave with everybody because she felt so a part of the whole process of being part of the defense and everything. And then they all got up to leave, and she wasn't allowed to. She was like, "Oh, I can't go with you." Yeah, we're gonna go have a lunch. Sarah, you stay there. You'll be all right, Sarah. You're in jail. You committed a crime, allegedly. The sad thing is, they talk about her having people to support her. The sad thing is these people that are supporting her have an idea that probably if she was out, she wouldn't have anything to do with these people. And she definitely wouldn't do anything kind for them. Kira, you need to take care of you. Drink more water, hun. Ollie, love you. I know. I love y'all too. Thanks, Zeph. Zeph, you're so sweet. I am. I'm drinking a lot of water. I always have like 5 or 6 of them here at my table, so I don't have to get up and get them. But yeah. So what do y'all want to talk about while we're waiting to see what happens next? What did he say about the time period it would be? Let me go to the live feed. RTL's. What time did he say they were coming back, y'all? I totally lost it. I got excited about the no snack thing. I didn't show that yet. No, I haven't shown it yet. I guess we could do that today. Ozzy. Carrie, go on a break and walk around. 1 p.m. An hour and a half. So an hour and a half from now. It's 12:30 there right now. No, it's 11:30 there right now. Yeah. Let's see. I'll show y'all the feed. Yeah, everybody was asking about her on Nickelodeon when she was younger. It's so silly. It's just so silly. But I'll get it. Hang on.
Warehouse.
Correct.
What is NFI?
NFI is a third-party contracted logistics provider in that
What is
particular
this?
building. They're contracted by Target to process freight for them.
It's a different trial. Oh, there's the Leilani trial. Yeah, we're not going to watch that. Oh, sorry, guys. We're not watching that. I'm learning that a lot of people can't handle the thing with the toddlers, and I don't blame you. I can't either, really. All right, so Trial TV Live has her Nickelodeon thing on here. Let me find it. It's kind of a long one, too. They got the whole thing on here. It's not just a piece of it.
Point that into your sport. Red team 250, you are going into the video zone. Yeah. Come on back.
Oh, it's her.
When you come back,
Definitely
when we
her.
come back, John and Sarah heading into the zone. They're going to try to battle Portia. Hey, she's a hot cookie. She's tough. but I think these two can extinguish a flame. Hey, I'm here with Sarah and John, and they're psyched to go through that door into the video zone to battle Scortia. Now, you have 1 minute to get through all 3 levels. After the first 2, with the time left, you will go and battle Scortia in the wizard level. Now, for each level you get past, you will get a great prize. For each item you pick up, you will get $50. Here is your challenge. All right, into the zone there with you and extinguish Scortia's flames. Go through that door. Yeah. All right, Sarah's on her way. She's flying along. That was a great time. Hey, she's up. Bam, there's 1 ring. She's staying low. All right, bam. Oh, she missed the ring at 40 seconds. She was down to 2 units of power. She got all of her power back now. Great. Bam, there's 2 rings at 32 seconds. Oh, at 28 seconds. All right, bam, 3 rings. They're going to go on and try to battle Scortia now. They're at 22 seconds. Down to 2 units of power, there's 1 orb. They're down to 1 unit of power, there's 2. Bam!
All right, let me show you guys. Oh God, we don't want to watch that again. Let me take that off. We don't want to watch that again. Oh, goodness gracious. Here, let me see if I can get this up on the screen really quick. When they said, no candy for you, no snacks for you. This is, oh, I didn't save it. I thought about the soup Nazi. Do y'all remember the soup Nazi from Seinfeld? No soup for you. No snacks for you, Sarah. Oh, my goodness. Oh, you can't even see it yet. There it is. Okay. Oh. She was Sarah Paulson back then, but it don't have anything to do with the fact that it was her, y'all. Why does everybody always say that? I don't understand that because that's her. Because somebody said, well, no, that's not her because it's her. She had a different last name. I'm like, no. When did they rule on the snacks? Just right before they went into recess. He threw that out there real quick. I noticed Judge Cranick is starting to get he's getting smart on this stuff. He threw it in there right before break. He was like, I'm out. He threw it in the fire and ran. Oh, goodness. All right. So thank you, Renelle. I don't know if an hour and a half is I don't know what y'all want to do for the next hour and a half. I don't know if you want to, I've got that stuff from the battered spouse syndrome that I could play for you guys if you're interested. Or we could just take a break and come back later in the afternoon because I don't know if we're going to get feed or not. We might not get it. Let's watch Harry Potter. I know, I wish we could. I wish we could watch movies together. I think we'd all have a blast doing that. I need to take a break. So what are you saying? What are you trying to say, Anna? All right. Well, we could take a break. Check back in with me, guys. I'm going to stay on this. And if I get jury selection feed, I'll go live. So just be on the lookout for it, okay? I appreciate you so much, everybody. I could leave the live up still. Do you want me to do that? Please play the game show video every day. Why? We could play puzzles and play hide and seek. Anonymous. Anonymous. Do you want to come up? someone going to edit this to George in the suitcase as the bad guy? Oh, yeah. Oh, the defense will have that down. Yeah, most certainly. George is going to be the bad guy. Y'all, I'm telling you, you're going to get mad. You are going to be upset when they start going after George. It's going to happen. So just be prepared for that. Oh, because I won't take it if we, well, I'll be fine. If I pass out, look, if I go mute for a while and you guys don't hear me, then call 911. Laura knows how to find me. She knows my address. Her and Bam are the only ones. But that's the only way you'll know that I'm gone. I worked too hard on this dadgum case. I'm sorry. I'm sticking with this. We didn't get to finish what we were watching yesterday because we were talking about the different battered spouse defense cases. Oh, I know. Jay laying out their case was fabulous. The way he did that, I was like, oh. It's like, this is really not a secret. I just can't wait for her to. Yeah. Okay. So somebody asked me this yesterday. I think it was Ozzy. Somebody asked me, leave up the trial TV feed. I will do that. Somebody asked me yesterday about, do I think that, what was it that they said? Do I think it was Route Irish. When do you think Sarah Boone is going to blow? Or do you think she'll blow during trial? She'll blow up and have a fit. And I said, as soon as prosecution gets her on the stand, they're going to fluster her. She's going to get all upset. I don't know what you want from me. I didn't say that. I never said that. No, I was afraid for my life. Can y'all not just hear it? It was not intentional. You could easily walk away and take a break and leave this up and your chat will keep talking. Oh, that's true. That's true. You guys, we've said all along, y'all don't need me. Y'all just, I could come up here and put in a blank screen and you guys would still be here chatting with each other. We've talked about this before. My little community, y'all are so cute. How y'all take care of each other and y'all love one another. I literally could put up a poltergeist screen. Okay. Y'all are family. Aw, y'all are family. Y'all are so cute. Am I part of the family too, though? Sometimes I feel left out. I'm just saying. I'm just saying. Mr. J is going to tear Sarah apart on the stand. Preach, Larry Powers. I can't wait for it. Okay, let's talk about Cacciatore a little bit here, y'all. I'm kind of worried about him. He hasn't said a whole lot. Hasn't done a whole lot. I don't know how aggressive he is. I'm scared he's going to. Please don't let him be the one that crosses Sarah. Because if it's not going to be as effective, I don't think. I don't know. Maybe they would have him do that because Jay's going to come across as bad cop. Maybe they're going to have Cacciatore cross her as good cop, and then he's going to tick her. I don't know. She has to, doesn't she? Well, she doesn't have to at this point if they don't do the BSS. I think she's going to, though. They want to bring in all that. They're going to have to let her up on the stand. Jury has been there since 10 a.m. Yeah. Oh, this is just day one of them sitting around like this and waiting. Can you imagine? I'd be finding an excuse to get the heck out of there. And I'm worried that a lot of jury members are going to start making up excuses and finding reasons not to come back because they're realizing what's going on with this what trial they're getting. Cass says, I think Owens is furious he is stuck. He thought he could have convinced Sarah to take the fantastic plea deal. Maybe that's what it was. Maybe he swooped in with his little Superman cape and said, you know what? I'm going to get a bunch of publicity right here and right now, And then in the meantime, right before trial, I'm going to have her take a plea deal and then I'm out and I can go back to my regular scheduled programming. And Sarah said, oh, you want to be my lawyer? You're going to lawyer. Let me see your lawyer. What does that pen do? Let me see it. What does that law school education do? What does that law license do? Let's make it work. Oh my God. Can you imagine being YouTube would break me. I don't know if there is I wonder if there is a cutoff on how long you can stream on YouTube. I've obviously never had that issue. I usually would only do like 1 to 2 hours at a time, usually, but I haven't been a big like trial streamer before now. So I don't know. Oh, I'm your little sister. Oh, thank you, Bama. Y'all send prayers up for Bama's sister. She's having a tough time right now. And send prayers up for Lenny, too. Lenny's supposed to be having knee surgery. Ginger Step says maybe Cacciatore is their secret weapon and is as sharp as Jay. Maybe. He's just not, so far, what we've seen from him, he's quiet, right? He comes across as quiet to me. I don't know. But he may, I don't know. It's hard to say at this point. Because I'm thinking back to when Bankowitz was in there and listening to him go back and forth. He never really, I want to say he didn't have a strong presence in court. He was just there, you know. I mean, I'm not saying he's a bad prosecutor. Don't get me wrong. He just doesn't have the snark that Prosecutor Jay has. I can't believe we're not going to start trial in the morning. That is blowing me away. What does the 911 operator have to do with the defense team? Well, the 911 operators are what the state has them ready to be brought in, right? And they had them ready to be brought in late, I guess, because the defense was bringing in witnesses late. The state says, well, you did that. We can do that too. We don't know we don't know who these 911 operators are, like from what 911 call. That's the other thing that confuses me, because they just said earlier that the 911 calls weren't being placed in evidence. So I'm confused by that, but it could be that they're just going to have the 911 call operators testify. I've never seen a 911 operator testify, though, when they didn't play the 911 call. So I'm confused by that. If y'all understand that, let me know what you think. All right, I'm going to go on break here for a moment. And I think what we're going to do is we're going to go pause. I'm going to pause it. I don't really. No, I'll tell you what I'm going to do. I'm going to put up this discussion that we were having. Let me do that for y'all. Because we started this yesterday and we never got to finish it. Do you want to read this?
It
I
was
want
only verbal.
a good starting spot for us on this. Hang on. Yesterday on those documents of the things that they want to bring in. No, it was the one that I was looking at yesterday where they were talking about the different body cams and whatnot. This is the part where I wanted to talk about the different witnesses.
Okay.
These are the officers they're talking about bringing up.
Okay.
So you've got August the 28th. Let's look at B. Officer John Alden. August the 28th. We do not have body cam footage of that. C. Officer Kenneth Davis. September the 4th, 2019. That was the last body cam footage I put up recently. That was the one that I got from, I just recently got from OCSO. And then D, Officer Joseph O'Neill, June the 15th of 2019. We don't have that one. But
So
then
you
they
don't
bring,
you don't have two, but you have one. So you have one of three.
nope. If you go down to E, Officer Patrick Strawn, 6/18/2019, we do have that one. There's 4 of them, and we've got 2, and they've shown 2. There's 4. I say there's 4 of them. There's more than 4. There's 4 of them that were 911 calls that were not related to his death. I guess let's put it that way. We've got 2, and 2 have been redacted. And it's not that I can't get them, you guys. It's that they won't release them. So,
Which I looked it up, and they are allowed to do that. I have it pulled up on one of my computers. The reasoning for redaction.
and I didn't doubt that. I mean, that happens. It's still an open case. They still haven't even gone to court. Shoot, the witness list is being held, you know, they got, it's not a gag order. What do they call it when they won't release the witness
It's
list?
sealed.
It's sealed. Yeah. So why were we talking about that? Why did we bring that up? Oh, we're talking about defense. Seeing her reaction to just seeing how she was, I guess, and how they're going to bring up how, if you look at I think it was June the 15th was, oh, I know what I was going to tell you, Sam. On June the 15th, there were 2 calls.
She made 2 911 calls?
No, it was June the 18th. I'm sorry. June the 18th, there were 2 calls to 911. The first time they came out, George wasn't there. She said it was credit card fraud. The second time, she said it was I forget what she said. I just did a video on this. But there were 2 calls on that one day, and we only have 1 body. So there's 5 body cam things, and we've only got 3. Or 2. We've only got 2.
Interesting.
No, we got 3. What am I talking about? Oh, we do. The one that he's not listing here, and I wanted to ask you about this. I'm confusing everybody. I know that I am because I'm trying to remember this. Okay. The June of 2018, it might be June or July. It was the summer of 2018. There's a body cam call that we have. Okay.
Mm-hmm.
They didn't include that one in this list right here. It's not out of, what do you call it when you can't bring it up anymore?
Oh, it's like it's expired in their system?
No, it's not that it's expired. It's that it's outside of the date that they could talk about it or something, or they can file anything on it, or I don't know.
I didn't know there was such a thing for body cam footage.
I didn't know if that was the case or not, because I'm wondering why he didn't bring that one up, because that is the one. Well, I know why he didn't bring it up. That was the one where he was also arrested, because they were both saying 2 different things. Yeah.
That would probably be it. But also, they don't have to keep records for, it's policy. Like maybe they only keep them per sheriff's office 2 years, and then the next sheriff's office keeps them for 3 years, and there's no law about it. It's just policy.
No, I don't think that's it. I think it has to do with the fact that was the one I have to walk through these to get to where I need to get sometimes. So I apologize. It took me longer to get to my point than I wanted it to, but yeah, that was the one where she was arrested, and they didn't want to bring that one in. But the funny thing is that was the one where when they drove up, she was sitting on the curb, and she actually looked like an abused woman. That was the first time she ever looked like an abused woman. But one of these other ones in the summer of 2019, she comes running out to greet the cops, jumping up and down, going, "Hey!"
Oh my gosh.
So it's like, okay, bring it in, because she doesn't look like a battered spouse.
So then has the defense, if it's okay, so the state would need to either list the officer, probably need to list the officer. We can't see the witness list. And then the defense would file a motion in limine to keep evidence out.
Yeah,
So,
but I guarantee you, But how can you bring these other ones in and not bring this? How can you bring one in and not bring in the other? I guess they have to go through. They have to talk about each one and what it was and
Well,
what was included in each video.
it's state, right? And it's a different officer each time. So they're going to bring every single one of those officers up to the stand. They're going to ask him some questions. They're going to play his body cam. And then the state will ask their questions. And they'll move on to the next one.
Well, no, what I'm saying is how do you, if you're the judge, because the defense is not going to want that one in June.
Right. He has to argue it out. So he has to know that the state's trying to put it in, first of all. And we don't know that yet. I'm guessing that the way we're going to find some stuff out is by the defense's motions. Again, there'll be motions in limine to keep out evidence, witnesses, etc. That's what a motions hearing pretrial is usually for. The motions get filed ahead of time, but it's the state and the defense arguing it out in front of the judge and coming to some kind of agreement on, for example, crime scene photographs, autopsy photographs, different pieces of evidence like that. So it may be that the defense has let it off, and the state's going to try and bring it in.
I feel like if they're going to show these other ones, they got to show that one too. I wanted to ask you guys, was there this deal back? Was that one brought up by them?
It was brought up in one of the motions.
It was. Okay.
Yeah. And if I highlighted it, that would tell you what it was there for. So you don't have to read all the other stuff. Oh, there in purple.
Is it?
Oh, they're citing to Hickson. Sometimes what happens is, like, for example, State v. Hickson, they'll hold something, they'll have a holding in their case, but you actually get a clearer and better explanation of it when another case cites back to it, which is what's happening here. You see what I'm saying?
Yeah.
This is Dooleybeck, and it's citing back to State v. Hickson here. And I just highlighted this because I thought it was, and we've already talked about what Hickson stands for, about the privilege of self-incrimination and the expert. These are what the state or the defense are using to make their arguments.
What about this Medina thing they kept mentioning, though? Did you look at Medina?
Yeah, I think it's there. I think I put it in there.
Let's look at Medina versus the state of Florida versus Medina.
He's appealing his convictions.
Second-degree murder. For his wife.
Excluding defense expert testimony regarding battered spouse syndrome. So that would be the one. When she was shot, omitting video of a pellet boxing and denying pellet's mission. So it'd be number one. So we hold that the trial court properly excluded appellant's proffered expert testimony regarding battered spouse syndrome, as it was not predicated upon facts and evidence, but instead upon hearsay evidence deemed inadmissible by the trial court. They're citing back to Hickson. This is exactly what we've been talking about before. So we should have a very good grip on this particular rule, right?
Okay. Yeah.
About the expert.
Okay. We have Kristen Elizabeth Wagner versus state of Florida. I guess.
So she was convicted of attempted first degree for shooting her husband in the back.
Claimed that the trial court erred in excluding evidence that she suffered from battered spouse syndrome. We affirm, because this evidence was immaterial to appellant's defense, that the shooting was an accident. Oh, this one is actually. On the night of July 26, 2014, appellant and her husband got into an argument that turned violent. Appellant had been drinking. She said she had 2 rum and cokes. Oh my God, I'm having flashbacks. I'm having Sarah Boone flashbacks. He said she had as many as 5, and the husband claimed that she was the aggressor. However, the husband admitted that during the argument, he held appellant down on the bed, pushed her to the floor, and took her cell phone and threw it against the wall. After the husband's son intervened in the argument, the appellant left the house and went across the street to a neighbor's house. When the neighbor did not answer the door, appellant went back to her house and demanded her keys from the husband, who was standing on the front porch about 25 to 30 feet away from appellant. The husband told her to come get the keys, but she pulled a gun. And from her she put from her pants and pointed it at the husband and told him to throw her the keys. The husband underhand tossed the keys towards her, and they landed 3 to 4 feet in front of her. He then turned around and closed the glass door behind him as he went back inside the house. Then, according to her testimony, she bent down to pick up the keys with her left hand, and the gun that she was holding in her right hand accidentally discharged. She could not remember if her finger was on the trigger, but she testified that she absolutely did not intentionally pull the trigger, and she was not aiming at anything when the gun went off. The bullet discharged.
Familiar?
Oh my God, this is crazy. The bullet discharged from the gun went through the glass front door and struck the husband in the lower back. The husband made it to the son's room where he collapsed on the floor, and he told the son to lock the door and call 911. Meanwhile, she got the keys to the car, put the gun in the center console, but she did not immediately leave. Instead, she went back into the house without the gun to look for her glasses, wallet, and phone. When she was able to find these items, she took the husband's phone and wallet from the master bedroom. Then she left the house and drove away in her car. She was apprehended by the police a short time later. The appellant was charged with attempted first-degree murder with a firearm. She filed a notice of intent to rely on BSS evidence under the Florida Rule of Criminal Procedure 3.201 and amended the notice 3 times. Although the court trial found that the third amended notice to be legally sufficient, the court granted the state's motion to strike the precluded appellant from presenting the BSS evidence at trial. The court did not explain its rationale for striking the notice, except to note that this notice contained unspecified defects that could not be cured through further amendment. And I'll let you read your notes.
At trial, appellant's theory of defense was that she brandished the gun in self-defense, but the shooting was an accident. So the jury was instructed on both justifiable use of deadly force and excusable attempted homicide. And during closing argument, defense counsel repeatedly, at least 15 times, described the shooting as an accident. So now we have to see what the court has to say about that.
This is where it tells you what BSS is.
Right. And right here, down below the first purple paragraph where it says BSS is not itself a legal defense, but evidence that the defendant suffers from BSS is admissible in Florida to support a claim of self-defense when the defendant is charged with a crime against her abuser. And it goes back to our favorite case, Hickson.
Wait,
Now,
stop there. I want
yes,
to process what you just read. It doesn't have to be the defendant can suffer from it. I'm confused. Is not a legal defense, but the evidence.
It's not. So, like, you can't look it up and find like that. It's considered to be an affirmative defense. So the burden of proof shifts from the prosecution to the defendant to show that the defendant is suffering from this syndrome. It's called an affirmative defense. It's just a little hiccup in the law.
Gotcha. I love this down here though. What you highlighted this twice.
It must have been important, or I couldn't get it to unclick. A defendant who claims that her injury of another was the result of an accident generally is not entitled to an instruction on self-defense. Thus, the issue in the case is whether evidence of BSS is also admissible where the defendant asserts the defense of accident rather than self-defense. So that's the question. What's our answer?
No, it can't be an accident and self-defense. It's got to be one or the other.
You're right. Very good.
Good God, that case is so close to Sarah's. So what happened?
Right?
What happened in the case? Is it on here?
It'll be at the bottom, whether they remanded or they affirmed the appellate's judgment and sentence. So the person who was appealing, their conviction did not win. Adjudication was upheld. Excuse me. So whatever they found, she's guilty. Yeah.
Can you hear me munching on Reese's Pieces? Do I sound like E.T.? Okay,
No.
good, because I feel like you can hear me.
Mm-mm. I have Reese's sticks, but I'm not eating them right now.
When the verdict was read, the judge had to step in and control the gallery.
Ms. Thompson, having been found not guilty by a jury of your peers, you are free to go. Ladies and gentlemen, this is not, I understand this may be a time to celebrate for you, but please recognize that someone lost their life. Please.
So what tipped the scales in the jury's decision regarding what happened with Marsha and Terry Thompson? I am so pleased to welcome in a very special guest, someone who was inside the courtroom for the entirety of the trial, inside the jury box, as a matter of fact. We're so happy to have with us juror number 5, Gail, on the program this morning. Gail, good morning to you. Thanks for making time for us here on Opening Statements.
Good morning. Nice to meet you.
Oh, thank you. So was this your first time serving as a juror?
This was absolutely my first time.
Oh, and what a case. What a case. This is just one it's tragic all the way around. And in a case like this, as you know, Gail, there are no winners. It's a legal finding. And now Marsha Thompson gets a second chance at life. What was really the biggest thing for you and your fellow jurors that convinced you that she was not guilty?
Well, first, there were lots of different holes in the evidence. There was different experts, and there was just a lot of indifference between some of them. We had a lot of missing pieces, a lot of inconsistencies, and, you know, some of us were right away feeling one way and a few the other way, and it didn't take too much time, but we got it done.
In terms of the defense witnesses, I'm so curious what you all thought of Dr. Michael Brannon, the expert who talked so much about battered person syndrome and really explained it. How convincing was he to all of you?
You know, all of the expert witnesses, I must say, they were extremely bright, educated, knowledgeable. They knew what they were doing. We heard all of them, even though there were inconsistencies on direct and indirect questioning. Michael Brannon, he was really a great guy. We didn't speak to him other than just listening, but he really, really was quite bright and a witness.
Appreciate it, Gail. Gail, I want to ask you about Marsha and Terry Thompson. So let's start first with Marsha. Your thoughts on her and her testimony in particular.
I must say, Marsha lived an unbelievable last, you know, her life was difficult from the onset. What she endured and the day after day of what she didn't know what was going to be behind the corner, the incidents at the golf outing, the incidents that she endured with him at birthday parties and at events, and the phone calls to her family. I am just so glad that we found her not guilty, and she is just going to live her best life now, and we're all so happy for her.
Oh, that's very sweet, Gail. Gail, what were the thoughts, the sentiment from you and your fellow jurors when it comes to Terry Thompson?
You know, I mean, nobody should pass away or die, whether it's cancer or a brain tumor or any other legal way to die. No one deserves to die. We heard so many things about Mr. Thompson. There was so much to absorb, and he just mistreated her, his first wives, his children, and everybody he got into contact with. That's no way to be. He must have lived also a very sad, traumatic time during his lifetime.
It's terrible the way that he treated people that he should have been loving all the time. Gil, I'm curious, was there any feeling bad for Terry Thompson in that jury room?
Mainly, I will be quite honest with you. We talked about Marcia. There was talk about the way, the evidence that we had that he passed away, whether he rolled off the couch, how he got off the couch, was he reaching for her, what was going on in her mind during that time. Not anything about him as a person or emotions towards him. We had we were appointed with a job to do, and we did what we felt with the evidence provided, what we needed to do.
Gil, tell me, if Marcia Thompson hadn't testified, would you all have arrived at the same verdict?
Absolutely.
So did you expect
Absolutely.
to hear from her?
Wow.
Or was that kind of just icing on the cake?
You know, we didn't know from morning to afternoon what we were going to endure. We walked in one morning and she was sitting on the stand. So obviously we knew. I'm glad she testified. I'm glad that she told everybody exactly what happened to her and what she experienced, and you know, that poor, terrible thing. She just didn't know what was coming at her from moment to moment or hour to hour.
Gail, I have to say, what a tremendous job you and your fellow jurors did in listening in on all of the evidence.
You know, looking at Marcia, she cried a lot during the pieces that I saw of the trial that they showed. And you think we're going to get any tears out of Sarah? Only when it's on cue.
I don't see how they are going to want to put Sarah on the stand. I just feel like she's uncontrollable, and that's why she lost so many lawyers. And she'll get up there, and instead of doing what she's supposed to do, she'll do what she wants to do.
I was going to say, but if she wants to get up there, her lawyer can't tell her she can't.
Correct. Can advise against it, but you can't. No, it's ultimately the defendant's choice whether to testify or not. And you hear the judge go through that colloquy every time. Like, have you discussed it? Is anybody pressuring you? All those things.
I just feel like it's just in some cases where you see a defense attorney work their butt off, and then you get a defendant that just wants to just have the last word, and you're like, you idiot, you just undid everything that I did for you.
Listen.
Yeah, right?
I had to have a conversation with one of mine at the jail earlier this week because I'm like, are you trying to talk yourself into a prison sentence? Because why'd you say that? Oh my God. I was so mad.
For murderer trial, Marcia Thompson is the defendant. She is claiming battered spouse syndrome in the shooting death of her husband, Terry. But the prosecution says that she shot him in a murderous state, that she wanted him dead, and that he was not a threat at the time. Right now, the jury is not present inside of the courtroom. We are listening to a proffer of testimony from Terry Thompson's ex-girlfriend, Teresa Benton. This is a proffer just for preserving the record. So she's not going to be testifying in front of the jury. The judge has denied her ability to testify, but the defense wants it on the record, likely for purposes of appeal if they need it. Let's go in.
Ms. Benton, how are you?
As good as can be expected. Thank you.
Okay. Ms. Benton, I'm going to ask you some questions, but there's a limited amount of questions that I'm going to ask you here. And they're going to be fairly specific. Okay, Ms. Benton?
Yes, ma'am.
Okay. Ms. Benton, do you know Terry Thompson?
I do.
How do you know him?
We were in a relationship. I knew him from 2005 until 2014.
Okay. And during that relationship, was the relationship abusive?
Extremely so, yes, ma'am.
Okay. Was Terry Thompson abusing you?
Yes, he was.
At some point, did you file for a restraining order against Terry Thompson?
After much effort, yes, I did.
Did he threaten to kill you?
Yes, he did. Multiple times.
Did he? No, it's okay. I'm sorry. Did he threaten you with a machete?
Multiple. There were 2 in the home.
And had he actually threatened you with a machete or to kill you with a machete?
Yes, he did.
Was Terry Thompson sexually abusing you?
I'm sorry. Yes, he was.
Was part of that sexual abuse to force objects into you against your will?
Yes.
I'm sorry. Was there a time when you were involved with and aware that an email was being sent to Terry Thompson's ladies?
My sister sent that email, yes.
Was that from Terry Thompson's, out of his account, like looking like it was actually coming from Terry Thompson?
Yes.
Okay. Did it discuss his abuse of you? Beatings in particular?
Yes. Many other things. It was a long message.
Okay. Some of those things were cheating.
Yes.
Okay. Did it also talk about him giving you a sexually transmitted disease?
Yes.
And did he give you a sexually transmitted disease?
Trichomoniasis, yes.
Did it also include graphic pictures of the different women?
So many, yes.
Is taking graphic pictures or videos something that you were subjected to?
Yes.
Is that something you wanted to do or something you were forced to do?
There were times when I wasn't even aware the pictures were being taken.
Were there times where you were forced?
Yes.
Was there another occasion where you called Marsha Thompson?
Yes.
Okay. And did you reach her? Did she say hello?
No.
Did you reach a voicemail?
Yes.
Okay. And did you talk onto the voicemail and allow the voicemail to hear what was going on?
It was the only way I could get him to leave, yes.
Okay. And was there, during that voicemail, was there an audible scuffle and fight going on between you and Terry Thompson?
He was coming at me, yes. It was the last time I saw him, yes.
Okay. And during this encounter, how were you able to fend him off?
I grabbed the only knife that was left in my home.
And what did you do?
I pointed it at him. I lived at 2020 Burnside Drive, and the kitchen was shaped like an L, and I was in the corner, and he was packing to leave for his usual Thanksgiving. It was November timeframe, and he was already packing. I had just found the picture of Marsha, Lomi, the new baby. I'm sorry, I don't know his name, the boy, and Marsha had written, or I'm sorry, I don't know.
Could you just tell me what happened, Ms. Bennett?
Okay, so we had gotten into an argument, and I was telling him that since he was leaving for Thanksgiving anyway, he needed to go ahead and pack all of his things because he was clearly lying about the marriage that he'd been lying about for all these years.
What happened when you got the knife?
He was coming down the stairs, and I already had the call, and I started like kind of pointing it at him. I know that.
So you had Marsha Thompson on the phone, Marsha Thompson's voicemail on the phone with you?
Yes.
Okay. And you're speaking to her and holding out the knife at the same time?
Yes. And he wasn't really kind of responding. But when I flipped the phone around and showed the number, that is the only time that he actually like showed that he was going to back up. Like he wasn't, he didn't care. He wasn't scared. But when he saw that I had actually, or that is my perception, is that when he saw that I had actually dialed a real number that was her, it was my impression that he thought that I might actually have reached her. Because I didn't pretend like I was leaving a message. It was one of these, hello, Marsha. So this address, 2020 Burnside Drive, is where I live.
I understand. One moment, please.
Sorry.
That's why this is a proffer. The state somehow managed to keep it out. And I had this happen to me in a trial, and my defendant was found guilty of 2 counts of first-degree murder. The issue was preserved. This proffer like this was preserved for appeal. The case was overturned on appeal, got it back, retried it, and got a not guilty verdict, and got our witness in.
I mean, this just
the judge kept our witness out.
This is huge because this is another person saying, yeah, he did the same thing to me. I mean, that is huge in this case. And then you have, I mean, if you want to say the woman was, I guess they're not saying that she wasn't abused. The prosecutor's not saying she wasn't abused. It's just that when she killed him, he wasn't abusing her at the time. That's what it sounds like.
That's exactly what they are saying. That's exactly what they are saying. That because she wasn't in the middle of an actual physical fight, she shouldn't have shot him. That's the whole. That's why we've been talking about all these different pieces. Imminent danger. What is your perception of imminent danger if you're a battered spouse?
No, but I mean, if the prosecution had gone at this in a different angle, could they have gotten a guilty verdict on this woman?
Well, like I said, it's not how the prosecution did what the prosecution does. They charged her with first-degree murder. It's the affirmative defense that saved her.
Okay.
So it's the defense. It's the defense putting up basically a I hate to use the word justifiable because that could open a can of worms, but justifiable is the easiest way to explain it.
Yeah. Okay. Well, in this case, we're I don't think anybody's gonna have a problem with you saying justifiable.
Oh, it comes up in the law.
Oh. Okay, so we're just 6 minutes into a 15-minute thing here.
Okay.
Y'all, it gets rough. It gets rougher. So be prepared.
Okay.
Was Terry Thompson doing anything to affect your work or your employment at that time?
Yes.
Were you in the military?
Yes.
And what was he doing specifically? Briefly tell me what he would do.
He would call work. He would come up to work. He made it impossible to sleep. He would keep me awake. At this time, he was already retired. He would.
Were you financially supporting him?
Yes.
Go on.
My sister had access to my bank account, and she was concerned because I had given him $40,000 cash over the course of 20 months, and she showed that to me. I had bought a car and a truck that he had given to his sister and his dad. I have an email where I can show that I was paying his student loan. I was sending money for him to pay for Lomi's daycare.
Is Lomi Naomi?
Yes.
Okay, Ms. Benton, thank you so much. I appreciate it. Let me ask if the state has any questions, okay?
Okay, yes.
Okay, nothing further, Your Honor.
And you're free to step down and leave. Thank you.
Thank you,
My
Your
bad.
Honor.
She already went through the
What are the
tough
issues
stuff.
that we need to address?
So they already went through that tough part.
Unbelievable, isn't it?
Yeah, but I think that's so huge. And you look at this as that another difference that I was thinking about while that was playing between Marsha and Sarah is that you're looking at Marsha she probably has no police record of ever being arrested. Let me say it that way. She had a wonderful job. She made obviously good money. And this guy didn't work. Now they did say he was retired military though. That was the one thing. So they could have made it look
They
really
think
good.
wrote down in that trial document notes that's gotten really long, or that trial notes document, whatever, that I've been writing on, is that he would not let her go to the doctor, which equals no medical records.
Oh, shoot.
So until she had no choice but to get this spinal fusion surgery because she would lose her income, she couldn't work anymore from being thrown into. So if that document is back in Dropbox and you just scroll down and see all the notes that I took during her testimony, but that stood out to me because, the police will say, well, where are the medical records? Well, if you're not allowed to go to the doctor, how do you have any medical records?
Exactly. Okay, I'm back. How are we doing in the chat? Did you guys like that? that was a good discussion that Sam and I had. I don't think we had all of that in the different portions that we showed in the Marsha Thompson versus Sarah Boone video because we had recorded a lot that day. So not everything that we just watched was in that last video that we did. I'm freezing. It's still 46 degrees here, and I wasn't prepared for it to be cold. I'm going to look for, I've got, in about 20 minutes, there's going to be a jury selection. I mean, they're going to do jury selection coverage, I believe. And until then, I'll be back. But I did make y'all something really quick. So y'all would be happy that I put these up for you guys. And I'm trying to get the emojis set up for, they're really super hard to see though. They're so tiny. So I don't even know if you're going to be able to see them. I just added an emoji for Henderson. Oh, Sam's here.
Hey. Hi, Carrie. How are you doing?
I'm good. How are you doing?
I'm fine. I'm trying to figure out where my phone is so I can shut it off or make it quiet. Hi, chat. How are you guys? Everybody enjoying jury selection?
That the court audio can't hear it at all.
Hold on.
What is that? Oh, is that you?
Yeah.
Oh, I thought that was me.
No,
Okay.
I found my phone. Sorry. In trying to silence it. I did not. All right. Hopefully that's it.
All right.
Hey guys.
Look,
Hi.
legal Q&A with Sam is now here. If you guys would like to
Oh God.
ask her anything. Have you been watching, Sam, since you've been gone?
Okay, so I have been watching, but this morning I was at the doctor's office, so I can't speak to the arguments unless I watch them back.
Oh my gosh, it was confusing this morning.
It was confusing, and that's why I say, like, I'm not even gonna try to wing it. I can try. Hi guys, it's so nice to see everybody. I'm not gonna try to summarize it for you right now because I'm afraid I'd do a terrible job because I was like, I didn't have headphones, so I was holding the phone up to my ear in the waiting room trying to listen.
I don't even think the defense and the prosecution understands it right now.
Yeah, it does. It does seem like that's a little confusing, and it did not help that Mr. Owens did not seem to be able to speak into a microphone.
Oh my God.
So,
yeah.
Hi guys. Hi. Oh, you guys
They
are
need
so sweet. Hi.
They need to remedy that with that microphone.
I know.
But I don't think they're going to be. Hopefully they're not going to be doing a whole lot of talking from that table. They'll have to go to the podium once that the jury gets in there, right? Hoping.
Yeah. Well, I think so. Yes. But remember, Owen says that he likes to walk around. That's concerning. Do you remember when he asked for like a mobile mic?
Yes, good Lord.
So
yeah, but he can't even make sure that he's being heard out of the mic he's been given.
I know.
So
I know.
Did you see the the debacle about the snacks? I did make something for that, by the way, you guys. I don't mean to cover you up, Sam.
You're fine. I'm just looking at the chat. Hi guys. Hi everyone. Hi.
I want to move us to where we're over here on this side. How do I do that? Hang on. I gotta move Sam.
No snacks for you. Oh, because you were just doing the no soup for you. I don't hear any buzzsaws or anything. Oh, chat wants to send us snacks, so we need PO boxes.
Oh my word! I don't even have one, to be honest with you.
I tried to go to Chick-fil-A the other night and it wasn't open yet from the storm. I had to go to McDonald's. I was offended.
Yeah, I don't think you could definitely get a McNugget that's going to replace a Chick-fil-A nugget. There ain't no way.
I got some kind of hamburger thing. I didn't care. I was so tired of eating dry, non-perishable foods and tuna fish. Did you just ask me a question? I already forgot what it was.
I did too. I forgot to. Hang on. I was trying to pull up. Let me pull up this feed that I've got here from Trial TV Live. And then I'm going to make sure that we have that in the background.
Okay.
There we go. Yeah, there we go. That's better. So yesterday, in case you guys, and if y'all didn't know, I sent a really nice 20 coffee thank you over to Trial TV Live to thank them for their efforts yesterday in getting us that coverage, because that was so cool that we were able to see that, because that wasn't on Law and Crime. That wasn't anywhere else.
No, that was amazing that they were able to do that. That was amazing. I was so excited actually to hear that. And I was watching everybody in chat and listening to it, and I was really intrigued by it.
What do you Okay, so here's my question about some of the stuff that was asked yesterday. Why did he go there with the whole watching the news versus what they want to hear versus what they
Okay, so no politics, right? But that was politics.
Okay. Yeah.
Like I'm not here to debate anyone. Obviously, this is a no.
It was
politics
what Why did he bring up
panel.
politics? What does politics have to do with this case? It doesn't.
Okay, so how do I word this so it's okay to say?
Yeah, because you're going to open up a can of worms.
I know, and I don't want to. So remember back like 10, 15 years ago when we had like 3 network news channels and maybe CNN?
Yeah.
And so everybody sort of trusted that was the news.
Mm-hmm.
You didn't have other options to go other places to get your information. And today we do.
Exactly.
So the question was, if you boiled it down, it's what source do you go to, or do you believe what's being told to you? Is the best way I know how to phrase this. I know I'm being careful. I'm trying to be super careful, guys.
No.
I'm trying to be super careful.
Do you go where you want to hear what you want to hear, or do you go to find the answers?
Well, that's how he phrased it, right?
Yeah.
Yeah, I didn't say that. But yeah, I mean, because in our world today, people do seek out what they want to hear. They have the option to do that now. We didn't used to have that.
Yeah.
So that's the most delicate way I can skate around it, I think.
Yeah. Okay. So did you watch yesterday, or you were? I know you worked a lot, so were you able to
No, I
get
had it
by
on.
stuff?
I had it on, and I was really interested. I was so thrilled you got sound yesterday. Yeah, I was really interested, and I had an eye on the chat too, trying to see how you guys were taking the questions.
Well, first of all, the sound in the courtroom was better yesterday than it is today. But I think it's because they moved the microphone around over on the defense side. But I think that the audio has been much better than it was in the past. So far, so good. And I don't know. I would think that today, going into jury selection, it's going to be the exact same setup where we're staring at Sarah Boone the whole time, listening to the questions. But now they're going to be coming from the defense side.
Well, hey, listen, y'all wanted to see her face.
Right.
Got what you asked for.
Ugh.
You really did. April 9th. This is a really good way of phrasing it that my brain did not see. April says, I think he wanted to see if people could listen to both sides of the argument and be impartial. That's a much better way of stating it than I just said it. Thank you,
Yeah.
April.
Let me put up, I totally missed this. Why are you eating Reese's and Sarah can't get a single cookie?
You left that in.
Because I did not hurt anyone. I did not zip anyone in a suitcase. Thank you. Oh, how do I say your name? Talancer? Did I say that right? Thank you for your super chat, and that was funny, and I like it. I like it. I like your snark. I love it. Oh, you gave me another one too. Oh, she's gonna cry like Amber Heard. You mean the no tear cry?
The no tear cry?
Yeah.
Mm.
Yeah. Exactly. So what you have a question from Ozzy you want to talk about?
Oh, Ozzy asked me a complicated question, didn't he? Ozzy says, Sam, if Sarah's testimony and cross do not prove an overt act by George, will she still be allowed to use battered spouse syndrome, or can the state file another motion to stop that after her testimony? So that's what they're arguing about, right? If she does not, if she cannot show this overt act, then no, it doesn't come in. And the mechanism, Ozzy, I don't know if it would be an oral motion or a written one, but it's already being talked about. That's what they were discussing. Was it today or yesterday?
They started yesterday, but they finished. They were supposed to finish it this morning, but they left it open.
Yeah, so the judge is really, really walking a thin line, and I see a lot of you guys being super frustrated. Yes, I have words. I understand your frustration because you have an extreme dislike for Sarah, and I'm not a fan of Sarah's, so I'm just gonna put that in there. But it is a process, and what he is trying to do is keep this case from turning over on appeal.
Yep.
And so what I appreciate about this judge that I've not seen in some of the other cases, or some of even my cases, is the amount of research this man does.
Yeah.
Is amazing.
He is totally prepared.
He really is, and it shows how the defense is not. Ozzy, I'm glad that helped you. I'm so glad.
I don't know. You said you were at the doctor this morning, but they pulled it again, Sam. They pulled that. Well, we just wanted to get this in there. They threw more paperwork at the. Let me tell you what they did this morning. So, of the 550 pages of the medical records they had for George, the judge had said yesterday, look, 487 pages, that's not irrelevant. I mean, it is irrelevant. It doesn't have anything to do.
Okay, I was listening to that. Sure. What's the question?
They were basically like, that's the part, right? Okay. So then this morning they came in with Sarah's medical record, and I guess they're trying to say today the prosecution brought up, well, you were supposed to go back, defense, you were supposed to go back and whittle down all of those 550 pages, what you wanted to whittle down for us to look at, and you haven't done that yet. And then once again, they threw in 119 JPEG
instead of one big PDF. I did hear that. Yeah.
Yes. I'm like, you're kidding me. That is horrible.
I'm unimpressed, and the reason why is because even when it's just been me working in a different capacity than I do now and a single attorney, we would never have. I mean, they've got four or five people there, right? We've got the new lawyer, we've got the assistant consultant person, and then we have 3 lawyers. The fact that they can't do that is unbelievable. Carrie, Laura put this question up, which is why I put it up.
Oh, did I miss something? Okay.
I put it up. There you go. Yeah.
Okay.
So Buzzman Jr., who's a new member, thank you for becoming a member. Is there any way we start opening statements today? And what do you think about Brian Boone being biased? Okay, I doubt you're going to get opening statements today. I know you want them. It's already almost 1 o'clock here on the East Coast. I am in Florida. And Brian Boone, they've put him on the witness list for both sides. I don't think it's going to turn out well for Sarah. I think he is going to, I don't think he has any reason whatsoever to lie or exaggerate, or I think he can just get up there and tell the truth, and that's enough. You know what I mean?
Let me tell you what they said about it this morning, Sam, and you might have missed this part. So the state came in and said that they wanted the relevance for why James Owens wants to bring in the family law case for Sarah, because they're trying to say that he's going to be a hostile witness because he definitely wants to bring in their family legal battles. That Brian currently owes Sarah alimony, past due alimony that he has not been paying her. And the defense is saying that he's going to be biased because he owes her money. So they had a sidebar about it. And then after they came back from the sidebar, the judge overruled the state's request to throw that out. So they are going to bring in the family court stuff on Brian. So that's why they're asking you that question about him being biased.
Well, I mean, I think no matter what, I don't think Brian has anything positive to say for the defense. You know, I mean, they might ask a question that they get a yes answer to, but I don't think it's going to advance their case any. And is he biased? Yeah, he's probably is anti-Sarah. I mean,
well, do you think they're calling him just to like get ahead of the game? Okay, first of all, the prosecution's going to call him up, so he's going to go up there before the defense calls him. So
that's right.
I'm confused about why they need to. I guess they have to recall him on their side, but
yeah,
it just seems to me like if they're going to tear Brian down, they'll do it when they cross him.
Okay, so they can only ask questions within the scope of the original questioning. So on cross, you can't go beyond the parameters of what's been asked. You guys all know the expression opening the door.
Yeah.
If the state makes a misstep and opens the door into something that the defense really wanted to talk about, then the defense can go there. So direct examination it's really key to be very careful that you don't get out of bounds, so to speak, right? Think of it as like a box. You want to remain inside your box and not go outside. And then when the defense comes in to question your witness, they have to stick to what's inside the box. They can't bring anything from the outside in.
That makes sense. So that's why they want to be able to call him back up, and then
so he's under. Yeah, and then when they do that, right, when the defense calls him up, they can ask him on direct whatever they want, and then the same rules apply to cross for the state.
Okay.
Oh, Michelle says, this is P.I. Sam, the best private investigator chat extraordinary. You guys know I love you.
I was looking to see if Law and Crime was going to give any feed on the jury selection today. I don't know if they will or not, but we do know that.
Are you on Trial TV? Because it looks like somebody is. Okay.
Trial TV Live has been giving us.
They gave you great feed yesterday.
Yes, they have been awesome. You guys, please make sure y'all go over and subscribe to them. They bypassed 3,000 subs yesterday.
Oh, that's awesome.
So we need to get them. You know, I was telling her in my memo to her when I did the tip, I was like, you guys need to be supported by all the streamers so that you guys can be a second source for us for this trial stuff. So it's going to be interesting how this, I think that channel could totally blow up.
Oh, I think so too. Well, I believe that the Court TV YouTube channel runs ads. Law and Crime does not, to my knowledge. I may be wrong. I'm not a streamer. I just watch a lot. So, but her feed from yesterday was really good and did a really good job of remaining super tight so as not to accidentally catch anybody out, because for a fact the judge would have, would then say absolutely no cameras.
I don't know his background as
military.
Being a cameraman. Is he military?
Oh no, I thought you meant the judge. So I'm sorry.
Yeah, I don't know what. I have a feeling he's a cameraman for somebody or was at some point in time.
Maybe.
Because he seems to really know what he's doing. He's got a lot of expensive equipment. So he's not. I was worried. I was like, is it gonna be bad? But it wasn't at all. It was really good.
Really
it was
good.
really very professionally done.
Very good.
But yeah, she said that yesterday she felt like there was a little bit of animosity. And yesterday when the jury selection ended, it looked like Sarah and Owens were kind of going at it a little bit again.
Okay, so I asked someone about that and I got the response of Sarah was being her normally bossy self.
Yeah. I kind of figured. I bet she goes back. I bet she has like
notes. So many notes.
Oh, well, yeah. But I bet I bet she just throws like jabs at him and fusses at him, and then the next minute she turns around and goes, so how was your day? You know, like she's totally like two different people. She
Mhm.
might have split personalities. I don't know. But she does act like that, you know, like she can just be da 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 da, and then turn around and be like, oh da da da. I don't know. It's weird. But
Yeah,
Sarah will have
I think that's probably true that she goes from irritated to nice pretty fast. If she was mostly nice when I was with her. I don't remember her being. That was way back though, before all the lawyers came through. So she didn't have so many reasons to be snippy.
Thank you,
back
April
then.
Knight, for your super chat. That's so nice of you.
Thank you, April.
Somehow or another, it's come to the chat is talking about Cyndi Lauper being on tour. Okay.
Oh, this is our Gen X chat. You know we love that.
Well, tell me what your message is, and I'll put it up. I'll watch for it, April. I know when people I've done that before.
Patty. Hi, Miss Patty. There is no jury yet. They're working on it.
Oh, Patty, you had a doctor's appointment or something, didn't you, this morning? Yeah. Oh, girl. It's just we're not any closer to where we thought we were going to be today. But I had said yesterday, I'm like, I really don't want to start opening statements on Thursday afternoon. I'd rather start them Friday morning.
Yeah, I
But
think everybody feels that way.
But what are we going to do? I guess they're going to go and have these hearings in the morning. And then, so by what, maybe 10 o'clock, 11 o'clock, they're going to end up having opening statements. They'll bring the jury in. And
that could be.
It could happen.
Sinez, I can't. Okay, you've got a rainbow as the second word of your name. And you said, I miss XXX. If you're talking about the rapper, I worked on that case too. And that was really freaking sad. He was like 20 years old, was shot and killed in his car. Is there any sound? No. Carrie's got it pulled up. So I think if there was, she would know.
We're waiting for them to go live. Now, let me tell you. Let me tell you what. They had said 11:45 a.m., right? But then the judge says they're not coming back from lunch until 1. So
right. You shouldn't be hearing anything until 1. This judge goes on the record exactly, usually on time, unless somebody else is holding him up.
So that's another 15 minutes away. So we might still have some time to sit here and chit chat back and forth and stuff. What's the channel? Okay, let me put the link in so you guys can go over.
Okay, did you see what Ozzy said right here? I just popped it up real quick. That we're represented well by Cyndi Lauper. Girls just want to have fun.
Oh, gotcha.
Because, you know, we do that.
Trial TV Live. That's their link. I just put it in the chat for you guys. So you can go over there and give them a sub. Judy says, SB argues with the jail staff about clothes, makeup, shoes, and snacks. When they tell her no, then she gets Owens to make a motion. She has weaponized the judge, just like she did the police. I think the judge is over it, though. He's like, you're in my courtroom now, and we're not going to do that. I'm in control. Have you noticed? I was like this morning when Jay kind of went back to the judge, he was I thought he was a little snippety with the judge when he said, no, that's not acceptable. When they were talking about the motions being on the record, yesterday's discussion and what was the motions that were decided upon.
They wanted the minutes, right? And they hadn't been described yet. Transcribed. Is that right?
Yeah.
They wanted the court minutes from the transcript, basically.
Yeah. And I was like, oh my God. Like, I was surprised. April Knight says, I was going to say, I saw Owens put a sticky note on the table. Sarah grabbed it and went to write on it. Owens attempted to take it back and Sarah snapped at him.
Well, we do write. I've seen a lot in the chat. Is it okay if I just talk about a couple things I've seen in the chat?
Oh, yeah. Go ahead.
Okay, so I have seen you guys talk a lot about like Sarah writing and trying to, you know, she's fidgety and whatnot. So we do give our defendants notes. We give them the big jury. We have them participate in jury selection. In my cases with my attorneys, we treat our defendants as if they're part of the team because they are a part of the team. So yeah, Sarah's writing is a little excessive, and yeah, she is, shuffling a lot of papers, stuff like that. But she's entitled to do that. And it's nerve-wracking to sit in there, even if you're not the one on trial. And I know we don't like her, and I'm not pro Sarah. I have to keep saying this, but I'm also here to show you guys the other side because I work for the other side, right?
So that's a
So
good point, though. It's a good point.
and well, I'm sure Sarah is being bossy and doing, I'm sure whatever, right? Yeah, nervousness. She could be like me and Carrie and have some ADHD in her. But yeah, we provide our defendants with pen and paper and court documents and transcripts, anything they have not yet seen in discovery. And then I wanted to tell you guys yesterday, you were like, what is she looking at? She was looking at juror questionnaires and making notes on them. And that's what that I sent. So guys, I sent Carrie badly. I sent her an example of the jury chart and a jury questionnaire. The only problem is, yeah, I used it in it's got people's real name and information on it. So, but to give you an idea, it's super blurry on the screen. She did that to redact out people's information. So, that would be row by row in the gallery. And then the questionnaires match like the first few little boxes on there about, have you been a victim of a crime? Have you been on a jury? Have you been convicted of a crime? What do you do for, just different basic things like that. So they give us this sheet, and I saw it yesterday in court. And then they hand out the jury questionnaires to us, both sides, both the defense and the prosecution. And we give our defendant participation in this. Like at my most recent trial, I keep talking about it because it was the most recent one. I had two attorneys, the defendant and me, and we all went through all of it.
Yeah, I think that was interesting to look at that sheet because I'd never seen something like that before. But I guess I envisioned that in my head.
You had or had not?
I had something similar to that.
Something like that. Yeah, they have to. Yeah.
I didn't realize they both had the same paper to work off of, though, I guess. I thought they did their own thing with it.
Well, you do your own thing. I mean, so each side, I guess, am I not explaining it well?
No, you did. I had not realized that before you said that.
So, for example, the folder that I grabbed was because somebody left it on the table, and I was like, I'm not leaving this here. But these are jury questionnaires that I read, like I'm looking at it right now. And then the big chart that I gave you, this is my chart. So this is the one I was filling in. And then everybody else had their own chart. And the red X's are actually the people that got struck. So they were gone. And the highlighter ones were ones that I thought had issues, or, I made a lot of notes on here about different things.
Oh, Sam.
Okay. Yes.
I don't know what you just I think something's hitting your microphone.
I'm sorry. That was the papers. I'm new, but Sam sounds pro Sarah, and she's a lawyer. I'm so confused. Private investigators don't sit there and go to trial in the defense team.
Okay. Educator. She's new.
Okay. No problem. So I am a private investigator licensed in the state of Florida. I also, I am a criminal defense investigator in the state of Florida, and I work on court-appointed indigent cases like Sarah's. I am not pro Sarah. This is Carrie's channel. I come on here as a guest to sort of give some insider knowledge as to the processes of the JAC, what's happening in trial and not. And I do go to trial every single day on the defense team. And Billy Lane, who is the private investigator on Sarah's case, he is in the courtroom today. You can see him on TV cameras. The chat all knows him. So, yeah, that's kind of why I'm here, is to dispel some myths. And there is a video curated where she interviewed me and I explained what I do for a living, how it works, the process.
There's a video on us discussing the JAC process and everything, and in that was our introduction to Sam on the channel. Cookie wants to know what you think about the outcome.
Oh, hi Cookie, how are you? What do I think do I see any? The defense won some. They made some ground yesterday. They gained a little bit of ground yesterday. I mean, I think that the state has thought all along, as we all have, that this is not, no pun intended, an open shut case. But they did win a little bit. It's going to be interesting. I think it's going to be more interesting. And I'll tell you, Cookie, what one of my attorneys always says: I've lost trials I should have won, and I've won trials I should have lost. Because you never know what the jury's going to do.
Yeah, every trial is based upon the juror's individual thought process, and that's scary. That is scary.
Well, that's why but that's why they're going so deep on these questions.
Mm-hmm.
You know what I mean?
This is more important than people realize, I think, because we never get to see it.
Right.
So we don't find it to be important.
Right. Exactly. Yeah. I'm just looking at the chat to see if anybody else has questions.
Tracy was asking, do you think male or female jurors would be better?
So I think female, and I think it needs to skew somewhat younger. I think a younger generation, like Carrie and me and a lot of the chat, we're Gen X, which puts us somewhere around 50-ish. I think women, us and older, would probably not be very good for Sarah. I think the younger generations, like millennials and downward, and we do get 18-year-olds on juries. I just got a text notification. Sorry, that is from Investigator Billy Lane, who says they're about to start again.
All right, cool.
And I'll try to turn off my notifications in my computer. That's how I muted myself the other day. What did Sam think of Billy's reaction to? I didn't see Billy's reaction. I'll have to go back and watch it. I've been texting with him though.
You didn't see my little short I did on that?
No.
I highlighted.
No.
I zoomed in and highlighted on Billy. He's sitting there shaking his head, rubbing his head. He's rubbing his head on that one.
Oh my gosh, yeah. Poor Billy.
Mark has a question.
Yes, I will investigate why you get put in timeout so often, Mark. I will do that for you. But you're going to pay a heightened rate.
Hey, Mo from the UK. Welcome in. Sam, here's another one from Route Iris. Is it standard for a defendant to go into their upbringing? Oh. Mm-hmm.
Well,
I think it is, but
it depends. Well, it depends a lot on whether psychology is being brought into, if that is sort of an element of a defense. And in this case, they're trying to make it not just oh my God, the word just self-defense, but battered spouse syndrome. So some sort of element of psychology obviously has come into play. Normally, like in a criminal case, for the guilt part, like I've got one right now that we had the trial, he was found guilty, but he's super, super, super young. So now we get a chance to do that, to go into his upbringing and present that to the judge. That's called mitigation, because she has some leeway in how he's sentenced.
Okay. All right. So Lisa says, battered spouse is not an affirmative defense nor a legal defense. It's basically diagnosis evidence that can be admitted to support self-defense. It's to explain the type of self-defense. Okay, I think I agree with you there.
Well, in the state of Florida, it is an affirmative defense.
It's affirmative?
Yes. Because now it's up to, normally the defense does not have to do anything at all, right? They just have to poke holes in the state's case. In this situation, they have to prove. That's why they need the overt act. They have to show that that was, you can't go to the, I think I said this in the video you were running, you can't go to the statutes and find battered spouse syndrome. It's not there. So it's like a tag on.
Mm-hmm. Yes, Gigi, we're waiting on the feed from the courtroom. They're supposed to be back from lunch any minute now. And we are hoping that Trial TV Live will again have the feed. We'll know here in a minute.
Oh, I know what I wanted to say to you guys. The state has to prove it's not self-defense, not battered spouse. Right. It's a complex argument, Lisa. I know what I wanted to say to you guys was, I told you the other day last week that Vordara was like confessional. People will get up and talk about stuff that happened 40 years ago to their uncles, sisters, brothers, cousins, and it's like it spills out of them, and it's just fascinating.
And it's sometimes it's more than you need. It's like it's TMI.
Yeah, sometimes it is. Cookie, how much of what Kranek is giving the defense is damage control, appeal grounds, and such? I think, like I said, I think he's trying to be super, super careful and walking a very well-researched line, because he does not want this. No judge wants any case to come back on appeal, but he for sure does not want this one coming back on appeal. And I think that's why he is so prepared. And I think he's being maybe a little overly reasonable to the defense. Like, he's given a little bit more than anybody else would. But I think the circumstances warrant it. And the decisions that are being made right now, they are not necessarily like, oh, Sarah's going to get convicted because of this or not get convicted because of that.
Yeah. Sam, do you think Margaret will get fired?
Yes.
Ginger Snap wants to know. No,
Well,
Margaret will get a raise. Margaret will probably
Margaret
get
might get a raise.
flowers.
That's true. That's true.
Margaret is probably used to getting thrown under the bus all the time. And then he'll come back with a box of chocolates. Talk about an abusive relationship. My God.
I know. No, you're right. I think she'll be there till the end. Margaret will be.
Scissor Man, no, they didn't. Yesterday was the first day that we were able to get some feed from the jury selection. And that's because Trial TV Live has been over there, and they're sitting in the juror box over listening in and playing, showing us feed from there. Yesterday, if you go to my live from yesterday, you'll see where that's when we first started being able to see it. And then hopefully today we will be too.
Can you refresh your stream, Carrie?
Yeah, I just did, and it's not coming up yet.
Okay.
And their feed says that
Chat
they were going to
goes
start at
crazy.
11:45.
Chat goes crazy, so just checking.
Oh, yeah. Thank you for the update. We adore Dwayne. Judge, can you hear me? I'm looking at their chat to see what it's saying.
There's
Okay,
a
thank you for the
question.
update, Sharon. Please give it
Who
more
do you think
love.
will be questioning the potential jurors? Owens, Henderson, or maybe Beck? Yeah, have we heard Beck speak yet? I'm guessing it'll be Owens, but he may throw it over to Henderson. I don't know. I don't know.
All right. Try to be love. Awesome. I don't see where they're answering to are we definitely getting a feed or not. So we're gonna find out.
I'll see if hold on.
I've been checking the other feeds too to see if like anybody else pulled up.
I'm gonna ask if it's back in section. Somebody asked if I was gonna go over there. I'm not.
I wouldn't want to go into that. No, I would not want to deal with that. Let's see. I'm looking for your questions. In the chat. The update. Is this a repeat or are you live? Right? We're live, hippie chick. Hippie chick.
Okay.
Good to see you.
Billy says not yet, waiting. I
Even
said there's no feed. I said, of course, back in session, there's no feed. And he says not yet, waiting.
All right. You might need to explain yourself, Sam.
Oh, God. What have I done?
She's
Oh,
not. She's not pro
okay.
Sarah, you guys. She's not. Trust me, she's not.
I'm not pro Sarah.
She just is. You have to remember her life, her career works on the defense side. So she's going to see things a little bit differently than us. Just automatically, I think.
I feel like my natural inclination, if I'd ever thought I was going to end up working in the criminal judicial system, I would have gone to the prosecution. But when I saw how the odds were stacked in favor of the government, whether it's at the federal or the state level, for anybody, and it could be you or me who gets, shoplifting for some gum or something, I really thought, okay, I'm interested in doing this. And the reason why I do it is because every once in a while there's a person who is being wrongfully charged, wrongfully tried, overcharged, whatever. The reason I think I sound pro Sarah here in this chat is because I'm trying to explain the defense side of things. So a lot of questions are being asked that I have read, and I've been here for a while. And I'm just trying to provide sort of context, right?
Right. Yeah. That's probably what it is too. People don't understand that they're because I see that a lot of these people that are asking are newer to the channel that I haven't seen them. I haven't seen their chats. I could be
Okay,
wrong.
so for any of the new people, we do have a video that says Florida private investigator and the JAC explains, and in the first part of that video I explain, excuse me, how the JAC works, how Sarah got to where she did, and what role Billy or I play in any of this. And for anybody else that's new, I worked on this case way back. So I have a tiny bit of insight into Sarah because I did spend some hours with her. April Knight, do you think Owens has been lying about his motions? So many times Kranick doesn't have it. There's no date, and Owens said he submitted it the day before. I feel like he's being sleazy.
Yep.
I find that to be unusual, right? Because in Florida, everything is e-filed. You don't have to print a piece of paper out. It date stamps for you. Yeah, I think I said this, Carrie, back when he showed up, right? Like, this shouldn't be so messy. There's no reason for this. I know I said this to you way back. I'm like, this does not make sense to me why this is like this, because it's just really not that hard to do. I don't know that he's intentionally being sleazy. Feels like to me he's being sloppy, and that he's used to practicing in his own courtroom where they let stuff slide. Michelle says, we won't throw you out, but we are very protective of our Sam and Carrie. Yeah, I'm not here to convince anybody of anything. I'm just here to give some insight, because I was listening one day and I was like, I could just explain this to her. So I did. Let's see. I saw something. I don't know how to say your name. CYKIQ. I don't know how to say that. I'm sure it's something easy. Sam isn't the only one finding things from the attorneys unusual. I've heard a few in the profession say the same thing. Right. So before I was an investigator, I did go to law school. And then I came out of law school and went to work in what was basically a criminal defense firm, and it was the attorney and me. So I got to see all different sides of things, including how to e-file. I did the e-filing.
Okay, Sam, they want me to play you this video. It's less than a minute, so I'm going to put it up
Sure.
real quick. It was over. Of course, it had to be turned into the Sarah Boone Show.
She's asking for 2 juice packs, 5 peppermints, 2 bags of chips, a bag of candy, and a bag of either cookies or a Pop-Tart to allow her through the day. I think they serve them a peanut butter and jelly sandwich down in the basement lunch. but she's not diagnosed with any kind of blood sugar, but she says she gets, like today, she's feeling tired and lethargic, and so she feels like those items during a break, that she could have something like that to keep her energy level.
I will speak to the captain of the jail if I can get a hold of her before 5 o'clock tonight and see what, if anything, we can do. I can't make any promises. My
ridiculous.
understanding from the deputies is that there are 2 bagged meals which are given, which include cookies as well, that are provided for Ms. Boone. That's for all inmates that are stored downstairs during trials.
Okay, so Carrie, first of all, you have got to send me that clip so I can send it to Billy. And then, can you hear me?
Oh, yeah, sorry, I was on mute. Yeah, go
Okay.
into my shorts. It was the last short I put up, so you can share
Okay.
it straight from my YouTube channel.
Okay, I'll send it to him. And you guys, I'm working on something for Billy, to get Billy over here. I'm not sure if Billy would talk about Sarah Boone. In the past, he has turned down all interviews. However, he has a really cool nonprofit that assists in finding missing people, and it's a group of like former federal law enforcement officers. It's really interesting.
Nikki, I think it's going to be Henderson that's going to be doing the questioning today, because just from what they and the way they acted yesterday.
Yeah, I could see that.
But what the heck is Beck there for? What is he working on? What's his piece to this whole craziness? I haven't
Who's
seen
that?
him.
Beck? I don't know what the purpose of him being here is.
Oh my gosh, what's Mark whining about? Does anyone feel like they need to take a shower after listening to Owens? Oh, KH.
Yeah.
Yeah, it's like yesterday getting off stream. It's like you need one long shower.
After most days in court, you feel that way about somebody. No, there's always somebody in there you feel that way. I don't know how Granite keeps a straight face on some of this stuff either. I will tell Billy that y'all appreciate him. He knows I know Sarah because, I used to work for him when I was on this case. So he's just, that's hilarious though. I'm going to have to send him that.
No snacks for Sarah. Judge said no.
Sorry, Sarah.
Michelle. It's Thankful Thursday.
Thanks, Michelle. We're thankful for you and your non-koala. What is it called? I can't remember. Something with a Q.
It's a weird name.
Yeah, I know. I can't remember.
What did Lisa say? Lisa said, let's not forget at their first meeting, the guards had to tell them to stop screaming, not to rep her until she called and begged him to. Oh, yeah. I don't know if she called him. I guess she did have to call him back. I just think it was odd that he admitted to the fact that he answered that ad.
Yeah, I don't know if that's the case or if that's really what happened, or not.
I mean, why would he say that why would he say that on the court steps? It just blows my mind.
Because it's theater.
Exactly.
Judy, no, I was not in the courtroom yesterday.
Hitters, it's hard work. I think I don't know what the heck Beck's doing. Doesn't she have a constitutional right to snacks?
So okay, for our cases, like we can usually put out like a tin of Altoids or some hard candy. Sometimes the judges will even have them at the defense and the prosecution's table. As long as the deputies can see what is happening, like if they can see, you basically have to like look at the deputy that's guarding your defendant or deputies, depending on what they've done, and be like, is this okay? And they're usually fine with it. I mean, The Hillsborough judges that I have worked with, and the deputies have all been really great. Is it a good idea? Oh, well, she has to in order to make this defense work. And do I think it's a good idea? Nope, sure don't.
What about perjury, though?
Well, okay, so we talked about that a little bit before, right?
Yeah.
And that is, she can't be asked questions by Owens to pull out specific answers, because then they know she's lying, and that's suborning perjury.
Okay, but when they go up, if they
When the
ask
state does,
yeah, so they go up there and they go to question and they ask it just the right way that gets around it, that fits in there. It's gonna. Don't they know it's gonna just hit her on the stand? She's gonna get stumped. It's gonna happen.
I agree with you, Carrie. And honestly, I've seen 2 cases recently with this narrative testimony, and I would need to go in and look it up further. But my guess would be that the same rules apply if she's a defense witness, right, for herself. So she testifies narratively, then the state can't come in and just ask her whatever they want. It would have to be within the scope, I think, of what she has testified to. I don't think it's going to end well for her. The people who think it's going to, it never does.
All right, I'm trying to read their thing to see if they say anything about updates on today's feed. Remember yesterday they started late too when they started to do this. Are they squeezing in a motion or something? Well, they let us put the feed up.
They've normally put that on the record.
So I don't know if the judges said not today, not anymore. I don't know. I don't see where it would have been a problem.
I don't think it was a problem either. Why is so Almit Stark asks, why is Owens not ordered to speak up and into the microphone? So because the judge can hear him and the court reporter can hear him. As long as the court reporter can hear him, that's what matters. We can't hear him because we're not in the room.
But when the court starts, the jury's going to have to be able to hear him.
Correct. Which they may say, speak into your mic. And it is not court TV or live trial TV or anybody's fault. That is an in-house system, right, with the mics at the desk. And so they wouldn't necessarily know unless somebody speaks up and says, we can't hear him.
I can hear somebody in your background. Are there kids playing in the background? Are you beating your children again, Sam?
I don't have any children. Do you want me to move? I can't hear them. I'm trying to move. Oh, it's just a neighbor walking by. It should just be a second. I have.
Oh, you don't have any feed on or anything?
No, I don't have anything else on.
Oh, okay.
It's just a neighbor.
Or is it? It's not Henry.
He walked in here a minute ago, and now he's gone.
Oh, okay. Okay, guys. So I don't know if we're gonna get a feed or not. We're waiting to find out. If we don't, we won't stick around. But they were supposed to come on 30 minutes ago, and they haven't come on yet. So I don't know. And remember, the judges got to approve them doing this. So feed incoming. Hang on. She just typed that.
Perfect. She read our mind.
We have a feed. She says we have a feed. Okay, they're coming in.
All right.
Whoop whoop. You go, Trial TV Live. You guys are awesome. I made the little parachutes for y'all. Do you like the parachute? I've got to put them on a whatchamacallit, like on a individual, so y'all can put them in your little emoji things. But I was trying to do that a while ago in the break, and I couldn't get them big enough, so they look too tiny. We'll wait for that. What does LFG stand for?
Let's effing go.
Oh, okay. All right. Well, Buzzman Jr. is getting a little antsy over here today. Are you upset over the defense being the way they were this morning? Because yesterday you were not this antsy.
defense
Sarah
is just,
goes on to-
I think we've learned that they're going to be messy. They have not tightened their ship up, which is absolutely bizarre to me, especially with those two young women sitting there. And I don't say that to be sexist or ageist or anything like that, but you know,
It is what it is.
it is what it is, especially because at least one of them just graduated from law school. So you'd think they would, you know, they're not the attorney. My point is they're there to assist at the trial and they are not the attorneys of record, right? So I would
Yeah.
think that they would help with this organizational issue.
Mark, so no, you know what I need to do is I need Henderson to be holding up a Cliff Notes book, since he seems to only have the Cliff Notes of everything in this trial. Oh, uncivil law. The motion for snacks being denied is the worst legal ruling of our time. I know, right? Shame on them. How could they do that? I think it's hilarious because you know what? To me, it kind of sets the stage and the tone for him to say, "I'm done, Sarah. You've hit the limit now." You know, it's one thing to ask me for a bottle of water. It's another thing to ask me for a Pop-Tart. Okay, girl? Ugh. But I still don't understand why why the prosecution can't just bring her a McMuffin if they need to. I still don't get that.
It's up to the deputies who have custody of her.
So maybe they're not allowing that. Why wouldn't they be able to allow her to have that while she's in the
Because
trial?
they don't like her.
Oh.
I mean, it's petty, but they can be petty. There's no rule that says, hey, we have to go get you what you want.
Michelle says argumentative. All right, I need a Diet Coke if we're going to get through the rest of this day. Thank you, Uncivil Law, for your super chat. I saw you were live this morning. You're not live anymore? All right, let's see.
A. Stevens wants to know if I've heard of what people think of Owens. So because so many of my friends are lawyers from law school, they don't want to talk about this with me. So that's why I'm here, to talk about it with you. And I think he's messy and a little lazy, if I'm honest.
Messy's a nice way of saying. Messy's a
Mhm.
classy way of saying, yeah, no.
I'm
we can't
trying
talk about
to
it.
I'm trying to be neutral. She can't fight Ginny. Jeannie Riesinger says, it wouldn't surprise me if right before the jury is seated, she fires them to delay it again. So if you go back to the judge's 16-page order, he basically says, you can't fire anybody else. If you get an attorney, that attorney stays. So I'm surprised about the iPad. Carrie, are you okay with me answering these? Let's see. Blue Jupiter says,
I'm back.
is it okay if I answer these questions in the chat?
Yeah, go ahead. I was getting a soda. Go ahead.
Blue Jupiter said, did you guys notice Sarah was using an Owen's iPad during the hearing? I'm surprised. Hearing yesterday. That surprised me because I would think not. But Ginger snaps, his country must be corrupt if this is how he practices law. Honey, this is Florida. And there are lots and lots of small courts or circuits, I should say, where they all know each other. And that's how it goes. Kurt
Welcome
answered
to
your
the South.
question. Kurt answered your question, Carrie.
What was that?
He says, I'm not covering jury selection on my own channel.
Oh, why not?
He says he's just waiting for opening arguments at this point.
Oh.
And wants to know if we need some company.
I mean, you could come up if you want to. We're all going to have to go on mute in a minute.
Oh, here we go.
Maybe after this, if it's not, I don't know how long it's going to last, though. They're making her read something now to keep her busy.
All right, thank you, counsels. Defense counsel, if you could see to address those matters that we have discussed, I would appreciate it. Anything else we need to address before we bring in our panel?
No, sir.
Defense. All right, let's stand and bring in our panel. Thank you.
The green line up. Shelby, hand me my seat. Thank you.
State, do you recognize our panel? Defense, do you recognize our panel?
Yes, Your Honor.
All right, thank you all. You all can be seated. Members of the jury, thank you again for your time. Welcome again to 23 Alpha of the Orange County Courthouse. My name is Judge Michael Kranick, and again, I will be the presiding judge in the case of the state of Florida versus Sarah Boone. I am going to ask the state to introduce themselves again to you this afternoon.
Good afternoon. Dave Cacciatore, Assistant State Attorney.
William J., Assistant State Attorney.
And defense, if you could introduce yourself and your client, please.
I'm James Owens, and I represent Sarah Boone.
Tony Henderson, representing Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
Shelby Andrews, jury selection and trial consultant. Lauren Henderson, assisting the defense.
Thank you all. You can be seated. Now, members of the jury, yesterday evening around 5:15, I gave you an instruction. If you could please raise your paddles to show that you complied with the court's instructions in this case. Record will reflect all paddles have been raised. Now, members of the jury, I want to take a moment again to thank you. Yes, sir. Juror number 26. Juror number 39. Did you follow the court's instructions? By you were able to hear the news yesterday, what does that mean?
I'm sorry. She needs a
Can we get her a microphone, please, for Madam Court Reporter? Thank you. Juror number 8, I appreciate you. Yes, ma'am.
I was at my parents' house yesterday evening and they keep the news on, and I was in the other room and I overheard it.
Okay. Did you overhear anything pertaining to this case?
Yes, I did.
Okay. Can the parties approach for a moment? Actually, just hold that thought. Ma'am, just hang on for me. We may have some follow-up with you individually. First, I want to take a moment and say thank you for your patience. I know I said we would start at 10 a.m. this morning, but one of those unscheduled breaks came up between counsel and I that you could not participate in. It took us some time to work through that. So I thank you again for your patience as we resolve those issues this morning. I want to confirm with all of you before I turn over questioning to the defense. As each and every one of you sit here today, are you an Orange County resident? Raise your paddles if that does not apply to you. Okay. Juror number 45. Yes, sir. When did you move to Seminole County?
Okay, but are you still a registered voter here in Orange County? Okay, can the parties approach for a moment?
Sam, is this this is the same 54 people from yesterday, right?
Yes, I believe it is because
I
they
mean,
weren't finished, right? I mean, the state may have wrapped up, but the defense didn't get a chance to question them.
okay, so we still have 54 people. Well, now it's 53 because apparently this lady heard something.
And one guy, so in Florida, you're called based on your registration to vote, I guess is what he was saying, because he was just asking if the guy was registered to vote in Orange County or Seminole County, because the guy was like, why am I here? I live in Seminole County.
Oh, okay. All right. So this is our 54. This is everybody then who's here right now. And this is going to be the only time that we hear this last bit. And then we're going to dwindle this down to our 6 plus our 8 alternates. And
wow, he's doing 8 alternates. I don't blame him. I don't blame him with the way they're dropping like flies.
I know. That's what, like, when he first did it, I was like, what? But it seems like that's what they're going with. So we do. I just feel like a lot of these people in this 54 pool yesterday, based on the questions and answers, there's a lot of them already been marked off based upon their answers.
Yeah.
Because, I mean, the number of people that were affected by alcohol addiction.
Right. Okay, so this is where the chart comes in.
Right.
Right. So everybody's using the chart, the big blurry chart, and they're all writing their notes as the questions are being asked. So defense is writing notes on there too for each of these people. And then the defense is going to ask questions. Then everybody's going to go away, and then they're going to try to hash it out. Like I keep saying, you don't really get to pick a jury so much as you fight to end
get
up
your
with you fight to meet somewhere in the middle.
Yeah, because I mean, some of the best movies that deal with law, a courtroom or whatever, or when the jury selection portion of them fighting out the juries, I hope they allow the cameras on for that discussion. I don't know if they will, but
I kind of doubt that, but I could be wrong.
I think that would be interesting. I think Tony says he's only got an hour and a half to 2 hours, right? So it is 1:30 right now their time, which means he'll be done by 3:30, which gives them an hour and a half of business time if they wanted to complete anything or get anything done. We could have a jury by the end of the day.
Possible.
I mean, do you think? Do you agree?
I think it's possible. I mean, if Henderson keeps it short, but you saw how people like to get all confessional. I told you guys it was going to be this way. I was in a federal trial, I think 2 summers ago, and AR-15s were used in the commission of the crime. And so they asked something about who owns an AR-15, and 3/4 of the hands went up, and most of them were women.
Oh my God.
I know. Even my client who was accused of using the AR-15 looked at me and he's like, what is going on with you? I'm like,
only in Florida. Only in Florida.
Yeah. It's just interesting what you see. You know, okay, so I assume things. I'm not going to say you. I assume things about, that are a certain way, and they're just not.
Yeah.
So, it's interesting to me. Cher owns 2, so there you go. I have no issues with people, and I'm not trying to start another war. It was just a comment.
Great. Juror number 8, you're slowing it down. I just read that out like that. I think that's what he meant.
I do too.
Are you serious? What's up? What are y'all serious about? I overheard the news. Yay. Okay, lady. LOL. Okay, I don't know what y'all are talking about. Y'all are talking amongst yourselves again. Okay, I think they're done. I'm gonna go on mute. I think they're done. Maybe not. Only in Florida and Idaho. Okay.
Yana,
no, Utah.
Yana said in chat that Sarah gets to make notes on what prospective juror to keep strike. She does. She absolutely gets to participate in this process. And it's a good thing for them too, because they feel Well, they're scared. I mean, even if they're really bad people, it's still nerve-wracking, and it gives them something to think about. You know what I mean? Something to do with themselves.
Well, she needs to stay busy and stay out of their business. So I guess he's probably like, yeah, I need you to color code these for me, Sarah.
Could be. Could be. I mean, it could be anything.
Here's some highlighters. Go ahead and color code this map for me. If he was smart, he would do that. Margaret, I need some crayons.
Cass has asked a question before. She says, PICM, could a witness refuse to testify in person? Do they have that right? Let's say I lived next door, hated Sarah, and just happened to have heard something. Can I be forced to testify? If you're under a court subpoena legally, yeah, and the court can hold you in contempt, which is what they did to little Woody in the YSL trial in Georgia. And they said, we're going to put you in here until you testify. But that's because he had an agreement with the state.
Yeah.
So the answer is technically yes. And then if you got up there and you didn't want to be up there and you were,
Members of the jury, again, thank you for your patience. We're going to take a short break at this time. Don't go
Oh my
far.
God.
5 minutes, just outside. And if jurors in seats 39 and 45 could stay behind. The rest of you, same instruction I've given you the last couple of days. There's still no case. Do not discuss this case. Don't do any independent research or investigation. And don't talk to yourselves about the case. You can talk about anything else other than those things.
That's the name of their thing, Top Mark Media.
What does his mug say?
It's Florida State, I think.
Oh, does it not
I
say
think.
world's best judge?
Oh, maybe it does. He's got a different one today.
No, I'm just making fun of it. I'm just joking. Sarah doesn't seem to get the notice that you have to stand up for the jury.
She doesn't get that, does she? I noticed that yesterday. I was like, stand up, hooker. And everybody was laughing in the chat because I said that like all of a sudden. I was like, like, are you just that ignorant? Don't you understand?
Yeah, in Florida. So I've seen this different in different courtrooms. In Florida, you rise for the jury entering and exiting the room.
So 39 and 45, they're going to get sent home. That's going to put us down to 52. No, that's 51 because the 25's gone now.
You're good. Thank you, sir. Appreciate you.
Oh, she keeps looking at the ceiling, I think, because there are cameras up there. I kept seeing that question yesterday.
Jurors in seats 39 and 45, thank you so much. In speaking with counsel for both state and defense, we're going to go ahead and discharge you from your jury service at this time. Please report back to the first floor, jury services. They'll validate your parking and give you any additional instructions. And again, I thank you for your time and your sacrifice during this week. Enjoy the rest of your week. And thank you. Again.
Now everybody's going to come back in and go, oh, I overheard something too. Can I go?
Mm-hmm.
As addressed at sidebar, jurors in seat 45 wearing badge 240 has been stricken for cause by way of stipulation, and juror in seat 39 wearing badge 551 have been stricken for cause by stipulation. One other additional matter, juror in seat 51 had advised either yesterday that did you recognize anyone? She had advised that there was a law student that she recognized she had seen at some volunteer organization. She's in fact Judge Leach's intern sitting in the box. And ma'am, if you please could introduce yourself for the record. Yes. Okay. So she is not a member of our panel. So I just wanted to put that on the record as to who it is that she may have noticed, and that person is not a member of our panel. All right, we'll be in a short recess until our panel comes up.
At some point, you were going to talk to Ms. Boone about the lawyers, some being out at the time.
Yes, okay, Ms. Boone, one of the matters that we addressed at sidebar out of everyone hearing is that I've noticed that one of your lawyers has been in and out of the room and sometimes been waiting, or this morning I asked you if you were prepared without your attorney being present. You said yes. Your lawyers have advised me that due to scheduling and speaking with other witnesses as to coordination, Not all of your lawyers may be here all at the same time. It may be Mr. Owens, maybe Mr. Henderson. It may be a combination or less than that much. So the question I have for you, ma'am, are you on board with proceeding without your full defense team being present at all times?
I am.
Okay. Any further inquiry state as to that issue?
No, Your Honor.
Any further inquiries to that issue, Mr. Owens?
No, sir.
Okay, thank you all very much. We'll give the juror another 2-3 minutes and then we can have the deputy bring them back in. Thank you.
Why did they do that?
Because she has three attorneys of record.
And Beck seems to be coming and going so much.
And I guess if you have three
Try again,
attorneys,
sir.
Can you hear me? Yeah. That works? Okay, we're good. Thank you.
That's Henderson.
Unsolicited advice?
Yes.
The tie, I think, works better because when it's onto lapel, it's very directional when you turn your head. That's
Oh, really?
that's a
Is that
microphone
close?
issue.
Yeah. You can hear me pretty.
Oh my God, that was funny.
I hear.
I'll do it like HGN and move my
I
whole
hear an
body.
air.
So, keep my head still. Oh, well, no.
I thought I heard an air conditioner or an airplane.
Oh, I'll go shut my slider. It rained in my house, so I'm trying to get a little air. Hold on, I'll go close the slider.
Okay. Sam just went through the hurricane, you guys, in Milton. Someone yesterday thought she was praying. Sarah, she didn't know how to pray. I hope she finds a way to pray. I hope she finds Jesus. She needs to. He's the only one that really can truly judge her, I guess. If I'm 39, I'm switching numbers with someone quick. If I'm 39 or 45, why? You want to be there, NR? I don't want to be there. I wouldn't want to be there. There was somebody that didn't show up this morning, though, Cass. Believe it or not. They played dumb. And the judge, I mean, what can you do? I mean, I guess if they wanted to do something about it, they could. But at this point, it's like they got too many other things on their plate.
Leah, that's my favorite clip of Sarah. My absolute favorite one. When the cop says, Jesus Christ. And she turns around and says, do you need Jesus right now? I love that one.
Yeah, it's Top Mark Media is connected to Trial TV Live, and you're saying it's connected to Recovery Addict too? I didn't know that. I did not know that.
Leah likes that clip too.
I did notice that he had a very, very interesting soundboard though when I saw him. I like his setup.
Recovery Addict?
Yeah,
he looks like he's running the world.
Like he's got like he knows what he's doing as far as the sound.
It's crazy.
So I wonder if him and the one that's doing the, what's his name? Oh shoot, is it Chris? I think his name's Chris. I wonder if they used to work together or something.
I don't know. I have admired that setup though.
Thank you, Luna Cat, for your super chat, honey. Yeah, I wish I knew how to do all that stuff. Maybe one day I'll watch I told Sam, I'm like, I want to take a class for that. And she was like, watch a YouTube video. There's still so much in editing I need to learn, but I do need to focus on audio stuff too, though.
Gypsy's mom says Recovery Addict was a professional sound guy. Well, that makes sense. He also sounds like he could have been on the radio.
Yeah. Somebody told me yesterday or the other day I sounded like the one from News Nation. What's her name? Ashley. Benefield? No.
Banfield. I know. Yeah, so here's a funny story. I went to college in Dallas, Texas in the 90s, and one of my friends was dating a guy who was best friends with Ashley Banfield, who was in a bar I worked at all the time. She
Oh,
was
really?
local news back then. Yeah.
Oh, she was even back.
She was,
Oh.
yeah, she was local news. This was in the mid 90s.
Hey, Abellis. Oh, there's somebody in here with the name Cheshire Cat. That's cute. Oh, and you know what, Cheshire Cat? I completely agree with you. I said that a while back. I felt like she was the modern day Sarah Boone.
State.
Lying downs.
Steve Ketchum on behalf of the state.
All right, we're going to mute.
Defense.
James Owens for Sarah Boone.
Tony Henderson for Sarah Boone.
Kevin Beck on behalf of Sarah Boone.
All right, Ms. Boone still seated at council's table. We're bringing our jury back in. Let's all stand and we'll turn over the questioning to you, Mr. Henderson.
You called it, Carrie.
What, you mean Henderson?
Yeah.
No, well, I saw him talking about it yesterday, though. I didn't really call it. But thanks, though. Thanks for the...
Ozzy thinks I have connections to all the crimes and I'm secretly a federal agent. I really appreciate you guys asking if you could help me financially with the damage from the storm. I'm good. Thank you so much, though. I really appreciate it. Can you hear that siren?
Yeah. Why, is that you?
It's outside. Like, I don't know where to move for it to be quiet right now because of the aftermath of everything. There's constantly some kind of noise.
Oh, you're fine. You're fine. Go get in the closet. No, I'm just kidding.
It's so hot in there.
No,
I
I was
already
gonna
lived
say-
without air conditioning for days.
No, I'm totally kidding. I'm totally kidding. Just go sit in the hot closet, surrounded by your clothes. You know, some people do that. Some YouTubers do that. That's how
I
they have their
know.
studio.
I know they do. I'd be accompanying Henry because that's where he takes his afternoon naps.
Yeah, we did. What they just said. Thank you, Miss Leah, for being a member for 2 months.
Thank you, Leah.
Oh, Abellis. Thank you so much. You
Kate,
always
recognize
come
our
in and do
panel.
that.
Defense, do you recognize our panel?
Yes, Your Honor.
All right, members of the jury, again, if you could please, you can be seated, thank you. If you just raise your paddles to confirm that you complied with the court's instructions during this last break. Record reflect all paddles have been raised. With that, Mr. Henderson, you may proceed, sir.
Yes. May it please the court, counsel. Ladies and gentlemen, good afternoon. That was my first challenge in public speaking. I've been practicing all day that it's good afternoon because we're here in the afternoon. I'm used to saying good morning. So even I have challenges when it comes to public speaking. I want to thank you for being here. Again, my name's Tony Henderson, and it's my pleasure to represent Sarah Boone. And I know the judge has told you, but on behalf of our defense team, in regards to Ms. Boone, we would like to thank you. And I'm going to tell you why. America is still great. And the reason that America is great is because of systems like this that we have. It's our Constitution. Because in this country, our citizens are protected. In this country, we have limited government. In this country, based on our Constitution, and the Sixth Amendment right that we have in our Constitution is the right to a jury trial. Folks, in some countries, they don't have that. In some countries, you don't have a jury. In some countries, they have professional jurors. In some countries, only a judge decides. In some places, you have to prove yourself innocent. We don't have to do that here. This is the way I rank these things. And of course, I have my bias as far as what you can do, the service that you can do for your country. I have this ranking. And I have a bias when it comes to this ranking, and I'll tell you about it. But number one, I think by far, is military service to your country. Number two, I believe, is jury duty. And my bias for the military service is the fact that my dad spent 22 years in the Navy.
No pending question.
Overruled for now.
Thank you. Number two is jury duty. Quite frankly, it's probably something I'll never be able to do because of the position that I'm in, but I would love to do it. Truly, folks, it's you that make this system work. All right. And number three, I think everybody should vote. Okay. Now, I want to talk to you about the trial process, and this is voir dire. And voir dire means to speak the truth. This is my only opportunity that I will have to talk to you. Okay? Because once these proceedings start, it is against the rules of conduct for us to have any communication with you on either side, being on the state side, being on the defense side. So if you were to run into us or see us somewhere and we don't look at you or we don't acknowledge you, we're not being rude. Okay? We're just following the rule. And it gets ingrained in us because this afternoon, when I came up the elevator, it was a couple of people with jury badges on. I made sure I didn't say anything. Okay? But that's the reason. But for a trial, I break it down to it being 4 fundamental rights. And these 4 fundamental rights apply to everyone. They would apply to me if I was on trial. They would apply to you if you were on trial. They would apply if you had a loved one or a friend on trial. Today and for the rest of this trial, they apply to Miss Sarah Boone. And the first one of these fundamental rights you've already heard about, but sometimes people say things differently. And the first one is the presumption of innocence. We've all heard that term, correct? Raise your paddles if you've heard that term. You probably heard it enough yesterday. But prior to yesterday, I'm sure you've heard that term before. Is that correct? Could you raise your paddles if that's correct? And all of you have said that you can presume Ms. Boone to be innocent. Okay? That means at some point in time, and the judge is going to read you an instruction, and I believe the judge already did yesterday, that presumption of innocence means that you believe that she is innocent.
Uh-oh, they seem to be going in and out with their feed today. They weren't doing that yesterday.
Yeah, I don't know what's going on.
It'll come back, you guys. Just give it time. I'm so sorry. The ads have been more today than yesterday. I adjusted my ads from yesterday, and they're supposed to be a lot less, and people are saying, no, they're more than normal. I can't figure YouTube out, you guys. I swear. It's so annoying. Do you think it's bad internet? That's what I'm wondering.
It could be Northwest. I think the entire, well, I don't want to say the entire, I think most of the power's been restored everywhere, but there could be internet issues. I mean, there's still flood warnings going on for different counties as things crest. It's crazy.
I love Ginger Snap's snark. Like his dream voice killed the feed. I thought for sure he was going to start singing the national anthem or cue a song from, just cue it for Whitney Houston singing it or something. Really? Are you kidding me? I know, Patty. We're all shocked. We are all shocked. Ads are what they are. Yeah, I know.
Well,
they
Patty
are,
says she's shocked it made it to opening statement.
See that? Okay, so here's why I'm asking you guys about the ads is because I actually got a text or a comment from somebody the other day that said that she logged on, she was on for less than 5 minutes, and that all of that she got like 6 ads is what she said or something like that. So yeah, I just want to make sure you're not getting too many on a live stream. You shouldn't be. But yeah, YouTube Premium rocks. I highly recommend it if you can afford it. If you can't, I hope you can at least hit the skip button.
Patty, this is still voir dire. We're not at opening arguments yet. We don't have a jury.
Our power keeps going in and out. Yeah, I'm wondering. I don't know if it's internet. I don't know what it is, but it's back now. Okay, I'm going mute. They did not have this problem yesterday at all. But she's looking up towards the bench, so I wonder if they're on a. They might have been called to the bench again. Sidebar. Is jury selection complete? No, KJ Brocky, they are not. That's what they're doing now. They need to change connectors for Yana. Per Yana. Okay.
Sam, in my area before trial, the judge has a meeting where he tells both sides, including Sarah Boone, his rules for trial, like no talking, interrupting, standing for judge and jury. Does Florida do that? I think it's
About
probably
the
based on the
presumption of innocence and how we are. Can we all set aside and presume Sarah Boone to be innocent? Thank you very much. The second one of these I want to talk about.
Oh, this is not good. But you guys, again, don't stick with us because yesterday they had a great feed yesterday. So just give it a few minutes. They might be working out some kinks.
Proof, okay? You heard about that yesterday. The judge told you in any criminal case, it's certain of proof. It does not have to prove anything. Okay? Well, jury number 6. Sir, do you know why the state has the burden of proof? Why should it be? Do you think it should be that way? That the state?
If they're prosecuting her, yeah.
Why?
That's the law.
Okay. Can anyone else give me a different reason by show of paddles that
Oh, so how you come here often? How's
Right?
the weather over there? Where you're at?
Actually, I'm really thrilled. It's kind of cool. It's not hot, which is really nice for a change. It looks like Yana is sort of passing on messages from Trial TV Live. Like they're
Yeah.
having trouble with their, there you go. They're working on it. They're having trouble with their feed.
Yana's got double things going on. Oh yeah, we just lost almost 100 people right there.
Oh,
It's okay. I think we're back. Not yet. Yeah, I appreciate you guys that are so nice about the commercials because it really, I mean, you think about it. If they're skippable ads, they don't bother me. They never bothered me before. But you wouldn't believe how many people are really fussy about it and they will leave your channel because of it. I'm like, really?
Yana transcribes for a living. Oh, bless her heart. You must, if you do court cases, I hope you get therapy because I can't imagine. I can't imagine. Henry is fine. Thank you, Ginger Snaps. He was pretty funny during the storm, but he found all the places the ceiling was starting to drip. So that was helpful. He was attacking the water.
Ozzy said, I'm not part of your legal system, so I don't have to presume innocence. Well, thank God you're not on the jury, Ozzy.
Right?
Oh. Ozzy, where you going? You gone?
He had to go to bed. Ozzy went to bed.
Oh, night, Ozzy. Dreams are made of little Debbies. Skip the pottery. You know what? I do like me some little Debbies. Every now and then I want an oatmeal cream pie. Every now and then. It's like
Yeah, right? Like every once in a while.
It's like a craving for like a McDonald's fish fillet, you know?
Mm-hmm. Yeah, it's
So
like the weirdest thing. It'll come.
These juror questions are so lame, Mark said. Maybe he's recruiting for Owen's dream team. Our new Mark, our new Mark from Mark I know I'm saying it wrong. Wetherill. He's got some snark in him too, so I'm not gonna be able to keep up with you guys. The extra ads might be due to the flood of new subscribers. Could be.
Is that how it works?
Sam's over there mixing a drink. You can hear.
I'm sorry. That was my cold coffee cup. I'm trying to be super quiet.
Oh, wait. Hang on. Let me go over there. Interesting. Interesting. That's old. That's an old feed.
Oh, okay.
That's from the court this morning. She's talking about this morning.
Oh, okay. Yeah. Oh, okay. Yeah, I heard her. Yeah. Okay, got it.
Okay. NRH says we have another inmate behavior report where Boone was hoarding staples from her religious class booklets and tailoring her pants with them again. Again? Is this new or old? Because I already have that. Y'all, I'm telling you that one image that I picked up.
As to element B, there was
That one.
But as to
Okay, I'm muting.
As to element C, you have a reasonable doubt.
No, we're not trained to talk down to people. But he's also a different generation of lawyer. And I found that there is a huge difference between generations in how they practice law. This is craziness. I'm just watching you guys in the chat to see what you're talking about. Oh, she did do it twice. NRH, the inmate behavior report outlined that it was the second time and she knew it was against the rules because of the first time when her pants were replaced. Oh my God. Oh, Lord. Laura, I know the mic is turned away.
Okay, and I used to try to say, granted, it don't work like that. But that was her fundamental belief. Okay? Is there anybody who feels fundamentally like my grandmother? Anyone? And it's something that I forgot to tell you when I went into this for die and talking about it's to speak the truth. And why this is so important at this point in time, folks, because guess what? I can't read what's in your mind. Okay? I can't. But more importantly to me, I don't know what's in your heart. I don't. So you have to tell me. And if it's something I say that confuses you or you don't understand, raise that paddle and I'll try to clarify it. Okay? All right. So, do you know what that means? Because the judge is going to give you an instruction about if Ms. Boone elects not to take the stand. And that instruction is going to include that you cannot consider that in any way in your deliberations. Do we understand that? Okay, great. So guess what, folks? You're back there and you're talking and it's close. And someone says, well, we didn't hear from Ms. Boone. Nope. That's wrong. Do you understand? Because you cannot consider it in any way. Do we understand that? Yes. Okay. Can we all adhere to that? Okay. Anyone with a problem with that? Okay. Thank you. So none of my grandmothers out there. All right. All right. I'm going to get to some more case-related questions, as I call them. I just want to make sure, is there anyone here who knows someone with the state attorney's office anyway? Is there anyone here who knows someone from the state attorney's office? Anybody who works at the state attorney's office? Show of paddles if you do. No one? All right, good, thank you. All right, there was a question asked yesterday about interactions with law enforcement or who knew people or related to or had friends with law enforcement. I remembered we took them down. I want a follow-up to that question that I just want to ask you, okay? Is it anyone who has such a close relationship with law enforcement that it would be hard for them if they're on this jury and after they listened to the evidence and said to themselves, the state did not prove this case. And we had to find her not guilty because we followed the law. Is it anyone in a relationship would have a problem telling that person that's what we had to do and that's what we did? Anyone in that type of relationship? Okay. Thank you. Now, in the state of Florida, there are certain things that we have that are known as affirmative defenses, okay? One of these things that we know as an affirmative defense is the justified use of non-deadly force and also the justified use of deadly force, okay? AKA, meaning also known as self-defense, all right? I think everyone's nodding now because they recognize that term, self-defense. By the show of panels, how many people recognize the term self-defense? Is it anyone here who disagrees with the principle that a person has the right to defend themselves? Show of panels. Anyone? Okay. Is it anyone who disagrees with the thought that a person has the right to defend others? Anyone fundamentally disagree with that? basically what I'm asking is anyone who thinks that slap my cheek, and let me turn the other one to you so you can slap it. Anyone? Okay. Has it been anyone in this panel who's ever been put in a situation where they had to defend themselves? Just show of paddles, please. Yes. 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 Anywhere. Those are all good questions. Anywhere that you've been in the position, it could have been at school and someone's come up and started picking on you or hitting you or whatever. Do you understand? Okay. Yes, we're talking about physically defending yourself. School, middle school, it could have happened. It could have happened when you were in diapers. Okay? Yeah. So at any time in your life, have you felt or did you have to defend yourself? Can we show paddles, please? Okay. Could you hold them up? And we'll start because my arm would get tired. It was getting tired yesterday. You can, this is my left side, so on the right side, correct? Okay. Yes, just on this paddle. And that's paddle number 1, paddle number 2, paddle number 4, paddle number 5, paddle number 6, paddle number 7, paddle number 15, paddle number 17, 18, paddle 32, paddle 41, paddle 43, paddle 44. Then we're going to be in paddle 47. I'm sorry, sir. Were you holding it down low? I just missed you. Yeah. Okay. Thank you. Now, this side. Paddle number 14. Paddle number 24. Paddle number 26, 27. Paddle number 36, 38, 48, 49, 50, 51, 53. Okay. Would you all agree with me that each of those situations would have been different? Anyone who disagrees with that? Okay. So would you agree with me that each of those different situations, if you disagree, just raise your paddle, that each of one of those situations would have to be determined on their own merit and their own facts? Would you agree with that? Okay. Is there anyone who disagrees with this? A person has the right to defend themselves, even if it means using a weapon.
Objection from statement of law.
Approach.
I'm a little surprised. That's the second time the state has objected during Mr. Henderson's speech.
Second time the state has objected. Well, he did say use a weapon, and my first thought was, you mean like a bat? Is that what you're talking about, Tony?
Oh my God.
Am I still loud, by the way, you guys? I turned my volume down again.
Somebody had a question. I started. Where did I put
That
it?
objection is sustained. Mr. Henderson, you may continue.
All right, as I told you before, there's two types of self-defense, okay? Self-defense with non-deadly force, all right, we're not going to be talking about that in this line of questions, all right? And the line of questions that I'm talking about is that self-defense with what's known as deadly force. Okay? That's basically force that is likely to cause death or great bodily harm. All right? Do you understand me there? Okay? In that situation, you have to be in fear of that time. The person has to be in fear of that time that is going to be an action against them or a threat or an imminent threat against them of being harmed with great bodily harm or death. Or a forcible felony is being attempted on them. Do we understand that? Examples of forcible felonies are aggravated assault, aggravated battery, felony battery. Some examples. Okay? In that type of situation, is it anyone who believes that a person should not be able to use a weapon in defending themselves? Is it confusing?
Depends on the situation.
Can we get
Yeah.
a paddle number?
Yes, please. I will. Paddle number 24.
It depends on the situation. I mean, you can negotiate and walk away and war, then do what you can, but always try to walk away as peacefully as you can.
Okay. Now let me ask you a couple other questions, sir, during number 24. Yes. Thank you. During number 24, when the court reads you the law on justifiable use of deadly force, will you be able to follow that instruction?
Yes.
Okay. Now, would you agree with me that every situation is different?
Yes.
Is that correct? Okay. Let me give you an example. If someone was to put a gun in your face,
right?
Okay. Do you think that you have to wait for them to fire it?
No.
Before you fired your gun?
No. Self-defense first.
Is there anyone who thinks that you should have to wait? Anybody? Okay. So in certain situations, based on the facts, are you saying there would be times when you feel it would be appropriate to have to use a weapon? Or I don't want to put words in your mouth. You tell me.
Well, if your life is in danger, you do what you can. It depends on the moment that you're in, but even though you try to look for peaceable solutions, but if your life is in, if your back is up against the wall, there's a knife at your throat, you do what you can. Not the intent to kill, but to resolve the situation without being killed, if you understand that part, yeah.
Okay. Would you judge it by each situation, sir?
Yes, every situation is different.
Let me ask you this. Would you consider physical ability when it comes to it?
Can be physical, and it can also be negotiating verbally. Sometimes that works. Depends on what the attacker's motive is at that time. So, you know.
Well, let me give you this example, and then you tell me about that. What if it's a male, 6'5", 200 and something pounds, and a female, 5'2", 105?
Objection?
Approach.
And here we go again.
Billy reports that he's very glad that he is not in camera view.
He said that.
I said, you're not on camera. Oh, let's see. He said, well, when he said he saw rubbing his head, then he said, I'm so over the camera. And I said, well, it's solely focused on Sarah right now. And he goes, right. I'm glad I'm in the box. He must be in the jury box.
Oh.
Because he ends up on TV all the time. This is Florida. All of our cases are crazy.
Tell me what you were telling us about how he is. He doesn't like any of that. It's so funny. He could
Billy? No.
He could showboat if he wanted to, and he's just
He
not
is
like
so
that.
not that. He is so not that. That is not him at all.
It's funny.
He's very diligent about doing his job, and he runs an agency with a whole bunch of investigators. Tries to keep a lot of attorneys happy.
Something clever. That's a good question because I usually I haven't seen it. Usually they schedule sentencing because I think what they have to do is schedule whether or not there's going to be impact statements involved. So what do you think, Sam? Do you think that have you ever seen it where they go straight to sentencing?
If it's something minor, like, a low misdemeanor or something, but like I've got one pending sentencing right now, which I pray to God is.
Sustained. Mr. Henderson, you may continue.
Yes.
We'll come back to that question. It's a good question.
Sir, I need to change that. Male, 6'5", 200 and something pounds. Okay. Female, 5'9", 120 pounds. Okay. Would you consider that when it comes time to how a person would have to defend themselves?
Yes. If it's life and death, it's either their life or your life. So yes, it would be, if that's the last resort and there's no other recourse, I would say yes in that situation, because it's either their life or your life.
Okay. Yeah. All right. Let me ask you this, so, and looking at like when you say it like that, but would you be able to recognize the difference in probably the physical abilities of a man who's 6'5" and 200 and something pounds versus a woman who's 5'9" and 120 pounds?
Well, are you talking about the lady defending herself against the guy that's?
Yes, sir.
Well, in that case, is the survival. I mean, she can either run away or depends on. But I mean, my point is, you try to avoid deadly force if at all necessary. I mean, that's the last resort. But if you can, you don't use it. But if that means your life, then of course, in that case.
Okay. Thank you, sir.
Yes.
Juror number 5. What's your opinion on that?
As a woman, I would want to defend myself, and no matter how big of a guy, I'm going to try to defend myself until he either hurts me or I take him out and get away.
Okay. Do we have juror number 10 here? No. You got me. I should have had my sleeping chart. 10. Juror number 17. Can we get the mic over there, please? Sir, yes, could you repeat that, please? Juror number 17.
Thank you. Does that work?
Yes.
What I was saying is if there's a larger, more imposing physical presence there that you're fighting against, that could put you in a situation where you have no choice but to use whatever's available to you, because in the example you gave, you're not going to win that fight 99 out of 100 times.
Okay. Thank you, sir. Is there anyone who disagrees with what juror number 17 just said? Hold your panel up if you disagree. Is there anyone here who, are you holding it up that you disagree, sir? Okay, thank you. Anyone else who disagrees? All right. How many people show of paddles who agree? To what he said. Who agrees? Okay, thank you. Do you all understand, in the state of Florida, when it comes to defending yourself, either with non-deadly force or deadly force, that you don't have to wait for the commission of the act? Do we understand that? Am I confusing anyone? Okay. Meaning that if someone holds their hand up and fist up and make like they're going to hit you, do you understand that to use non-deadly force in that scenario, you don't have to wait for them to hit you? Do we understand that? Okay. Also, in the use of deadly force, if someone holds up a gun, all right, you don't have to wait for them to fire it. Do we understand that? Yes. Is there anyone who disagrees with that? Also, in the state of Florida, if it's two people or someone has knowledge of a person or the other person who's exerting force on them, if they have had difficulties or events in the past, that could be considered in their use of either non-deadly force or deadly force. Do we understand that? All right, if you understand that, show of paddles, please. Okay.
I don't understand what you said.
All right. Let me try to give you an example. A and B are school kids, okay? They go to school every day. Let's go, say they're in middle school, all right? And for the past couple of weeks, you know, A has been beating on B, okay? So A and B go to school again one day. Next thing you know, A comes up to B, and B just automatically hits A.
Approach.
You want to finish what you were saying about sentencing?
That's the fourth
Immediately.
time they've done that. Oh, so short sentences done right away, longer ones like life, etc. They do a pre-sentencing investigation and they give us opportunity for putting together and presenting mitigation.
Mm-hmm.
So, like,
Objection is sustained.
I've got one right
Mr.
now.
Anderson,
We're
you may
waiting
proceed.
to do that.
Let me try to explain it to you like this, ma'am. If you hear an instruction that you can consider past difficulties between the parties if in determining if someone was justified in using non-deadly force and deadly force or deadly force, could you follow that instruction? Okay. Is there anyone here who could not follow that instruction? Yes, ma'am.
I need a microphone.
Oh, okay.
We get juror number 13, the mic.
I'm not doing a good job with the mic. I'm sorry. I'll get better.
So like in your example, if I'm allowed to use the example that you were just using on Amby, no.
Not the example that I used before. Okay. That was found to be wrong.
Okay. So I guess my question is, even though there's been past events that have happened and they could weigh in with that, something still has to be happening in that moment for them to defend themselves in that way, right? It's not like
You're absolutely,
somebody walks up to you and you can just defend yourself.
you're
because-
absolutely correct, man. Because what the statute is going to say and what the instruction is going to say, that has to be an imminent threat, okay? An imminent doesn't mean that you have to wait for it to happen, but you have to have reasons to believe that it's going to happen, okay? But the instruction that I'm talking about, do you understand that past difficulties can be considered? Because that's what the jury instruction says. Can we follow that instruction? Is that correct? Can you follow that instruction, ma'am? Okay, thank you very much.
Oh, I don't like the way he talks to women. Nope, 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 nope.
How many people here own guns? Or at least one gun? Okay. All right. Let's start on this side over here. Juror number 4. I'm not going to ask you how many you own. That's your constitutional right. I'm not going to. I asked that one time. Somebody said, I'm not telling you how many I own. So I learned from that. What's the purpose of your gun?
My American right.
Yes.
Self-defense, and then we're just on the street.
Okay. All right. Thank you. Juror number 5.
So they're actually my husband's, and he had purchased one for me for that reason. If he was home or not home with, and I was by myself with my child, someone were to break in, we would have self-defense.
Okay. Thank you. Who else on the first row on this side owns a gun? Anybody else? Second row? Yes, sir. Juror number 15. Excuse me? You have to speak up, juror number 15. Oh, there we go.
It's basically for home defense. That's all.
Home defense? Okay, thank you. Anyone else on the second row on this side? Juror number 17.
Exactly what she said. Exercising my right, self-defense, and I like to target shoot.
Okay, thank you. Anyone else on this row? Yes, sir. Juror number 19.
Self-defense.
Self-defense.
I don't really shoot, but I have it in case I need it.
Okay, thank you. Anyone else on this row? Third row on this side. Anyone owns a gun? Okay. Last row on this side. Anyone? Let's start with juror number 44 because she has the mic, I believe.
Same reason as the lady up front.
Okay, thank you. Juror number, what's your panel number, ma'am? 43. Thank you.
For self-protection, I live alone, and also in my job, I have drugs. And so somebody could, I'm a veterinarian. So if anyone knew that and people are crazy, then they might want to break into my house and try to get, or into my truck and get drugs.
Or in other words, if anyone gets froggy.
I'm sorry?
I said froggy, it's a slang term, I'm sorry.
Yeah, so just, I mean, it makes me feel safe.
Okay, thank you. And sir?
Yeah, just old hunting shotguns.
Okay.
Hunting rifle from my father and grandfather.
All right, thank you. Anyone else on this side own a gun? This side, if we can have the mic come this way, would be great. Oh, they have a mic on this side too? That's great. It's like a relay team. All right. Juror number 23.
For self-defense.
Self-defense. I like your juror number, sir. That was my football number.
Home defense, and recreation.
And recreation. Thank you, sir. That was juror number 24. This is juror number 26.
Home and self-defense and shooting practice.
Okay, thank you. Anyone else? Oh, did I get the first row here? I didn't get it first. Yeah, juror number 8. Sport and recreation. Okay, were you able to hear that? Okay. All right. Now, I'm on the third. Anyone else on the second row on this side? On the third row on this side, anyone gun owner? Juror number 37.
Just for recreation and home defense.
Okay. Anyone else on this side? On this row, I'm sorry. Back to juror number 51. Thank you, ma'am.
I don't own a gun, but my husband bought one for target shooting. I don't even know where it is, so he's got it locked up
Oh,
somewhere.
okay.
But it's not for home defense, though.
Okay. Well, thank you, ma'am.
Is that it?
Recreation, home defense, and our rights.
Your number, please, your panel number? 49? Okay. Thank you, sir. Anybody else? Anyone I miss as to gun ownership? All right. Thank you. Folks, if you disagree with this, raise your panel for me. Yeah, I'm sorry, I'm about to say. If you disagree with this, raise your panel, okay? Your home is a sacred place. Yes, anyone disagree with it? Your sacred place. Your home is a sacred place, okay? All right, let's do it this way. I'm sorry, yeah. I did it the wrong way. Let's do it this way. If you agree with this statement, raise your panel, please. Your home is a sacred place. Okay. Is there anyone here who believes that you can't defend yourself in your home? Okay. If you do, raise your panel. All right, thank you. All right, it's going to be one other thing that I'm going to talk about with this justifiable use of non-deadly force or justifiable use of deadly force, okay? And it ties in with the burden of proof because remember, it's the state, the government, who has the burden of proof, all right? However, folks, once the judge reads you an instruction saying that it's an affirmative defense of justifiable use of deadly force or justifiable use of non-deadly force, do you understand that Ms. Boone does not have to prove to you that she was acting in justifiable use of non-deadly force or justifiable use of deadly force? Do you understand that? Yes. Guess what has to happen? Juror number 3. I hadn't picked on you. What has to happen, sir? Do you know what has to happen? What do they have to prove? Yeah, you're really close, but this one's tricky. You're really close. You're almost at that. But you know what? The state has to prove to you that she was not acting in self-defense. Either deadly force or non-deadly force. Do we understand that? Okay, because it gets a little tricky when you think about it. So she doesn't have to prove that she was. Once the instruction is given, she doesn't have to prove that she was. They have to prove that she wasn't. Do we understand that? Can we all follow that? Is there anyone who thinks it should be a different way?
We'll talk about the connection with this, what he's asking in just a minute, you guys.
Is it anyone here, and I think a little bit of this man came up yesterday, that has ever been in a situation that either they were abused or part of an abusive relationship, or they know someone who was abused and part of an abusive relationship? Show of panels, please. Okay. And if I remember correctly, didn't we cover this yesterday and these things? All right. So I just have a couple additional things that I want to talk about when it comes to this. Folks, is there anyone who disagrees with this? That sometimes people are just embarrassed and don't want to talk about those situations. If you disagree with that, raise your panel, please. Do we understand that? Okay. Would you agree with this, that sometimes the person being abused tries to minimize the situation? Is there anyone who disagrees with that? Is there anyone here who either themselves, yourself, or knows someone who has stayed in an abusive relationship over an amount of time? Raise your panel. Okay. Is it anyone here who has ever tried to talk someone into leaving an abusive relationship? Raise your panel. Okay. Thank you. All right, we're going to start over here. Juror number 2. Without telling me who it was or what the situation was, did they follow your advice?
Yes,
In the end? Did it take a while? About how long did it take?
there were a couple of different instances. So one of them took about a year, and then another learned about it as they were getting out of it, but after they had been in the relationship for a number of years before I even met them. They ended up leaving after about a year and a half to 2 years.
Okay. Anyone else on this front row who had to paddle up? All right. Second row on this side. Anyone? Yes, ma'am. Did the person listen to you? The microphone's right behind you, too. I'm sorry.
No, they did not.
How long did you try?
Well, over a year.
Okay. Thank you, ma'am. Anyone else on this row? This second row? On this side? 21, can we pass the mic down, please?
I too found out late in the game, but when I did, it did take a little while, a couple months.
Okay. Thank you. All right. Anyone on the third row? All right. Thank you.
She left the person after about 10 or 11 years, but it was not because of anything I said. And I did talk with her the entire relationship.
Okay. Thank you. Anyone else on this third row? Fourth row? Yes, ma'am. Juror number 43.
One girl, I tried to help her, so I let her stay with me, and I brought her here to do a restraining order, but then it all fell apart. And then she was a mess, so I got her out of my life, but I don't think that it would have made any difference.
Okay.
And then I also know quite a few clients, not very well, but you see it happen over and over, and people usually don't leave.
Thank you, ma'am. Is it anyone else on this row? Okay, let's go to this side. Anyone on this side? Juror number 8. Where's our mic here? Here it comes. Yes, sir.
No, they did not leave the relationship.
Okay. How long did you try? talked to him?
Years.
Okay, thank you. Anyone else on this row? Yes, ma'am. Your
Same,
number, please. 13. Got it.
same years. And I think in most cases that I've seen, like it just has to be them that finally makes the decision. It doesn't really matter what you say.
Okay. Anyone else on this front row? All right, second row. Anybody? Juror number 28.
It was about 2 years. They eventually left on their own accord, but I was there and the support offered a safe place and they would go back. It has to be their decision.
Ma'am, thank you very much. Did y'all hear that? When they said it has to be their decision. Is there anyone who disagrees with that? Basically, it has to get to the point when they say they're done. Is there anyone who disagrees with that? Okay, thank you, ma'am. Anyone on the third row? Anyone on the last row? Yes, ma'am. Yes, sir. Where's our mic? Hey.
3 years, they didn't listen. The guy ended up leaving her. She would gladly go back to him probably today.
Okay.
That type of person.
Okay. And that was hard for you to understand, wasn't it?
No.
No?
Not as I grew older.
Okay, that's fair.
It's a much simpler place.
That's correct. Well, simpler in some ways, harder than others. Anyone else on this row? Yes. Juror 50.
My cousin is off and on in the relationship. The family knows. We've tried to talk to him. It's ongoing.
Okay. Anyone else? Yes, ma'am.
A colleague, and I talked to him for maybe a month, but they did it on their own years
Okay.
later.
Years later? Thank you. Is there anyone here in the panel who's ever had an injunction filed against them for no contact, that you couldn't have contact with a person? Anyone here? Excuse me? Somebody else, but not, it wasn't against you. Is that right, ma'am? Okay, thank you very much. Yes, sir. Okay. All right, and that was your wife, correct? Not yourself. Okay, thank you, sir. Thank you for your candor. All right, anyone else? Thank you. And that was jury number, what's your pallet number, sir? 15 and ma'am, 13. I got it. This term came up yesterday, battered spouse syndrome. There were some people who said that they were familiar with the terminology, okay? So I know that, and we've taken, we have that information, okay? But this is something that I want to talk about. Is there anyone here who knows someone, friend, relative, who just knows everything about anything, if that makes sense? Anybody show a panel? Do you know someone like that? Okay. All right, so there's very few people who know someone like that. Well, we all agree that there are just things in life that we don't know about, right? Anyone disagrees with that panel? Okay. Guess what? When my car breaks down, I'm going to the mechanic because I don't know a thing about a car. Okay. Now, when my AC or air conditioner goes out in the summer, I'm calling the guy as quick as I can because I know nothing about the AC. Do you understand that? Okay. So when the car guy says, oh, Mr. Henderson, it's going to cost you $2,000. You know, what do I want to do? Or what does a reasonable person? Well, what's wrong with it? Okay? But guess what? It gets to a point I have to rely on the car guy because I don't know about it. Do you follow me there? If I get sick or if anyone gets sick, where do you go? Do we have any doctors out here? Okay. Thank you, ma'am. And did you say that's the vet clinic? Do you?
Yeah, I'm a veterinarian.
You're a veterinarian? Yeah, I have a German Shepherd.
Except the patients don't talk to you. So.
Yeah. Yeah, I let him stay with some people who had dogs, and he don't even miss me. I've been here in Orlando all this time. But, so, what do you go to the doctor for? Yeah. Aren't you trying to find out what's wrong? Okay. Folks, there are some people under the law who become expert or known as expert witnesses. Guess what? Because they know about a topic more than we know about a topic. Do you agree with me there? Is it anyone who disagrees with me on that? Raise your paddle if you disagree. Can you all, by show of paddles, listen to an expert testimony and weigh it accordingly? Can you do that by show of paddles? Everybody can do that. Is that right? And guess what? You're not going to hear me say anything else about an expert because I really don't know about the expertise. That's why we have the expert. The expert can talk about it. Okay? We agree with that? Everyone agree? Okay, thank you. All right. There's been talk about fear and fears and what kind of fears people can have. Okay? If you disagree with this, just raise your paddle. Oh, no, let's do this. If you agree with this, raise your paddle. Okay? That some people can have the fear of not being wanted. Do you agree with that? Okay. Thank you. Anyone disagree with that? Okay. Some people can have the fear. Oops, excuse me. Yes. Thank you. Number 6. I'm not even going to ask you to explain it because I understand some things we just don't agree with. Okay. All right. Thank you, sir. All right. Some people can have the fear of not being good enough. Would you agree with that? Okay. Is it anyone who disagrees with that? Number 6. Okay. Thank you. Paddle number 6. Thank you. All right. Some people can have the fear of being hurt emotionally or physically or both. I said that all backwards, though, but you know what I mean? I should have said emotionally, physically, or both. Okay? Anyone disagree with that? Okay. Number 6? Good? Okay. Is there anyone in the panel by show of your paddles that's claustrophobic? Okay. Can we keep that up? We'll start on this side first. Juror number 3. Thank you. Juror number 34. Thank you. Jury number 44. Thank you. 44. Did you get it, Miss Andrews? Okay. Yep. You can put your paddle down there. Juror number, this side, paddles up, please. Juror number 9. All right. Juror number 40, juror number 51, juror number 53. Okay. All right. Thank you. Is there anyone here, maybe I asked this another thing, but let me make sure, who has a medical background? I don't mean a doctor, but just has a medical background. Okay. Let's do this. Could you hold your, we're going to start on this side over here. Could you hold your paddles up high, please? All right. So we're going to go juror number 5, juror number 16, juror number 18, juror number 21, juror number 31, juror number 43. Thank you. Anyone else on this side? All right. On the right side, juror number 51. Anyone else on this side? Thank you very much. All right. I have to talk about another topic here. Alcohol. It was brought up yesterday. Okay? So this is what I need to ask you. If anyone disagrees with this, just raise your paddle if you disagree. That alcohol affects people differently. Anyone who disagrees with that? Well, let's do it with agree. It makes it easier. I'm sorry, I get confused. I'm confusing people. Let's do it with agree. Anyone agree? Who agrees with this statement that alcohol affects people differently? Do you agree? All right. Anyone who disagrees with that statement? Okay. Now, would you agree with this? Who agrees with this? That sometimes people or certain people drink alcohol and they get happy and giddy. If you agree with that, raise your paddle. Okay. Sometimes people drink alcohol and just get downright mean. Do you agree with that? Raise your paddle. Okay. Anyone who disagrees with that? All right. Folks, sometimes there's people who don't drink a lick of alcohol and are just happy and giddy. Would you agree with that? Okay. Anyone who disagrees with that? Folks, sometimes there are people who don't have a drop of alcohol and they're just downright mean. Do you agree with that? All right. Thank you. Now, I think yesterday it was juror number 4. Juror number 4, correct? You drank, is that correct? And we talked about drinking yesterday, is that correct? Okay, let me ask you a couple questions about drinking. Have you ever drank and did something that you would not normally do when you're not drinking? Okay. All right. Have you ever drank and said something that you didn't mean or regretted the next day that you said it? You agree? Has that happened? If you even remember saying it. Correct? Has it ever been a time where someone had to remind you the next day or a couple of days later, you said something rude to me when you were drinking? Has that ever happened? Said things that you wouldn't normally say. Okay. They could be nice things. Yeah. Right. All right. So, is there anyone who disagrees with those things? Do we all agree? Here's the thing. Do we all agree that people can do things after they've been drinking that they wouldn't normally do if they were sober? Does everyone agree?
Approach.
I could stay entertained just watching the chat's reaction to the. You guys are hilarious.
I know, I'm reading through it. I'm trying to go back and read through some of the ones I missed.
Well, don't get into any that are too thorough, because we might have to check right back out again like we just did a while ago. That's the problem.
Yeah, I know. I'm just looking.
My fear. Doreen has a fear that the trial will never start. Paula, I don't see opening statements happening today either.
It's not going to happen today. No, I would agree with that.
Oh my gosh, y'all are too funny. Some of these things are just too funny. I need some water. Can I have some water, please? You think that's what she's asking? Can you make them stop turning the camera on me? Thank you. She thinks the bailiff guys are there like they're like pool boys. Yeah, I need to get can I get a frozen daiquiri, please? With vodka? Thank you so much.
The bailiffs,
Oh,
deputies I've interacted with would not like that a whole lot.
you know they hate her.
Oh, I'm sure.
Objections overruled. You may continue, sir.
Thank you.
I knew it wasn't gonna be long.
Is there anyone who disagrees that people act differently when they drink? Okay. Now, juror number 26. Yes, sir. Do you drink? Okay. Do you drink at home? Do you drink out socially? Okay. Are your drinking habits any different at home than they are out socially? Okay. You probably drink more socially, meaning more occasions or quantity? Okay, good. Is there anyone here who drinks more at home than they do out socially? Okay, thank you. Juror number 38. You drink more at home than you do out socially? Why?
Because I can stumble to my bedroom more than I can stumble to the car.
Hey man, that's A+.
Sign him up.
That's exactly it. That's exactly it. Is there anyone here who disagrees with that? Okay. Juror number 49. Sir, first of all, I'd like to say congratulations to you, okay, and continued success, all right? And I actually appreciated the story that you shared with us. I have a couple questions, though, okay? How long have you been a non-drinker?
Well, since 1987.
Since 1987? Okay. And prior to being a non-drinker, how long did you drink? How many years did you drink?
Probably 15, 18 years.
15, 18 years. If you don't mind this sharing this with you, when did it come to you that you thought or recognized that you had a problem with drinking?
Well, I was going through some difficulties with a wife that I had at that time. I was overseas. The last thing I remember doing was drinking 2 beers, and I evidently blacked out, and I embarrassed myself in the Air Force.
Okay. Sir, was there ever a time in your life that someone confronted you about drinking and you denied that you had a problem?
Actually, multiple ways, multiple directions. I had people telling me that I didn't have a problem, and I had people telling me that I had a problem.
Okay. Was it your drinking buddies who were telling you that you didn't have a problem?
Not only my drinking buddies,
Not
I
only
had
you.
commanders telling me that I didn't have a problem.
Okay. Were there loved ones telling you that you did have a problem?
No, actually, when I confronted them, telling them they had to stop doing that, they actually got a little upset.
Okay. Who was it who was telling you that you had a problem?
Medical personnel,
Okay. Did you listen to them?
initially, no.
Okay. Sir, can you tell us what changed your mind, your attitude?
To be honest, after numerous incidents, I know my family history. I felt it either I needed to stop drinking or just take myself out into a field and eliminate the problem before I actually hurt somebody else.
Okay. So you looked in the mirror?
Absolutely.
Is it anyone here who disagrees with the fact that there are people who are in denial about a drinking problem? Anyone who disagrees with that? All right, let me ask it in it this way. Would you all agree that some people are in denial that they have a drinking problem? Thank you. All right. This is what I need to ask you now as the panel, and I want you to understand. Because we've talked about how people act differently when they drink, or they'll say things differently, or they'll do things differently when they drink. Do we all understand that being drunk is not an excuse for your actions? Do we all understand that?
Really?
Okay. Raise your paddle if you agree with that. That being drunk is not an excuse for your actions. Do we understand that? Okay. Do we understand that in the state of Florida, there is no defense for voluntary intoxication? Do we understand that? So you can't come in the state of Florida and say, well, I did it because I was drunk. Do we understand that? Okay. Is it anyone here that would not hold someone accountable for their actions merely because they were intoxicated or drunk? Anyone here? Anybody going to do that? Okay. All right. Thank you.
Yeah, he should only have about 20 minutes left.
He has that much longer?
He said an hour and a half
You
to
ever
2
heard,
hours.
has everyone here heard the term by show of paddles, rush the judgment? A rush to judgment. Okay? Is there anyone here who has a story that they can share about them rushing to a judgment and it turned out that they were wrong? Anybody? All right, I have one. Tell me if you can agree with this. In a building one day, come out from the building, I'd done my shopping and stuff. I go out to the parking lot and I'm walking up to my car. And as I get closer to the car, I see that there is a dent, a big dent, in the back driver's side of my car on the bumper. So guess what? I'm mad now because it wasn't there when I left. So I'm going up to it and I see, man, it's only in my car. So I'm looking for a note and I don't see a note to see if the person left a note or information. So then I get to the point where now let me put this in here. Let me go and see if they have any video footage inside so I can see who hit my car. Okay? So on the thing of putting it in there, I clicked my key fob and the door wouldn't unlock. Now I'm really mad because they done damaged everything. Can't even get in my car. I go to the handle and I push with my thumb the button to get in and I can't get in. I said, oh man, this is just bad. So I walked back to the back of the car and I happened to look and I said, that's not my Florida State University license plate. Matter of fact, that's not my car. At the time, I was driving a black Nissan Maxima. At this time, this car was a black Nissan Altima without a Florida State license plate. Would you agree with me, folks, that sometimes everything that needs to be investigated? Is there anyone who disagrees with that? Okay. Would you all agree that there should be a full investigation before a decision is made? Would you all agree with that? Anybody, by show of paddles, who would disagree with that? By show of paddles, who agrees with that? Okay. You know, when I found my car too, which was behind me over there, I was relieved. But then, you know, I thought maybe that car was like that beforehand. All right. Now I have to talk about one of my, well, it's one other thing I talk about. Remember yesterday there was conversations about you being the, as the jury, you sit in the position of determining what the actual facts of the case are, okay, what the actual evidence of the case are, and you have the great power of giving evidence its weight. Some you can consider greatly, some you could give less weight to, or some you have the power just to ignore it all, and you don't even think it's important. Do we understand that? That's your power as jurors. So it's talking about, one of the things we're talking about, one of the things too, you're going to have to determine credibility of witnesses. Okay? Credibility of witnesses. And they talked about some things, and the state talked about some things. Would you like to look at them? Would you just be able to hear them? Or could you be comfortable with that? All right? The judge will read an instruction when it comes time, and I want to know if everybody can follow this instruction. It's going to be weighing the evidence, and the judge is going to give you a series of things that you can use in determining which evidence is the best evidence, which evidence isn't so good, or which evidence you don't find credible at all. Do we understand that? Okay? But I want to focus on one of those. I'm telling you it's more, but this is the one I'm focusing on. Weighing the evidence. Does the witness testimony agree with the other testimony and the other evidence in the case? Do we understand that? Okay. Does the witness testimony agree with the other evidence, the other testimony, or other evidence in the case? Can we do that? Is it anyone who feels that they're not capable of doing that? All right? Now, when we say other evidence, we're just not talking about other testimonial evidence, because evidence comes in different forms. Okay? There could be physical evidence. Do we understand that? There could be scientific evidence. Do we understand that? Or there could be expert opinion. Do we understand that? Can you weigh all those things, follow the law, and make a fair and impartial decision based on the law? Correct? And based on what else? That high standard of proof, the highest that we have in our country, beyond and to the exclusion of a reasonable doubt as to each and every element. Can you do that? Guess what? Two more things, I think. I'm going to check with co-counsel too. But two more things, basically. One is this. I'm going to date myself here. Or I'll just go ahead and tell you, I'm 63 years old. Okay? So, and in fact, when y'all had the opportunity to meet Lauren Henderson, okay? She's not my wife. She's my youngest daughter. We are related. Okay? So, and actually, she's an attorney now. She just finished law school and passed the bar. So that's why she's assisting in this case today. Okay? So that's the relationship. But when it comes to weighing the evidence, this is, no, I'm sorry. I'm past weighing the evidence. I was getting emotional. Anyway, this is one of the things, and she has to help me with it. That's where the age difference comes in. It's called social media. Okay? Guess what, folks? I do not have a Facebook page. Quite frankly, until it started becoming prevalent and people looking at them and stuff, I added it onto my board hour thing because they had to tell me, my staff had to tell me what the forms of social media are because I don't know them. Facebook, I guess YouTube's one too. I thought that was TV. But Twitter, Snapchat, TikTok, Instagram. Okay? So I become familiar with these things, but I'm looking for something. I'm looking for someone who lives their life on any type of social media. All right? And this is what I'm talking about. So if you're this kind of person, I want you to raise your paddle.
Did you say who lives your life not on social media?
No, who lives your life on social media. Okay? Who lives your life on social media. Well, you'll see with this example. Okay? That's it. Some of y'all are getting nervous, I can tell. You're getting nervous, but here we go. Here we go. 6 a.m., just woke up. 6:10, headed to the bathroom. 6:20, man, I really don't want to go to work today. 6:35, darn it, let me go in here and see what I can have for breakfast. 6:45, darn it, looks like either Fruit Loops or eggs. 7:05, darn it, I still don't want to go to work, but those eggs I had were really good. Okay? 7:30, I better head to work so I don't get caught in this traffic. All right. Anyone who leads their life on any form of social media or texts anyone to that extent, would you please raise your paddle? Okay. Remember that word for dire? To speak the truth. Now watch this. Is there anyone who knows someone that does that? I always get a yes to that part. I always get a yes to that part. So no one who knows that way. Is that correct? No one who does it. Okay. Judge, may I approach a minute, please? May we approach a minute?
Yes.
Hey, Kay, I saw your text. Be right back. Gonna send Sarah a DoorDash pizza. I'm gonna send a DoorDash pizza to her defense team so she has to sit there and watch them eat it and she can't. Oh gosh, you guys. Did he did he did ask the question, is anyone here claustrophobic? Or are y'all just saying that in the chats? Did I miss it? Did anyone hear that? I wrote it down, but I wasn't sure if it was y'all were saying that or he was saying it. And I'm confused as to why he's talking about at the beginning he said something about how do you feel about the defendant not taking the stand and speaking for herself. Now, I will say that the prosecution asked the same question. So I kind of wondered, are they they have plans for her to take the stand still. I think they just have to ask that question just in case.
They ask it in any. I feel like they ask it in pretty much every single case. Whether or not you would be biased against someone
Thank you, Your Honor.
who did or did not take the stand in their own defense.
All right, the procedure. When you get here, if you're on a jury, when you get here, you're going to have to turn your phone off. You're going to have to leave your phone off, okay? I think they've been having y'all do that now. Is that correct? All right. During deliberations, you got to check the phone at the door, okay? You're not going to have it. Everyone understand that? Who's going to go through withdrawals? I need to know. Who is going to go through withdrawals? That means you're not going to be able to text someone. You're not going to be able to get on the phone and see who's trying to call you. Well, you're not going to be able to put that last post on there. Do we understand that? I mean, back in the day, guess what? We used to have to ask this question about cigarette smoking. Okay? I think they allow breaks for cigarettes. I don't think they allow phone breaks. Okay? So is there anyone who is that tied to their phone that they're going to be worried about that phone and not worrying about the evidence and the case and the testimony and everything else? Yes, sir. I'll defer to the judge.
I can answer that question. So if you are selected to serve as a member of our jury, an emergency phone number will be provided that you can provide to any loved ones or friends or family. And in the event there is an emergency situation, they can call that number and we will get in touch with you. Thank you.
All right. Judge, can I confer with counsel?
Yes, sir.
Real quick.
Aiden says, has anyone accidentally, not intentionally, but also totally on purpose in self-defense, like put someone like in a suitcase, like while drinking? I added the likes. Sorry, Aiden.
I mean, this is crazy.
Well, we're going to talk about why he's asking about the weapon, okay? We're going to talk about the pew pew in a minute.
I'm back on? Okay, I'm back on. There we go. You know, in our little courthouse in Santa Rosa County, you don't have to wear a mic. You know, you just, everybody said, oh, we got a new courthouse, but it's nothing like this.
Bless you.
Okay. Bless you, sir. All right. Great escape clause. I don't really think anyone has said today that they couldn't be fair or it's anything, but I know you've been responding to questions. This is what I want you to do. I want you to think about it. And if for some reason, it could be anything, okay, that you don't feel comfortable about sitting on this case, if you'd raise your paddle and let me know. But let me give you some examples because I don't really, before you do that, it could be the fact that you don't like the fact that I move around. You don't like the fact that I look. You don't like the fact of how I sound, okay? You don't like the fact of, darn, Mr. Henderson, what were you thinking about when you got in the mirror this morning? Okay, that don't match. It could be that. Folks, it could be as simple as this, that you think my hair is way too long. Okay? But now, or it could be something that you don't like about Mr. Owens, that you don't like about Miss Boone, that you don't like about Mrs. Henderson.
and that you don't like about Mr. Beck. Miss Andrews is a little sensitive, so I won't say it, but you can consider that too. Okay? So at this time, if you feel uncomfortable, would you please raise your paddle at this time? Okay. Number 40. All right. Thank you, ma'am. Anybody else? All right. Folks, I want to thank you. I want to thank you on Miss Boone's behalf. I want to thank you on our team's behalf. People here have made us very comfortable. Sometimes it's hard going to a different place, but everybody's been very friendly. Y'all have been very attentive to me, and I really appreciate it. And I want to thank you on behalf of me, our team, and especially Sarah Boone. Thank you. Judge, that's all the inquiry I have.
Can the parties approach for a moment?
Yesterday was an AA meeting, Pinky, not today. You should have heard yesterday. It was like, oh my gosh. I could not believe how many people are affected by alcohol.
I'm telling you, it's you learn it's very personal. It's the craziest thing. It's like people are in therapy or something.
I'm gonna have a good day when they concur. In fact, you know what? That's what I'm gonna put on the thumbnail for the Senate thing. It's such a good day. Join us for sentencing, the live sentencing of Sarah Boone. Remind me to do that, please.
Oh my gosh. Somebody said something in the chat that I really, really appreciate, and I didn't start it, so I don't know who it was. But when people were saying they thought I was pro Sarah, somebody said, Sam is not pro Sarah, she's pro justice.
Oh, I think that might have been Yana. And I think I unstarred that, and I didn't mean to. I apologize. We have the absolute best chat. I mean, I know we have a lot of people that just listen. I call y'all lurkers. That's okay, because I usually, when I go and watch another channel, I'm a lurker. I don't usually chat, but we have the best chat. Sometimes I think people come here for our chat more than me. That's okay, though. We have great chat peoples. No, Sam is totally, trust me, in private talk, Sam is not pro Sarah. I've
Members
had
of our
private
jury,
discussions.
Thank you so much again for your time, your sacrifice, and your attention. Most importantly, your honesty in answering the court's questions, the state's questions, and the defense questions over the last couple of days. We're going to excuse you for a few moments while we decide who may be able to serve as members of our jury in this case. Please do not leave this floor. There may be some of you that we need to speak to on an individual basis. And again, I'm going to give you a similar instruction that I've given you as well over the last couple of days. Please don't conduct any independent investigation or research regarding the charge, persons, places, or things that are involved. Do not have any communications with anyone else or amongst yourselves about any of those things. One last thing. You may see the state attorneys for the state and the attorney for defense outside, maybe in the same elevator as you over the next couple of weeks. They're not allowed to talk to you, and they may look away from you. They're not allowed to communicate or have any interaction with you whatsoever. If you make eye contact, they may shy away and look away from you. I promise you, they're not doing it to be rude or insensitive. They're just trying to avoid the sense of any impropriety while we conduct this trial. With that, I thank you again for your time and your sacrifice, and we'll bring you back in as promptly as possible. Thank you.
Thank you, Sam, for the 5 memberships. Is that UPI, Sam, or is that a different Sam? I think that's a different Sam. Because yours is Florida PI, Sam, right? Oh, wait, where'd she go? Oh, she might have gotten a phone call. Sam got booted. She'll be back. Chi-Chi. There she is.
I think the internet went down.
Oh, I was like, please tell me I didn't boot you by accident. Did you see? That's not your gifted memberships, is it? That's a different Sam.
No, that's a different Sam.
Okay, well, thank you so much, Sam. I appreciate you for doing that. That's so kind of you.
Y'all can be seated. Thank you. We'll be off the record for a few moments for y'all to review your notes, use the facilities, take 15-minute recess. It is 3:30. We'll see you all at 3:45, and we can address any individual voir dire or charging conference at that time. Court's going to be in recess. Thank you.
So they have to do individual voir dire now. I
No.
forgot about that.
Are they doing person by person?
He said that. He just said, we'll discuss any individual voir dire.
Any individual. So remember that a couple people had said that they had things to tell, but they wanted to do it in private.
Oh, okay. That's what that's
Did you
about.
hear
This-
what I was saying about the comment somebody left about me?
Yeah. And I
Okay.
told him, oh, you missed what I said. I told him that I've talked to you many times in private, and trust me, I know she's not pro Sarah.
No, I just love that somebody thinks of me as being pro justice, because really that's just the best. So I really appreciate that.
Yeah, that's true. Because she talks a lot about how there are some defendants that she's run into that shouldn't be in the position they're in, and it's sad. And it happens
Yeah,
way
that
too
is.
often.
There are.
You know, I can't watch those documentaries and stuff about people that I get too broken up over that stuff.
The wrongful convictions.
Yes.
Yeah.
Sad.
Yeah. I think I have one sitting in the hallway.
Thank you, TT. Let's go up here to the starred comments that we have, Sam. We've got somebody
thank you. Okay,
says,
sorry.
I'll put them up and you can answer them. Sam, is this just a new jury panel? What are they doing right now?
Narrowing things down. This is the same panel as from yesterday. So yesterday we heard the state. Today we're hearing mostly from the defense. All from the defense?
Had said, yeah, today's the defense questioning. And then I had said that I thought there was 51 jurors left. I think there's 50 left. I think I was incorrect on that. Carrie and Sam, you both deserve medals or scented candles or a lifetime supply of C's candy for listening to this. Oh, thank you so much. I don't know if I've ever had C's candy before.
Oh, you haven't?
Who makes C? What kind of candy is it?
C's. That's the I feel like they make
like
chocolates or butterscotches or something like that.
Oh, okay. Okay.
Maybe it's a Midwestern thing. I don't know.
Maybe. Why only 6 jurors in Sarah's case, but 12 in Wade Wilson's case in Orange County?
Okay, so Wade Wilson, I double checked this. Wade Wilson was Lee County because he's Fort Myers. And you know what's really super scary is some of that happened right where I used to have a business.
Oh, that's right.
Terrifies me. He had 12 because he's death penalty.
Death penalty. There's the key word.
Sarah is second degree murder. Second degree. Manslaughter. So she gets 6.
No, she's not manslaughter. She's second degree murder. She had a plea for manslaughter.
Is it murder? Okay.
Yeah, it's second degree murder. She had a plea that was offered for manslaughter. She turned that down.
Okay.
So yeah, this is for second degree murder. How can she claim self-defense if she admits to being the initial aggressor? She never admitted to being the initial aggressor. That's the problem, Tommy. Is it Tom? Yeah, Tommy. Is that what it is?
Tommy.
Yeah, that's the problem. In fact, she's admitted to very little, actually. So, and then I start some other stuff in here about speaking of how she was or whatever. How could she go to sleep if she was in danger? If she felt like she was in danger? Exactly. And the other one was what Kay said. If Sarah doesn't remember taking the video, then how can she remember how she felt afraid for her life and remember hitting his hand with the bat? Right? And also, Kay, how could she remember how far she zipped the suitcase up? See, none of that makes sense to me. If she was that drunk that she doesn't remember zipping the suitcase or doing the videos, how could she remember all those other details? I think those details were fed to her. I don't think those are. Yeah. What do you think, Sam?
I don't know. I honestly don't know.
That makes me so angry. When I think about it, it just makes me so angry.
I've been trying to think if we talked about it at all when I met her and what she said, and I know she didn't say anything about the bat. I know for a fact she did not.
Not initially, she didn't.
No, I know it didn't. That's why I was so surprised the other day, because
Yeah, that was
during my interviews with her, it was more about, well, Sarah, of course.
Yeah, like, how did she come up with a memory of the bat all of a sudden?
I don't
And
know.
and I think we were talking about that. It's like, was that her? Because remember, I feel like that what they did was they were pinning her down on the questioning, and they said to her, "Sarah, how do you remember that you didn't zip it up all the way? You didn't even remember taking those videos." And she goes,
Mhm.
"Well, because of the bat, because I remember his fingers were sitting out. I remember his fingers were sitting out. How do you remember his fingers were sticking out?" Because I got a bat and I hit him. You know what I mean? Like, I could totally see her doing something that stupid.
But she didn't
Um
say it, right? Until the other day about the bat, because I was
No.
surprised, or else I just haven't been paying attention.
She didn't see it until the other day, or she didn't say it until she said it in the I think when she was being questioned by the therapist, like one of the
Right,
therapists, I
right,
don't know which
right.
one.
Okay, that's when that came out, right?
Yeah.
Because she never said it. She said, as far as I can remember, and when I left the case, I gave all my stuff back to Billy. Far as I can remember, that was brand new information to me, because if you go back to our salacious speculation stream, I even said that I wasn't sure where the bat came into play. I thought he went down the damn stairs.
We were even questioning whether or not the bat was used at all.
Yeah,
Period. I mean, a lot of people
exactly.
were making, and we still don't know if that's the limited extent
Yeah.
of the bat's use.
We may
There could
never
be a lot
know.
more. We might not. Yeah.
We might not ever know.
The video shows just how scared she was, and I know Tracy meant that as a very snarky
Sarcasm.
comment, and I agree with you. Yes, sarcasm
Yeah.
completely, and we agree with you absolutely. Seriously, Sam, what do these pew pew questions have to do with the case? Why are they talking about weapons?
I think they're talking about self-defense in general, and
I
what
do
people
too.
believe in terms of what you're allowed to do if you feel challenged.
I was looking at it like the defense would think that they would want a juror who owns a gun because they would and says that they would use it for
Mhm.
self-defense.
Mhm. I think
So
so.
they're okay with doing something to defend themselves with. I that's where I thought
Makes sense.
anyway.
That makes sense to me.
But yeah, it was kind of the way he was doing it was kind of like, what, huh? The other question was, let's see. Oh, honest, genuine, fierce. Never let anyone restrain you, and God, please do not get inside a suitcase. Never let anybody restrain you. Never.
Mm-mm.
Beyond your will. Beyond your will. I think that's the key word there.
Mhm.
There must be a method to Henderson's madness, and only he knows what that is. He's got a method. Have you figured it out, Sam?
I'm in, they always have a method, right? And he's been sort of the DV person in this whole thing. So I would imagine, I mean, this voir dire has been so extremely detailed that I imagine a lot of time went into it. And then the defense got a bit of an advantage because the state went yesterday and they got to go home. The defense got to go home and think about it, what their questions were going to be.
A lot of yeah, but I don't know. I felt like there was a lot of the same questions. Like it in a way, I saw there was some teamwork there between the defense and the prosecution. I know there really probably wasn't, but like the prosecution covered the whole alcohol thing. I think more than
Right.
He touched on it a lot today, but
the thing is, you want to ask the same question in a whole bunch of different ways because people don't process information the same. So somebody could ask you a question and it mean one thing to you, and I get a completely different spin on it.
That's true. Very true.
So, I mean, I think that's what it's getting at is, I mean, there was one case where the jury didn't know what the word unanimous meant. If you can imagine that. So I think you can't, I don't want to insult people, but at the same time, you can't assume that everyone understands everything that's being said.
Well, and
Does that
you
make
know
sense?
what? Yeah, no, I get that. And sometimes I question how long they keep juries without moving around a lot, because it's like, you get tired and you kind of you tune stuff out, and I feel like after a while of jurors just sitting there listening, there could be some really important testimony they're missing after sitting there for 4 or 5 hours or whatever. I don't know. I just
So during the actual trial, I would be surprised if they sat for that long without any kind of moving around. I feel like that's changed a lot. Where people they'll be like, get up and take a stretch break or whatever.
Yeah. Yeah, I agree. Did you want to talk to Sally Bragg?
There was a comment somewhere. Oh,
Thank-
yeah. She said she's a PI too, and I think she said she was in Florida. So, nice to meet you, Sally Bragg.
Do y'all ever have PI meetings and get together and chat with your educational seminars and stuff?
Actually, there are several organizations that do that. I have not participated.
Route Irish wants to know, why is it the professional people rarely get picked for jury duty? Are they afraid of intelligent jurors?
Well, depends on what you mean. Like, because we look for people who are critical thinkers. So that's something that we pay attention to. So if someone is any kind of a critical thinker, no matter what their job, then we're probably interested. You just don't want lawyers. And in some cases, maybe not medical people.
And
Don't want law
professional people,
enforcement.
well, professional people could be a huge range of things, but a lot of the times the really professional people, they'll just throw an excuse out there to get out of the jury duty, period.
Right, like having a trial start next door to the trial you just got summoned for.
Exactly. There's a
Mhm.
lot of, professional is a broad, it's very broad, in my opinion. When I think professional, I think anybody that wears a suit to work every
Yeah,
day.
I think he's meaning anybody that's, like, maybe not in the trades,
Mm-mm.
but I don't know.
Thank you so much, Emily, for your super chat. Oh my God. Emily. I don't even want to say this out loud. She probably is. She's that lady that walks past you in the grocery store and does a silent and then keeps walking and leaves you standing there like, what in the hell just happened? How dare you? How dare you? Thank you for your super chat, Emily. I'm disgusted by you at this point, though. Thank you, though. Emily. You're so wrong. Y'all are so wrong. I should not encourage you guys so much. Y'all are going to get me in trouble one day. We're going to be reported by you. We had another person come on last night and said they were reporting us. I don't know why. I think they said they were reporting. I think they were mean and we wouldn't allow them to be mean. And so they got mad and said they were reporting us. That happens a lot, though.
I keep
what?
Go ahead. I'm sorry.
No, I was just saying Laura's not putting up with it. Her
Good
and
for
Bama.
her.
And Bama's gotten to where she hits that button. She's like, nah.
I've been getting these emails that are meant to be extortionist emails. Like, don't make us call your number. We know you're watching porn. We'll expose you.
What?
Send us Bitcoin. Yeah, I've been getting these emails. And so I just go, I send them to the FBI cyber fraud unit, which you can do, by the way.
Oh, good.
And so every time they send me one, because they're carbon copies, and then there'll be a screenshot of what's supposed to be like the outside of where I live. And I always write back and say, thank you so much for your letter. I just forwarded it on to the FBI cybercrime unit.
Well, see, here's the thing. Like, what the hell are you looking at on the internet, Sam, that's coming up?
I'm not. That's the funny part about it. So, like, I sat there and I read the letter, and I'm like, no, I don't do a single one of these things this person is saying. It's just it's the latest scam, But they were like, they had my name, my address, my phone number, and I thought, where are they getting that information from? And I think it came from owning a business in Florida.
Oh. One time when I was at my job, when I was doing commercial insurance, there was a day, because I used to have to research a lot of properties and stuff. So, like, let's say I was trying to insure a building or a business that a building or business owned. And I'm having to do a lot of research in the background. And I did a lot of sleuthing in that to help find questions that I needed to fill in the gaps with when I talked to the client. And one day I came across a porn site. I don't know how I did. Don't know how I did. So I immediately got up and I was like, oh shit. So I immediately got up and I went to the human resource lady. I'm like, I'm just going to let you know now that I just hit a porn site and it wasn't me. I didn't do it on purpose. It was supposed to be this. This is exactly what it was supposed to be. And she just thought it was freaking hilarious. And I'm like, well, I just don't want you to get in trouble. I don't want anybody to think that that's what I'm over here doing.
Right? Um, back in the late 90s, I was teaching like computer stuff to older people who wanted to learn to use the computer. And one of my favorite examples was that at the time, and I don't know if this is true, but whitehouse.com was porn. You needed
Really?
whitehouse.gov. Yeah. This is before. You see the
Oh,
difference? So
yeah.
anytime anytime you get an email, check to see where it's from, the dot part, because the .gov is critical. Jeannie or Ginny, I
Jeannie. I
like
think
your
it's
gray
Jeannie.
hair. Mine's getting there. How long does this next part take? So what I was trying to explain to Carrie, and I don't know if I can explain it very well, is you don't get to randomly pick from the ones that are left. They are, it's like as they are stricken, the next they just slide together. So like let's say 1, 2, 3, 4, 5, and 2 and 3 are gone, then you still have 1, 4, and 5. And so but when you hit your number that both sides agree on, when you've got those first 6 that everybody agrees on, that's your jury. Does that make sense at all?
Yeah. No. Well, when we look at this one piece of paper, which if I pulled it up again, which by the way, I wanted to tell you just really quick when you were talking about the site. There are sites now out there, you guys, where you can put in it's free. You can go to these sites and you can put in the URL of where people want you to click. Like if you get an email from somebody and you're unsure about it, and you can check the site. I found one earlier today, which by the way, I wanted to ask Bama if she sent me an email of a link because I got one from a number from North Alabama, and I was wondering if it was her. I have not opened it. Okay, here's
Okay.
what you're talking
Yeah.
about.
So at the bottom left-hand corner would be like number 1, for example. And the reason this is so blurry for anybody who's just seeing this, no, alternates are also chosen at the same time. Anybody who's just seeing it, it's blurry because it came from an actual trial, and it's got people's information in it. So like you see the first 2 are X'd out on the bottom left-hand corner under the banner. So then if we were picking 12 because it was a capital case. Okay, so we X'd out 1 and 2, so they were struck. And then if 3, 4, 5, 6, 7, and 8, I don't think they all stayed in. I think these are big strikes that everybody agreed on. But the first number, whatever number you're trying to get to, whether it's 12 or 6, the first time you hit that number of people, that's your jury. You don't get to go up to the top and say, well, I like that person. I like that person from the middle.
Mm-hmm.
Does that make sense, chat?
No, it
Does that make
does.
sense?
I was wondering, okay, so I have a question about that then. So when they're going to pick the jury, do they put everybody's name in a pot and they draw for the first 6 and that's who's on it? How do they figure out who's alternates and who's not?
No, it just goes right in a row like that.
Okay.
So let's say that 3, 4, 5, and 6 make it through. 7 doesn't. 8 doesn't. We pick back up at 9. That one makes it through. The next one doesn't make it through. You go to number 15. That one makes it through. 16, 17. It's like you're just removing a square and sliding the ones that are left together.
Which is interesting. So you don't want to be a lower number juror.
Well, they give out random paddle numbers or random numbers, and I'm using 1, 2, 3, 4, 5, or 6. I don't remember. Those are seat numbers. Okay. So on the chart, seat numbers start at 1. And then each juror has a different number. So it wouldn't matter. So that somebody couldn't do what you're talking about.
I'll be right back. I'm grabbing a soda.
Okay. Elimination and not by selection. Thank you, Lotus Spider, for saying this simply. You cross people off, you don't circle your favorites. Very good. Thank you so much. Sometimes I just cannot get the most simple explanation out of my mouth. I know. So Tracy Clifford, you're saying that if anyone saw your Google history since you found out about this case, you think you might be in trouble. My internet provider loves to throttle my internet, block me from going to sites. They say I'm a bot. And if anybody ever looked at my history across 5 different browsers, they'd think I was trying to plan the murder of the century. And I've called them and said, stop this with what I'm doing, because I'm not a bot. I'm an investigator. I'm batch looking for information. It's crazy.
I'm looking for more questions. Hang on.
Yeah, it doesn't look like
I know.
anybody's
And you should have said fort for the Emily. You should have said box fort. That's hilarious. Thanks for your super chat. Oh, my word.
So the next part then is going to be they're probably questioning or will question the ones that didn't want to spill their stuff in private or in public, right? So that'll be that. And then my guess is that the next part is the battle of
the different strikes.
Yes.
Okay, so hopefully we'll get
They'll
to watch the battle of the strikes. I don't know if we
No,
will or
I
not.
don't believe they will, but I could be wrong. But that's kind of I don't, Carrie, I don't know how they would stream that with sound.
Bless you.
You hear the court?
Yeah. They're back on, y'all.
Ms. Boone is seated at counsel's table wearing the same clothing from this morning. All right.
And then they just went back again. So we know for a fact there's not gonna be any opening statements today. We think that it could be possibly tomorrow following the hearing, if they can get this done tonight with the jury. If we can get a jury tonight, which I feel like we're so close, then we should be able to have that opening tomorrow after the motion. I can't think of anything else on there. Can you, Sam, that they would need to do?
No. So, and I was just going to say, I don't know that they would stream with sound this part where they are trying to do the strikes, because if you focused on either table, that's like attorney-client information that you know what I mean? Like strategy that you're trying to do there on who to strike and who to keep. Does that make sense? Like, that's not a public discussion. That's a we huddle all around and whisper kind of discussion.
You should text Billy and ask him if he needs a gas mask right now.
I'm not going to do that. He's got his phone on silent anyway. I think he gets stuck putting up with her. She's probably telling him which one she doesn't like.
This is what I want to do, Billy. Look at her. This is what I want to do. This one right here. This one right here. I want this one. Make it happen. Make it happen. She's like the little girl on Charlie and the Chocolate Factory. I want this one.
She's just bossy.
Yeah.
He says she's not being like, she's not in a bad mood. She's just bossy. Because I asked him if they were arguing. If she and Owens were arguing. And and he said not.
Owens is like, look, I already got one damn wife. I don't need another one. Oh, look at her getting flirty with Billy. I think she likes Billy. I've been thinking that for a while now.
She might, but it's not reciprocated.
Well, she's been like, remember the day that she came in all smiley and giddy since she'd been working with Billy? She's been all, and she hasn't smiled like this talking to her attorneys, other than the female attorneys. But Billy might have a way with people that just makes you feel that, nice and at ease and stuff. You never know. Does he the type of person you feel like you can open up to, Sam?
He's very quiet normally.
Quiet people make me nervous.
He listens. Yeah, I guess when you get to know him, you talk to him for a long time, but I honestly, I've known him since 2019 and I don't know much about him personally.
So he keeps everything business.
Yeah, I mean,
did find out that his website is called We Are
The Essentials.
The Essentials, and I found some stuff I was gonna use it as a filler, like during trial, if we ever needed to look into it and look at some of the cases and stuff they were following.
Parties
They
can
actually were
continue
helping with some
reviewing
big
their
name
notes before we
trials,
proceed
missing people.
with selection in this matter.
Yeah, they're very
As
good, and
addressed
he'll
at the
give you an
bench,
interview,
we
I
will
think.
begin with jurors seated in seat 1. The state will have the opportunity to accept or reject those persons seated in odd seats. Then it will proceed to the defense for all even seats to accept or reject. Both parties have 10 preemptory challenges.
I'm wrong.
selecting
I'm wrong. They're going to stream it.
Once we have that panel of 6, backstrikes will be permitted. If there are no backstrikes, we will then proceed with selecting as many alternates as possible.
I just missed what he
Parties
said.
are ready to proceed with selection, please let me know. We'll be off the record.
Exactly what I did. They're going in person by person, number by number.
Okay. So they're doing individual, each person. As when they're going to call each person in. Each person they have a question on, right?
I don't know that they're calling people in. Like, the jury is normally not present for that portion. There's no reason for them to be. It's just the attorneys working. And then they dismiss all the jurors that are not needed, and they bring the ones they picked in and swear them in. Do you see what I'm saying? The jury doesn't need to be here for this part. This is like you're trying to be strategic, who you want, who you think they want, who you're trying to keep off.
No, but I thought they told them to sit outside and hold on, because we might have some questions for you, because they're going to sit here and go through their strikes, and then they're going to whittle it down.
Right. Well, so they might have specific questions for a specific juror. But they're not going to bring every single one of them in. Jurors have not always been 12 people, no matter what the crime. This is Florida. Florida capital cases are 12. Sarah's not charged with the capital case.
Laura, I wish I was over there eating up on that slow cooker you got going on. I would love some soup today. Today would be a wonderful day for me. Yes, a huge thanks to Trial TV Live. Please make sure you go over there and subscribe to them. I've got their number. I've got their link up in the comments, up in the chat pinned, so that you guys can go over there and give them a sub. They're doing a lot of stuff for us in the background that we're not getting this off of Law and Crime or Court TV. So thanks to them, we're able to see this today.
Yeah, it's great.
So he said they were going to pick the jurors just like you had said, starting at 1
He
and
said
going
it. Yeah.
Okay. So then what they're going to do is they're going to sit here and do their little back and forth. And then they're going to narrow that down. And then they might call each juror in that's left with a couple and ask them a couple of questions.
If there was an issue, but he also said once the panel of 6 is up, then they will do backstrikes if anybody has them left. So
gotcha.
If you haven't used up all yours by the time you get your number of people, then you can go back and strike, and then you'd have to take the next person in line, basically.
So now I get why. Let me throw this up really quick. Now I get why they start at the top, because
No,
you're
we
going to
start at
use
the
up.
bottom. Start the
Oh,
bottom.
but
On
it's
that
to the
chart, we start
bottom's
at.
one.
Mhm.
Okay.
And then you
So
go
then,
across.
and then they. Okay, hang on. Take this off the thing, and then they pick. That makes sense. Okay. Oh, does my sister not know I'm live streaming? Let me text her and tell her stop calling me.
I had to tether myself to my phone to come back on.
12. Oh, so you lost your internet completely at the house?
Mhm.
Oh, that sucks.
Yeah. But when the power was out and the internet was out, I called up the mobile phone company and I said, "Hey, I'm going to need some high-speed data here, please. Are you going to give it to me for free? I live in a disaster zone." They said, "No, that'll be $25."
We need a lip reader for the accused. Yeah, because we were talking about yesterday. We were talking about Olive Garden. Now I want Olive Garden soup. I've been craving that. Monday, I don't know. No, because I
No,
figured
I don't think it'll be Monday. I think
it'll happen tomorrow.
Opening, there's a really, 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 really good chance it's tomorrow. I think he's going to try really hard to get this jury sworn today.
If they can do that today, then yeah, in the morning they'll have the. Oh yeah, think about that.
So they'll have to finish up the little bit of motions. There was a question in the chat about the motions.
Is it still there? Did you store it?
I don't think I did. But somebody asked if why there were still motions going on. Is this normal? And yeah, it is. Even, I mean, they're on a rush schedule, but there's still stuff going back and forth. There's still motions being argued, motions eliminate, witness lists updated. Oh, and even depositions. So one time during trial, the state took the telephone deposition of a witness we wanted to call the next day. So things happen like that, And the federal government, they love to drop last minute stuff on you. Like last minute. Which makes my job so much fun.
Are you telling Soleil Souffle? Are you saying that she looks like one of the Hanson twins? Not the Hanson twins. The Hanson
They were
brothers.
triplets. They were brothers. Yeah,
Three
they
of them.
came.
Yeah,
I saw them recently on YouTube. They played.
They're adorable.
They played their
they're grown up
MMMBop
now.
song.
They're still out doing stuff. I don't know why they're not getting more. They're still just as cute as they can be. Oh, they were on. Do y'all ever watch that one on Fox? Is it Fox? The Masked Singer. Do y'all ever watch that? I enjoy watching that.
Mm-mm.
I do but I'll fast forward through a lot of it. But I like to find out who's behind the mask. Sometimes I'll fast forward to find out.
Deanie Cole Holland wants to know how and why I know Sarah, because I'm a licensed private investigator in the state of Florida, and I used to work for Billy Lane, who is her investigator, and I was on the case with him. And then I got off of it because I'm like, you really don't need any help. You're handling it all yourself. And I had other stuff to do. But I did spend about I estimate it was about 8 hours with her in person at the jail that I will never get back.
Cass said they do this so different in Brooklyn.
Kathleen, AT&T gave her free mobile data for the month because of being in a disaster. Well, T-Mobile did not. They just didn't. And I'm not happy about it.
Oh, Jeffrey's got a good question.
Yep. When the jury, that one?
Yeah, did you talk about that one? Because I feel like that one's kind of, they could at any point during the trial, they could still offer a deal outside of court. Like it just won't be on the record.
Has to offer it. State has
Right.
to offer it. like Sarah can't just say, "Oh, hi, judge, I'm ready to take that plea now because I don't think this is going to end well for me."
Right.
That can't happen.
And the state could come back and go, okay, yeah, but the deal has changed now.
Yeah.
Right? Because the
Sure.
plea deal is on the table for only so long.
It went on the record that she rejected it. So that means she can't go back and take that one. She's going to have to take a new one if offered.
Debbie, I am so sick about this whole ad thing today because I specifically went in today and tried to fix it to where you guys weren't getting that many ads. I don't know what the hell is going on with YouTube. I feel like they're forcing everybody to buy YouTube Premium. I really do. Because I don't know any other way to do it. And I don't know how to manually put ads in there while I'm in the stream. I don't have enough manpower behind me to do all that. So I don't know.
Leah, I'll tell you the story sometime of getting the Mbop CD and how my friend and I were so embarrassed to do it because of our age. Rose is asking if Sarah's is as annoying in person as she is on paper and on camera. Yeah, I think you see. Okay, so when I saw her, it was earlier on in this case. Like it was a couple of years ago now. I can't even think. Okay, so I was there before the parade of lawyers. So I didn't see the snippy Sarah. I saw a Sarah that thought she was going to get out of jail.
You saw the arrogant Sarah.
I saw a Sarah that was, oh, woe is me.
The
But
early on
also,
Sarah.
I'm saving the entire dorm kind of thing.
Yeah.
Now they're probably trying to explain to her.
Yeah, and you know what? That's weird because, like, yeah, somebody else said I'm not getting ads. So it's weird how they pick on people.
Yeah, I don't know. I finally said, okay, I'll pay for it because I stream it too much.
Kathleen says she's getting them every 20 minutes. Sam?
I don't know, Gary. I do not work for the YouTubes.
I'm so sorry, y'all. And I don't know what to put it up against because I have YouTube Premium too, so I don't know what to expect. It's on all the channels. Well, thank you for telling me that so I don't feel bad.
Yeah, it is. It's not just on your channel,
We're
Curie.
back on the record, case number 2020, CF 2603, State of Florida versus Sarah Boone. Let me get appearances for the state. Defense.
James Owens for Miss Boone.
Kevin Beck on behalf of Sarah Boone. All right, thank you very much. The state is advised to the juror members that they would like to follow up with 40, 49, and 51. Defense, do you have any juror members that you would like to follow up with other than 13? Okay, all right. Let's go ahead and bring in juror in seat 40 wearing badge 201, and we'll stand when that juror enters.
What did we miss, Pinky?
Y'all may be seated. Thank you. Ma'am, thank you so much, juror number 40, for coming back in. We've got a couple of follow-up questions to ask of you. State,
Okay.
you may proceed.
Okay, yes, fine.
State, you may proceed. Thank you.
Ma'am, I believe towards the end of Mr. Henderson's questioning, there was a question about potentially feeling uncomfortable or something to that effect.
Yes, so it was mostly because of the time. I have to be at pickup of my kids by 6. And if, like yesterday, I made it at 5:59. So if at any point we go over 5, then I would not be able to make it on time.
No follow-up.
Any follow-up? No. Thank you, ma'am.
Thanks.
Yeah, there is a way, Leah, to turn it off, but then that means I
State
sit here
any
for 8
position
hours
with
without
regard to
getting
juror in
paid.
seat 40 at this time.
I can't afford to do that.
Juror in seat 40 wearing badge 201 will be stricken for cause by way of stipulation. Let's bring in juror in seat 49 wearing badge 192.
See how the seat numbers don't match their badge numbers? That's to keep the jurors from saying, oh, I don't want a low number because I might get picked.
Oh, okay, gotcha. Yeah, she's
Thank
very
you.
aware of
Everybody
the
can be seated.
camera.
Juror number 49, good afternoon, sir. We just had some follow-up questions to ask of you, okay? State, you may proceed.
Sir, I believe at some point during questioning, there was a point in time where you indicated you'd like to speak without the other jurors present, is that correct?
I did, but to be honest, I can't recall the purpose.
Yeah, everything's on.
My apologies. I did say that, and I don't recall in what respect that was to, other than my comment late yesterday afternoon.
Did it have anything to do with a friend being murdered potentially?
My brother.
Your brother, okay. And did more details you want to share in private, or?
I just wanted to make sure that I wasn't omitting anything as we were discussing everything, or as you were asking the questions. It happened so long ago that I didn't really bring it up at the correct time. I just wanted to make sure that everybody knew.
Okay. Well, I understand that's a deeply painful experience that you went through and the rest of your family went through. That experience that you and your family and his loved ones and friends all went through with his loss, is that going to affect your ability to be fair and impartial in a murder trial? As opposed to, there's lots of other trials you could have done. You're going to be excused today if you don't make this one. They're not going to make you do another trial, but are you?
I'm not concerned with my ability for jury status. I do not believe that it will influence me because it was 30 odd years ago.
Thank you.
Any follow-up? Okay. Thank you, sir. I appreciate you. State any position as to the juror in seat 49.
No motion.
Defense?
No motion.
Okay, thank you. Let's remain standing. We'll bring in the juror in seat 51 wearing badge 325, excuse me. Y'all can be seated. Thank you. All right, juror number 51, good afternoon. We wanted to bring you in because we had some specific questions to ask of you. State, you may proceed.
Okay. Good afternoon, ma'am. Was there a certain point in time during questioning that you indicated that you wanted to speak to us without the company of the
There
other jurors?
was, and I think it had to do with, it was the personality, mental stuff. Our daughter has had a lot of physical and mental health problems, has been diagnosed with multiple medical or, mental illnesses. At one point, she was diagnosed with a borderline personality disorder, which I think they decided that wasn't it. So she's just had multiple diagnoses. I think that's the question that you had wanted clarified. And I think there may have been something else. If so, I can't remember.
That was my one note. And so my question is, potentially in this trial, there might be testimony about disorders that are recognized by the DSM-5 TR, which is what your daughter would be diagnosed from.
Mhm.
If there's testimony about that, either by civilians or by expert witnesses, is that going to present a problem for you to sit and fairly and impartially decide that testimony and evidence that you hear and see how it applies to this case and to this defendant and this decedent?
I don't think my experience with my daughter would influence me. I think mental disorders can be complicated though. So,
All right, and so just to phrase it a different way without going into the airplane ticket scenario that we use that in every talk. Do you have any doubt in your ability to be fair and impartial if you hear that sort of testimony and evidence?
no, I do not.
Oh, thank you.
Okay.
Defense, any follow-up? All right, thank you, ma'am. Appreciate you. You just leave the microphone right in the seat next to you. Thank you. State any motion with regard to juror in seat 51.
No, Your Honor.
Defense.
No, Your Honor.
All right, let's remain standing and we'll bring in the juror in seat 13 wearing badge 2130. Y'all may be seated. Thank you. Juror number 13, good afternoon, ma'am. We just had some additional follow-up questions to ask of you. Mr. Henderson, you may proceed, sir.
Good afternoon, ma'am.
Hi.
I'll speak the podium.
Yeah, podium's right here, Mr. Henderson, front center.
Afternoon, ma'am.
Hello.
I believe it was yesterday when it came up, but you said that you're going to be testifying in a case.
Yes,
Is
sir.
that correct?
Yes,
Could
sir.
you tell me what case that is?
It's a case, the state against my ex-husband for a domestic battery charge.
All right. Are you the alleged victim in that case?
Yes, sir.
All right. Due to the nature of this case and what you've heard and the questioning, do you think you can be fair and impartial?
I think so, yes.
Excuse me?
Yes.
Okay. Do you feel, what's your relationship with the state attorney's office now?
I don't have one.
Okay. Do you feel because they are representing you, well, not really you, they're representing the state, but you're the victim in the case. Does that give you any feeling that you have allegiance with them or anything like that?
No, I would hope that this would have no impact. I would assume so.
All right. Thank you, ma'am. I don't have any further questions.
Any follow-up? Thank you, ma'am. State any motions with regard to juror in seat 13.
No, Your Honor.
Defense. Okay, all right. Y'all can be seated. Thank you. Are there any additional cause challenges on behalf of the state? Yes, sir.
May I remain seated?
Yes, sir.
Seat 2.
Response?
Stipulate.
Juror in seat 2 wearing badge 651 will be stricken for cause by way of stipulation.
I was wrong. I can't believe they're airing this.
22.
Stipulate.
Juror in seat 22 wearing badge 13 will be stricken for cause by way of stipulation.
Seat 34.
I'm sorry?
34.
Stipulate.
Juror in seat 34 wearing badge 310 will be stricken for cause by way of stipulation.
Seat 44.
Stipulate.
Juror in seat 44 wearing badge 506 will be stricken for cause by way of stipulation.
Seat 48. Stipulate.
Juror in seat 48 wearing badge 4045 will be stricken for cause by way of stipulation.
No additionals.
Any additional cause challenges on behalf of the defense?
No, Your Honor.
Okay, all right. I believe that leaves us with 38 potential jurors remaining, if my math is correct. We will begin with selection at this point in time, starting with seat number 1. State, acceptable?
Judge, excuse me. Can we make some seating arrangements because I have to reseat because I'm gonna
Sure.
have
If you need to move, go ahead, sir.
All those seats over there, and they're acting all weird about the seating. What's going on with that?
I would guess that the attorneys need to be close together so they can agree or disagree. See, he's got the big chart in his hand. And they're starting with seat 1. Did you catch that?
Starting with seat number 1, state, acceptable?
Acceptable.
Defense? Seat number 2 was previously struck for cause by way of stipulation. 3, state.
Acceptable.
Defense? 4, defense? State?
First peremptory.
Any response, defense? Any response to the peremptory challenge is to juror in seat 4. So stricken. Seat 5.
Acceptable.
Defense? 6, defense?
Acceptable.
State?
Acceptable.
7, state?
Acceptable.
Defense? Any response, state?
No, sir.
That will be juror number 7 wearing badge 380 will be struck by virtue of the defense's first peremptory. 8, defense? State?
Second peremptory.
Any response?
None.
Juror in seat 8 wearing badge 361 will be struck by virtue of the state's second peremptory. 9, state?
Acceptable. I'm sorry, acceptable.
That's fine, appreciate you. Defense?
Acceptable.
10 and 11 were previously struck by way of stipulation for cause. 12, defense? Any response?
No, sir.
Juror in seat 12 wearing badge 837 has been struck by virtue of the defense's second peremptory. 13, state?
Acceptable.
Defense?
Acceptable.
I believe that we have a panel. Our panel currently is jurors in seats 1, 3, 5, 6, 9, and 13. Any backstrikes, state?
Seat 6.
Any response?
No response.
Juror in seat 6 will be struck by virtue of the state's third peremptory. Any additional backstrikes, state?
No, sir.
Any additional backstrikes, defense?
No, Your Honor.
Picking up on 14, defense? Any response?
No, sir. So that's alternate strike 1.
We don't have a panel, sir.
Oh, I thought we said
No, we had 6, currently of 1, 3, 5, 9, and 13.
acceptable. Sorry, no objection to their peremptory. I guess that's.
Juror number 14, wearing badge 537, will be struck by virtue of the defense's third peremptory challenge. 15, state?
Acceptable.
Defense? Believe that we have a panel. Our panel currently is 1, 3, 5, 9, 13, and 15. Any backstrikes, state?
No, sir.
Any backstrikes, defense? You may.
Somebody get the shots out. We're gonna celebrate. We have a jury. Well, we have a panel. We don't have all of them. We have most of them.
We're getting so close. So close.
I know, right? Wizard of Ego, finally.
Judge, at this time, the defense would like to use a peremptory on juror number 1.
Any response, state?
No, Your Honor.
Juror in seat 1, wearing badge 134, has been struck by virtue of the defense's 4th preemptory. Any other additional backstrikes?
No, Your Honor.
Any additional backstrikes, state?
No, sir.
All right, picking up with 16. Defense. State?
Acceptable.
I believe we have a panel. Panel is 3, 5, 9, 13, 15, and 16. Any backstrikes, state?
No, sir.
Any backstrikes, defense?
Can you read the panel?
I can, sir. 3, 5, 9, 13, 15, 16. Yes, sir. Of course.
See, it's what happens when you have so many people on your defense team. You don't work more quickly. Sorry about that, quicklier. I know that's not a word. They are slowing down the boat. I'm not happy about it.
It'll just be a few minutes. I just didn't realize, Cass said, why wouldn't this be streamed? I just didn't realize it was. I didn't think it would be.
Well, and originally we didn't think any of it was going to be streamed.
So, I mean, I'm learning new things every day. Is she facing life? Because if it's life, the question was how many challenges. If it's life, it's 10. If it's not life, it's 6.
Any response, state?
Another strike?
Juror number 3, wearing badge 899, been struck by virtue of the defense's 5th preemptory. Any other additional backstrikes? Defense?
No, Your Honor.
State? Yes, sir.
How many strikes do you have?
You've used 5. Any other additional backstrikes? State?
No, Your Honor.
Picking up on 17. State?
Acceptable.
Defense?
Acceptable.
I believe we have a panel again. Jurors 5. Yes, sir.
I need to go back on 17.
Any response?
No, sir.
Juror in seat 17, wearing badge 57, will be struck by virtue of the defense's 6th preemptory challenge. 18. Defense. State?
4th peremptory.
Any response, defense? Juror number 18, wearing badge 7, struck by virtue of the state's 4th preemptory challenge. 19. State?
Acceptable.
Defense? Any response?
No, sir.
Juror number 19, wearing badge 891, will be struck by virtue of the defense's 7th preemptory. 20 was previously struck for cause. 21.
Acceptable.
Believe that we have a panel. Panel is 5, 9, 13, 15, 16, 21. Any Any back strikes, state?
No, sir.
Any back strikes, defense? The first, of course. Okay, our jury panel will be jurors seats 5, 9, 13, 15, 16, and 21. We will now proceed with selecting any alternates. Yes, sir. I can't, sir. 5, 9, 13, 15, 16, 21. Thank you. Juror number 22 was previously struck for cause, 23 for an alternate position. State.
Acceptable.
Okay. Juror number 23 will be serving as our first alternate. Moving to juror in seat 24. Defense. Any response?
No, sir.
Juror number 24, wearing badge 235, will be stricken by virtue of the defense's 8th preemptory challenge. 25 was previously struck for cause. 26. Defense.
I have a question on the process. We're at the alternates now.
Correct, sir.
So at this point in time, it starts over because we have alternate count.
Yeah, the way I marked his down was as defense alternate 2 strike, just because it was our second alternate, but we should have as many alternate strikes as we seat alternates is what I believe our agreement is.
All right, that's fine by me. All right.
I don't think, I thought I only had one.
Well, but I just marked it as, because we're shooting for alternate number 2, so I'm just trying to keep track of that but
I understand. So I've used one alternate.
yes, sir.
That's correct.
All right, I'm ready.
25 was previously struck for cause. 26. Defense. Any response?
No, sir.
26, wearing badge 165, will be the defense's second alternate preemptory. '27, state.
Acceptable.
Defense? Juror number 27 will be our second alternate. 28. Defense.
Acceptable.
State.
Acceptable.
Juror number 28 will be our third alternate. 29.
Acceptable.
That's the state's call. It's odd.
I'll use an alternate strike.
Any response, defense?
No response.
Juror number 29 will be struck by virtue of the state's first alternate strike. 30 was previously struck for cause by way of stipulation. 31, state.
Acceptable.
Defense? Any response?
No, sir.
Juror number 31 will be struck by virtue of the defense's third alternative strike. 32, defense.
Acceptable.
Acceptable.
32 will serve as our fourth alternate. 33.
Who's it on?
State, it's odd.
Acceptable.
Defense?
Acceptable.
All right, 33 will serve as our sixth alternate.
Fifth.
I'm sorry, I'm one ahead. I already wrote it in for 5, I apologize. 34 was previously for cause. 35. State.
Acceptable.
Defense. Juror 35 will be our sixth alternate. 36, defense.
No response.
Juror in seat 36 will be struck by virtue of the defense's fourth alternate strike. 37,
Acceptable.
defense. Acceptable. 37 will serve as our seventh alternate. 38, defense. Acceptable. State.
Acceptable.
We have an alternate panel, a total of 14. Our alternates are 23, 27, 28, 32, 33, 35, 37, and 38. Any back strikes, state.
Seat 35, alternate strike number 2 for the state.
Any response?
I mean, I'm not 30, did I say 35?
You said 35, yes, sir.
33.
Okay. All right, juror in seat 33 will be the state's second alternate strike. Any additional back strikes, state?
Not at this time.
Any additional back strikes, defense? 39 and 40 were previously struck for cause by stipulation. 41, state.
Acceptable.
Any response?
No, sir.
All right, juror number 41, wearing badge 76, has been struck by virtue of the defense's fifth alternate challenge. 42 was previously struck for cause by way of stipulation. 43, state.
Acceptable.
Defense. I believe that we have our alternates. Our alternates at this time are 23, 27, 28, 32, 35, 37, 38, and 43. Any back strikes, state.
No back strikes to the original panel or the 8 alternates.
Defense. Any back strikes? Yes, sir.
Judge, we're satisfied as to both the original panel and alternate.
Okay. So our alternates in this case will be juror in seat 23, 27, 28, 32, 35, 37, 38, and 43.
State accepts the panel.
Defense, do you accept the panel? Yes, sir.
Hey, hey, look who it is. Lenny, just in time.
Okay, very good. Can the parties approach for a moment?
Y'all give Lenny some love. She just had her knee surgery. Mandy, you have good timing. Now you get to sit and rest and watch the trial. Yeah, I think that's the problem. A lot of people can't afford the YouTube memberships. I think they're only going to get more and more expensive as they go, but they do grandfather you in. Julie said, somebody please blow their nose. Who is it? That wasn't one of us you were talking to, was it? Because I sniffle a lot because of my allergies. I just did it right then. Sometimes I think I do it out of habit. Yes, zombies. Zombies. We have a jury. I want to go scream it from the rooftop. Guess that might be a little bit dramatic, but hey, why not? These are the people that are going to send you to jail for the rest of your life,
Ms. Boone,
Sarah.
Good afternoon, ma'am. I have a couple of things to go over with you before we bring in our panel. You were previously sworn this morning. You've been present throughout the entire jury selection process that began on Monday. You've been seated at counsel's table either here in 23 Alpha or 12 Alpha of the Orange County Courthouse, and you've been able to observe the jurors during that entire process. Were you able to hear the questions asked of the jurors and their responses?
Yes.
Did you confer with your counsel about who you wanted or did not want to be selected for your jury?
I did.
Do you believe you were given a meaningful opportunity to participate?
Yes.
Is there anyone that you wanted to keep that your lawyers struck?
No.
Are you satisfied with your attorney's performances so far in this trial?
Absolutely.
Do you agree with the panel that has been selected for your case?
Absolutely.
Is there anything you would like to bring to my attention at this time?
No, thank you very much.
When the court reads the 2.1 preliminary instruction defense, would you like me to read the defendant's right to remain silent section of same to our panel?
Yeah, sure.
All right, thank you very much.
YouTube should let us, they should all let us start gifting out YouTube premium memberships. That would be cool. I cannot
Bring our
keep.
panel in. State.
No, Your Honor.
Defense.
No, Your Honor.
Okay. Let's go ahead and bring back in our panel. We will stand. Madam Clerk will identify them by their badge number. I will ask them to remain seated where they are, and then we'll excuse the balance of the panel. I will give them an instruction. Court will then read the 2.1 instruction and 2.1a note-taking instruction and provide explanation for where we will be tomorrow morning. So let's go ahead and stand and bring in our panel.
Yes, Lenny's son. She's part of our family here on YouTube. She's special to us.
Thank you.
She does. You know what? You're right. Gosh, I can't. I can't even click on the chats. I don't want to click on it. It's going so fast. She does love the attention, Amy. It's so odd. She's the type of person that, regardless of if it's good attention or bad attention, she still eats it up. Oh, just as we said it, they cut it off. I'm sorry if something pissed her off already again. She could still claim that. Wendy, can't she claim ineffective counsel, Sam, up until the end of trial?
You can't claim it during trial to mine. I guess you could. I've never seen it done. That's usually something that is done on appeal.
Well, no,
And
what Wendy's saying, like now she's saying because they're going all out for her, that she can't claim it. But I think she's got all the way through the end of trial to make that decision, is what I'm saying.
If that's the case,
State, you
I'm not
recognize
aware
our
of it.
panel? Yes, sir. Defense, do you recognize our panel?
Yes, Your Honor.
I thank you. All can be seated. Members of our panel, we have been able to select a jury to serve in this case. Madam Clerk is going to call you out by your badge number, not the paddle number that you've been using all yesterday and today. Please stay in your seats when your badge number is called. Madam Clerk?
Juror number 295. Juror number, you want them to stand? So.
Please, if you could stand when your name is, your badge number is called, please. Thank you.
Juror number 9. Remain standing. Juror number 569. Juror number 515. Juror number 130. Juror number 249. 249. Juror number 448. Juror number 110. Juror number 306. Juror number 33. Juror number 519. Juror number 2130. Juror number 413. And juror number 102.
State, do you recognize the jury is selected?
Yes, Your Honor.
Defense, do you recognize the jury is elected? Bless you.
Yes, I do, Your Honor.
All right. Thank you. You all can be seated. Thank you very much. To the members of our panel that were not selected, I thank you so much for your time and your participation and your attention in this very important process. You have my thanks, the thanks of the lawyers, and the thanks of Ms. Boone. It is entirely up to you whether or not you would like to discuss this case. You may do so, or you may decline. That privilege is yours. Please proceed now back to the jury assembly room, where they will validate your parking, provide you your jury certificates, and give you further directions. Thank you, God bless you, and have a great rest of the week.
She's futuristically
go
going to be in
anywhere.
jail.
One more time. Okay, please.
So now he has to read. No, he doesn't read the jury instructions now. He waits, right?
Right. I'm just going to do a roll.
Y'all can be seated. Thank you.
Just going to do a roll call. You don't have to stand, just raise your hand. Juror number 295. Juror number 9. Juror number 569. Juror number 515. Juror number 130. Juror number 249. Juror number 448. Juror number 110. Juror number 306. Juror number 33. Juror number 519. Juror number 2130. Juror number 413. Juror number 102.
All right, thank you. All right, members of our jury, I have a couple of instructions to read to you. Oh, yes, Madam Clerk needs to swear you in. So if you could please stand up, raise your hands, please.
Do you swear or affirm to truly try the issues between the state of Florida and the defense and render a true verdict according to the law and evidence, so help you God?
Thank you all very much. You can be seated. Ladies and gentlemen of the jury, you've been selected and sworn as the jury to try the case of the state of Florida versus Sarah Boone. This is a criminal case. Ms. Boone is charged with murder. The definition of the crime charged will be explained to you later. The state's charging document, which is called an information, is not evidence, and it is not to be considered by you as proof of any guilt. It is the judge's responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusations beyond a reasonable doubt against Ms. Boone in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined, and they do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may also be produced as evidence. After the evidence has been presented, the court will give you instructions on the law. The attorneys will then have the opportunity to make closing arguments. Following the closing arguments by the attorneys, the court will conclude with the final instructions. After the final instructions are given, you will then retire to consider your verdict. You should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the argument of the lawyers, and the instructions on the law by the judge. Until that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no emailing, text messaging, tweeting, blogging, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of any of these rules at all, notify court personnel of the violation. During the course of the trial, the court may take recesses, and you will be permitted to separate and go about your personal affairs. During these recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about this case, tell him or her that you are on the jury trying the case and ask that person to stop. If he or she persists, leave that person at once and immediately report the matter to the court deputy, who will advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure your cell phone or electronic device is turned off. End of the case, while you are deliberating, you must not communicate with anyone outside the jury room. You cannot have in the jury room any cell phones, computers, or other electronic devices. If someone needs to contact you in an emergency, the court can receive messages and deliver them to you without delay. The contact phone number will be provided to you. The case must be tried by you only on the evidence presented during the trial, in your presence, and in the presence of the defendant, the attorneys, and the judge. Jurors must not conduct any investigation on their own. This includes reading newspapers, watching television, or using a computer, cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are in the courthouse, at home, or anywhere else. You must not visit places mentioned in the trial or use the internet to look at maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. So do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about this case face-to-face, you must not talk about this case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages related to this case or your jury service. Do not discuss this case or ask for advice by any means at all, including posting information on an internet website, chat room, or blog. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in the courtroom. If you investigate, research, or make inquiries on your own, the trial judge has no way to make sure that the information you obtain is proper for the case. The parties likewise have no opportunity to dispute or challenge the accuracy of what you find. This is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered against it, and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result, which would require the entire trial process to start over. A mistrial is a tremendous expense and inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of a defendant to prove her innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it was made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had he or she been permitted to answer. During the trial, it may be necessary to confer with the attorneys out of your hearing to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences occur, they will be conducted as so to consume as little of your time as necessary for a fair and orderly trial of the case. Members of our jury have one additional instruction to read to you regarding note-taking. If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to you individually. You will be provided with a notepad and pen for your use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from the courtroom. During recesses, the court deputy will take possession of your notes and will return them to you when we reconvene. After you have completed your deliberations, the court deputy will deliver your notes to me. They will be destroyed. No one will ever read your notes. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled to any greater weight than each juror's memory of the evidence. With that, members of the jury, we will pick up tomorrow morning in courtroom 12A of the Orange County Courthouse, and we will begin with opening statements at that time. I instruct you to follow the instructions that I've just read to you, including not reading any newspapers or watching the local news, having any conversations with anyone, or conducting any independent research or investigation as to the persons, places, things in charge in this case. With that, again, I thank you for your service, and we will see you in 12 Alpha tomorrow morning at 9 a.m.
Patty, did we hit 15,000 subs? Carrie?
May the
I
parties approach for 1 minute.
know. Thank you guys so much.
Look at you. That's amazing.
Whoop, 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 whoop. Thank y'all so much. I appreciate that. Thank you, Miss Patty, for your super chat. Dr. Barry's in the house.
She sure is. Hi, Dr. Barry. I was watching one of Dr. Barry's videos and I fell asleep last night. I have to go back and rewatch it.
Not that. Did you fall asleep intentionally? I'm just kidding.
No, well, she's got the most soothing voice.
Dr. Barry, it wasn't intentional.
It wasn't intentional. Know that.
I'd love for Dr. Barry to come up today if she has a chance. I think Cookie wanted to say something really quick though, so let's invite Cookie up first.
There was one question I didn't get to answer earlier, and it was really bugging me. And of course, I don't remember what it is. So yeah, they will start tomorrow. There will be opening arguments. They may need to do a little bit of a
Owens, once you've
motion
had that
hearing.
conversation with her, just let me know.
In Florida right now, it is 5:01, so they're going to be calling it a day.
And the 5 women, 1 man is straight out of the courtroom.
Oh, thank you guys. I wanted to do something while y'all were here really quick. Maybe y'all can help me do it. Let's do this. I don't know if I want y'all to see me do this though. Hang on. I don't want you to see my... We're going to go over and buy some memberships for... I can't buy that many though.
I'm muted. For the trial TV people.
Yes, to say thank you.
I've conferred with my client about the issue on cross-examination of her ex-husband, Brian Boone, about the family law case, the dissolution of marriage case. And through my cross, if I explore those issues, it may come out that she's been in jail pending her arrest back in February the 24th of 2020, so 4.5 years. She understands that may open the door. It may come out. She understands that I have to make a decision about whether to explore that area of cross-examination, but I believe she's going to say that she trusts my judgment. She is concerned about it coming out that she's had 8 prior attorneys. She does not want that coming out, but that's her biggest concern.
Okay, we'll address that in just a moment. Ma'am,
really?
I don't want to go into the specifics of any conversation that you've had with any of your attorneys on that issue. I just need to know whether or not you've had those conversations, okay? Is what your lawyer just represented accurate as the conversation that you've had as to that issue regarding cross-examining your former husband, Brian Boone?
Yes.
Okay. Do you understand the risks that if he seeks to impeach or call into question the bias and credibility of your former husband, Mr. Boone, as to what has transpired in your dissolution of marriage case, it may open the door to the fact that you have been incarcerated since February of 2020?
Yes.
Are you in agreement with that strategy, understanding those risks?
I am.
Okay. Now, with regard to your concern, ma'am, over having 8 prior attorneys, I don't intend on allowing it. I'm sure that's not part of the state's case in chief.
No, I don't see how it would possibly become relevant, but if we somehow believed it did, we would certainly have a sidebar before anything about that.
If by some circumstance that somehow becomes relevant, I'm going to ask the state to approach before we even get near addressing that issue in front of our jury. Okay. Ma'am, do you have any other questions for me at this time?
I do not.
All right. State, anything further?
No, sir.
Defense, anything further?
Yes, sir.
All right, we will see you all tomorrow morning at 9 a.m. The court will conduct its regular docket at 8:30. Thank you. We're off the record.
Okay, did you guys understand exactly what they just said? The marriage dissolution evidence that he wants to bring, that the defense wants to bring in, could possibly open the door to how long she has been incarcerated, which could open the door to how many attorneys she's had. I think that would be a stretch to get to how many attorneys she's had, but I don't know as much. I don't know. It could cause questions, but they're willing to do it. So thank you, Route Irish. Thank you so much. Y'all are so sweet. So sweet.
So there we go. Owens thought it would be Monday. Here it is, 5:00 on a Thursday. So, oh, there's Cookie. I'll mute myself. Hi, Cookie.
Where's he go? Wait, at the stage. Oh, there you are. Hey, Cookie. You're muted, Cookie.
Hey, baby, what's up?
Not much, baby. What you doing?
We made it.
Thank goodness, right?
Man, I'm telling you what, my blood pressure been out the roof today.
5 women. I think that's a good sign.
Look here, let me read this to you.
Okay.
Dear Judge Cranick, please blow your horn. The cats are confused and Sarah's sipping corn. Mr. J's on lunch break and Owens is peeing. Sarah's been triggered and looks like she's fleeing. But not to worry much, Chelsea's on the scene and she'll make sure Sarah will be back in her seat. All of Boone's fans forgot to show up. She dipped into her GoFundMe, but there wasn't very much. The peppermints and Pop-Tarts, cookies and chips will for the time being have to wait. No juice boxes she'll sip. Rosie O'Donnell has called in as well. I thought Boone favored her, but she said no way in hell. Boone's mouth is twitching like a dragonfly on crack. She's pretending to be a lawyer. She's smart, know that. So Cranick, please help us. Don't let her out too soon. And if all else fails, we can always blame Boone.
Woo! Excellent.
All right,
Everybody.
the last one. This is the last one.
Oh, I'm sorry.
Hickory dickory dock. Owens is watching the clock. As the hands go round and they finally line up, the pretty girls go to lunch, but Boone gets chained up. The defense team is over it, ready to hit the pavement. They can't leave right away. Sarah's still chained up in the basement. So Carrie and Sam, Bama, Laura and Mel, Benny Blanco and Pope, Mandy Strong, Vanna, the Judys, Mark, Jenny, and Mark L. Leave the empty nester, Brat, Baba, Ginger, Root Iris, Sub, Rosa, and the bloke. Damn, I love all y'all. You help keep me awoke. I know I miss so many. I wouldn't do this usually, but believe me, it's not done on purpose or intentionally. Sarah, get ready. Your time is about up. And believe me when I say we're all so ready to see you shut the hell up. Your story is a lie, ridiculous, and no one cares. Nobody believes you unintentionally flew up the damn stairs. Like a nurse with the meds for someone that's sick. How sweet it's gonna be to hear your jail cell door click. But cheer up, Sarah. It's October and time for Halloween. You can win the costume contest by dressing up like Eileen. Warrose, that is, a really bad woman like you. I'm sure you'll have no problem doing this, as you always know what to do. So Judge Cranick's finally listening, and you're included in it all. Remember, Sarah, darling, pride cometh before the fall. Maybe take a second, if you're not too sleepy or bored, and at least for once acknowledge just what you did to George.
Yes.
For now, you're in the limelight, the show, your last hurrah. If you happen to hear people screaming, it's all of us yelling, see ya.
I love it.
You're very talented.
So that is.
You
You're
are a
very
poet.
talented.
You a poet and we didn't know it.
I guarantee you, baby.
Oh, thank you so much.
Sam, Sam, it's been
Hi.
a pleasure. It's been a pleasure listening to you up there with Miss Carrie.
Thank you. I appreciate that.
I am so anxious for this thing to start. I believe I just have to believe, like Ms. Mayo said yesterday, in the end, it's not in our hands, and I just have to trust that everything is gonna work like it's supposed to.
Exactly.
Yep.
Yeah, that's all
will.
you can do.
Cookie
You
was
never know
nervous.
what the jury's gonna do. So
Cookie was nervous yesterday, Sam. He thought that it was a bad thing that was going on. I don't think so. I think
no,
we're all right.
I think actually that it was. I know everybody wanted it to be much, much, much of us faster, but I actually think that it was a good thing that they were as detailed and took as much time as they did. I
Well,
I
I
feel
think
like
I had to. You had to remember as well. A lot of this is new to me, and so I'm learning by listening to you and Carrie and all these people in the chat and watching, and so I tend to get too caught up in just a moment, and you know yesterday after yesterday after your stream, I went over to I'm also a member over at Surviving the Survivor. I like
Yeah.
to I like to watch his channel, and then there's another one, the one I can't think of right off the bat. He's a guy and does a real good show. Anyway, he had a former detective on, and I asked a question. I said, what are the chances that the jurors in this case, since they're not kept overnight, really, really don't know or really don't go and research know what's going on? And he said in today's world, he said that he didn't know how else to say it, but a very slim to none chance that jurors nowadays are not informed about what's going on.
It's almost impossible to stay away from it. Have you guys ever tried to, like, let's say you hadn't watched a movie or a TV show that was coming out. For instance, I remember when Game of Thrones finale came on, and I didn't want to know what happened, right? And for some reason, I could not stay away from here. Everybody was talking about it. And I couldn't not hear about it. You know what I mean? And I was trying my best. Or like say a football game or something. You're going to rewatch it later because you didn't get to watch it live, so you don't want to know who won. And
Right.
and you can't even turn on the TV without finding stuff out. Or just pick up your phone to check the time, and it doesn't pop up something that tells you what's going on in the news.
But
So
I'm still amazed at even today watching court TV at the amount of coverage and the amount of people that absolutely hate this woman.
it's
I
crazy,
mean,
isn't it?
on court TV today, they roasted her, man. They roasted her whole defense team. They roasted the overt act deal and all that stuff. I mean, I have never seen one defendant just catch it from every which way possible. And and I get it, because this has just been a ridiculous show from start to where we are right now.
yeah,
But that's the way it works.
yeah. Oh,
I am excited. I want to thank you. I want to thank everybody in the chat. Thank y'all again for letting me be a part. Sam, it's good to see you again.
Thank you. You too.
And I'm looking forward to in the morning, baby.
Woo! Bye-bye, babe.
Bye-bye.
Bye.
Vinny Bellatano was coming on as he was leaving, and I thought he was playing an outro. I was like, Cookie got his own outro. You know how Court TV has that music that pops up?
I don't watch them. They annoy me. If I'm not watching a commentary, I'm watching long crime usually.
Oh, Cindy, thank you so much. That means a lot to us. That really does.
I'm glad you think we're engaging. Sometimes we're ridiculous and make
Well, yeah.
technical errors.
Most of the time, we're ridiculous. Sam
Or
keeps
make
it to where I'm
technical
not.
errors.
If it was me, we'd be cutting up all the time. But Sam keeps me insane.
Oh no, you're saying I'm not fun.
Cookie's a Mark Twain. No, I'm not saying you're not fun. I didn't say that. I just mean I'm a goofball, and then you kind of keep me from doing, going too far off the ledge there. Um, because you bring in a lot of you make me sound smart. Well, not me. You make my channel sound a little bit more educated than what it really is. So yeah, that's what I mean. Haha. Um,
Oh,
being
that's
in
funny.
jail for 4 years because you keep firing your attorneys, right? That's gonna come up. That's gonna
Well,
come up.
it's not so much. Okay, so we were just talking about how different things hit differently. So for me, it wasn't that she fired that many attorneys, it's that she's been in jail for 4.5 years. So then some people could think, wow, she really must be guilty if she's been in jail that long already. You know what I mean?
Yeah.
So I just think there's different ways to interpret it, and they may have meant that it's about firing the attorneys. Hippie chick subs means subscribers, people that subscribe to the channel.
Oh yeah. Is Dr. Barry still in here?
No, she dipped.
Did she dip? Okay. Yeah. So you guys, it has been a long 2 days. Tomorrow is gonna probably be another long day. We're gonna be here in the morning for a hearing. Don't ask me what time that is because I don't know.
9 o'clock.
Is it 9? Did he say 9
Well, he
a.m.?
said the jury needed to be there at 9, I think.
We'll probably start at no later than 8:30, maybe 8:30ish. I got to put up the link for you guys. So, I hope y'all can join us back here.
Patrick J. Says his wife served on a couple of multi-day criminal trials, and the juror takes obeying the rules very seriously. I would agree with that. I think they do. They really, really do.
I think when you get in there, because it's not a death penalty case, but you're looking at putting somebody away for 22 plus years.
They don't know how long. Jurors aren't told how long a sentence is.
They don't know yet.
Nope. They will never know. They're not allowed to know. Unless it's a death penalty case because they have to be death qualified. But otherwise they don't. They're not told because it would affect if they knew how long somebody was going to be in prison for, it would totally impact their
The decision.
thinking. Yeah,
Well,
so they
I
don't
was just
know.
thinking, well, I guess so you have to look at it. If they're gonna obviously they're gonna find out that someone lost their life. So it's gonna be important.
Well, yeah, of
that
course.
they do what's right for that person and that person's family. So
Right. I mean, they're going to hear that, obviously. I mean, they're going to hear all about the crime. I mean, they're going to stand up there and say what happened. So it's not like they won't know that this isn't serious, but they just can't know what sentence is at stake.
Okay. Hey, Steven. Steven H is in the house. Ladies, how are you, Steven? Where you been? Did you work today? Friday morning for first day of Sarah Boone trial. Yes. I know I don't have the link yet. I haven't set it up yet. I actually today went by so much faster than yesterday for some reason. I thought I was going to be able to do that, set up that stream while I was listening to them, but I was so involved in listening or reading y'all's chats that I never did it. Listen, y'all come back tomorrow night. Any closing, Sam, that you have before we get tonight?
No, I don't have any closing.
Did we touch on everything, do you think? Did we have
I
any
think
questions that
so.
we didn't answer?
I've been trying to keep an eye on chat, trying to keep an eye on questions, and I think juries don't give the sentences in Florida. No, so we do have a lot of international people in here. The jury only decides whether the person is guilty or innocent, or not guilty, of the elements of the crime charge. So what I wanted to do, and I need to do it, is I'm gonna give you guys the elements of the charge and then the potential jury instructions so you understand what the state has to do in order for the jury to find her guilty.
Mm-hmm. Thank you, Judy. That's funny. Justice for George is coming soon. Yes, 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 yes. All right. Well, we can talk about some of these notes I've made. We can talk about them in the morning. It'll be better to talk in the morning anyway, because we'll have to refresh everybody up.
Mm-hmm. Yeah, thank you to Laura and Bama.
Yes.
I didn't see Mel today. Did you see Mel
God bless
today?
y'all.
You didn't?
Mel's been in and out, I think, today. She might have had to go get chemo, but
Oh,
yeah, she's there. And then Casey comes in every now and then and says hi. So yeah, thank you so much to Bama and Laura who've been here the whole time. Once again, working them to their bones, you guys.
thank you guys so much. You keep all the negativity out of the chat. It's much appreciated.
I know. I was thinking about sending them a Kranick t-shirt, and then I thought, you know what? I think they need a little bit more than that. I gotta send them some, maybe like give them like a gift card. Let them go get what they want. I think that'd be better than to do them a t-shirt.
Yep.
Yeah, Steven, you got to go back on the replay. All right, you guys. Well, y'all have a blessed evening, and we'll see you early in the morning.
Bye, guys.
Bye.